Hey, everybody. How's everybody doing? Welcome, welcome, welcome. I was on mute, didn't know it. I was just up here talking and talking and talking, and y'all couldn't hear nothing. Dude, couldn't nobody hear nothing over here. So we just had sentencing over there in Florida, and now we are in Nevada, right? They actually start court on time. Is 9:12 in Nevada, and they have the jury filing in. This is interesting. We are on day 7. The state rest their case yesterday, guys. So we are going to see, what does the defense have. Is she gonna take the stand? I don't know if she's gonna take the stand or not. We shall see today what happens in regards to this. So I will put a poll over here to see, will Devyn take the stand or will she not, before we start our case today? Let me get that set up for us now. I am going to set this poll up even before we start court over here. Worst case scenario, we'll have a little bit of TiVo time, guys. It is not going to be a ton of TiVo time, as y'all can see, because we're starting court pretty much on time today. Hey, drunkie. You say you would love for her to take the stand. We gonna see. We gonna see. I'm gonna put a poll up here. Okay, so just so everybody knows, if you were watching the orphan trial, they are going to do sentencing now. Um, so if you want to watch the sentencing, it will be in the other room, but I'm gonna go ahead and start playing what we have today because I don't want to miss anything. And if she gets on this stand, I want us to catch it. I don't want us to be too far behind. So if you want to watch the sentencing, you can stay over there and watch the sentencing, or you can watch on your tablet, you can watch on your phone, and you can watch on your iPad, you can watch on your computer, your TV, many places, depending on where you're at. Okay, cool. Here we go. I'm taking everybody into their respectable courtrooms. On behalf of the state, the both parties stipulate to the presence of our jury.
Yes, Your Honor.
Yes, Your Honor.
All right. The state rested their case yesterday. Do you have any witnesses you intend to call?
Yes, Your Honor. We're going to call Sean O'Brien.
I do. Sure. Sean O'Brien, Sean Obrien.
Good morning, Miss. I'm sorry. Good morning, Mr. O'Brien. How are you doing?
Pretty good.
How are you employed?
So I'm employed with Roll-Off Digital Forensics.
Okay, and what's your position there?
I am a digital forensic examiner.
Okay, can you give us a description of that job? What are your duties? What do you look at? What do you do?
Sure. As a forensic examiner, I look at any type of digital devices, digital artifacts, just pretty much anything that you can connect to the internet or even standalone, not connect to the internet, but it's digital in nature.
And about how long have you worked in this field?
Over 20 years.
Okay, you want to tell us about that, previous job assignments? Give us a little bit about yourself.
Sure. So I started off, I got a little intro to it whenever I was active duty in the Army. Got out of the Army, got recalled after 9/11. From there, moved on to the Air Force Office of Special Investigations Laboratory in Lithicum, Maryland. That's where I began my forensic journey, starting at the ground up from the basic taking a device and capturing it, as you saw earlier. From there, I got lots of training. I'm a Department of Defense certified forensic examiner. I also hold certifications with Cellbrite and Magnet and various other certifications related to the field. I worked there for about 9.5 years. I started off, like I said, it's technically called the imaging and extraction section. From there, I moved on to becoming a full-fledged examiner. And in that role, I was part of a child exploitation division that combated child exploitation and just all the different digital devices associated with that. From there, I went to the counterintelligence, counterespionage section and worked there as the deputy section chief. So I had a team of people under me that I mentored and taught how to do more advanced digital forensics. From that point, I went on like a little teaching circuit around the world to teach more stuff on like sexual exploitation type material. And then after that, I spent a little bit more time there at, it was called DCFL at the time. And then I switched over to Navy NCIS. I was offered a position to go start up a digital forensic lab, or restart a digital forensic lab in Naples, Italy. I was the sole digital forensic expert for Europe and Africa and backup for the Middle East. I covered all those countries. As part of that duty, I also worked in hand and on location with essentially like the special forces of the military police for Italy, and worked in a lot of like terrorism cases and stuff like that with them. I also worked with NATO, establishing the baseline digital forensics standard operating procedures so that everybody in NATO would have a baseline, because you have a lot of different economics, like there's very wealthy countries in Europe and there's not so wealthy countries in Europe. So trying to teach them how to do forensics with the bare minimum, because a lot of the tools are extremely expensive, and just teaching them how to balance the cost versus that. I spent 8.5 years doing that. I had to return to America, and I started working for the Veterans Affairs in the Office of Inspectors General. I ran the e-discovery division. It's essentially, it's not forensics, but it is in a related field, and I managed a team of people that would pull emails and do examinations and help agents and other requesting officers or parties to do audits and things like that. From there, I left and came over to roll off digital forensics, and here I am today.
All right, so now you work for your forensic company. What are some of the programs or software that you use in your role at your current job?
So my primary tools are some of the ones that you've seen here. Cellbrite and Magnet are probably the top two that I use.
All right, and then what about any certifications on those programs? Any training on those programs
Right, so
specifically?
I'm certified with both Magnet and Cellbrite to be an examiner and like to extract the devices, to get the device and get the information off of it and then process it and review it.
And so when you're not just talking about cell phone like pictures and things like that, you can also look at locations and all those types of things as well that go into anything with the digital forensics, correct?
Correct. Cell phones are essentially databases, so it's looking at all the different databases, some that can be seen, some that can't be seen in particular readers, so you have to use different tools to get to it and look at the data inside of those databases.
So I'd like to turn your attention to this case. Myself and Mr. Draskovich called you to hop on to this case and help us to go through, I believe there's 6 terabytes of discovery on this case to go through?
There is a
Something like
plethora.
that. There's a lot. And we asked you to look at a few things. What were those?
So cell phones, the cell tower records, looked at the Barilla extraction of the infotainment center. So everything that has to do with the cell phones, the cell towers, and the vehicle.
Okay, so right now I'm gonna turn your attention to the cell phone examinations. You were tasked to look at certain things dealing with cell phones, correct?
Correct. I was primarily focused on 3 different cell phones. The cell phone of Devyn, Jonathan, and Desiree.
And did you have an opinion on the accuracy of the information that was given to you?
I mean, accuracy, it's the data that's on there. Are you asking more like, was there anything that stood out, or?
Well, was it the accuracy of the extractions? Is there anything that was missing or that you would have liked to see more?
So as previously stated, the cell phones are made up of databases, and I stated that the software doesn't always pull all the information. So the information that I was provided was a UFED reader report, which is after you do an extraction, you take that data, you put it into another piece of software, and then you can create a reader report, which is what I reviewed in this. That is only the data that is able to be interpreted by the software. So I found it problematic because over my review and looking at everything, it's only, of all of the apps that are on the phone, the average between the 3 devices was only 3% of the data was displayed and presented with the databases backing it up.
So would it be your opinion that this was incomplete as what was provided to you as a whole?
Yes.
And what's the basis for your opinion on it being incomplete?
Years of experience and knowing that one tool doesn't do it all, and that whenever you look at that and you see something as low as 3%, like, okay, well, what else is there? What am I missing? Personally, if I pull up Cellbrite, I'm looking through it, I don't work off of reader reports. It's a bad practice because, again, you don't have all the information. I typically use Cellbrite as an initial tool. It's very good. It's accurate. It's accepted all over the world. The data that it displays is great. The way that it displays it is great. But sometimes you're like, well, I want to know more about that. And if you're in a reader report, you can't go back to, say, a database that holds messages and be able to find out more information about those files and to look in the databases and see the different information. So not having that is problematic. And then I typically use other tools. So if there's a database I can't get into, I could run it against, throw it into Magnet Axiom and be able to pull that up and look at it in a different tool to try to verify information as well as see if there's any additional information that can be gleaned. If there's databases there that I can't get into, then I can pull it like DB browser or some other deconstructing tool that deconstructs the database so you can look at it in different manners.
And I believe it was yesterday, Detective Campbell came in for the state and testified about UFD, and I'd asked him some questions about UFDR. And could you kind of explain to the jury the difference between the terminology before we go any further?
Sure. So whenever you get a cell phone, I mean, if it's all right, I'd actually like to start prior to that, if that's
Of
possible.
course.
Okay, so whenever I've been to many crime scenes and was the person that collected the digital evidence and worked it all the way to trial, as you see today. The standard procedure is you get on site, what's this case? So first of all, you have to figure out what's your scope, what are you looking at, what do you have authority to look at, what type of evidence can you get? So first thing I do is I look after all the photos are taken, because that's the first thing that happens. The crime scene investigators come in, they take the pictures, and then we go in, we start doing a search. If I see anything that's digital in nature, I stop. If I don't have a camera on me or there's another person that's assigned to take pictures, that person would come up, or I would come up, take a picture in the state that it's in the location that it's at. And then from there, once that's been categorized and like logged down, then you would take that, secure it from being connected to any networks, so turning off data, putting it in airplane mode as a bare minimum. From there, you would then, if you're not processing it on scene, you would put it in a bag, seal it, evidence tape, do all that, take it back to the lab, take it out, and then begin your extraction. So that, we're going to use a phone for this example. The phone that was collected, I would connect that to what's it's called UFED, and there is a UFED for PC, which is software that's on a laptop, and you can connect the phone up to it, and it starts extracting the data from the phone and puts it on there. There's also like mobile UFED devices that you can be in the field and on the crime scene and plug it in. So there's multiple ways to get that data through Cellbrite, and what that does is it builds a UFD. And that UFD is more like a index and some supporting information that tells you, hey, in this big package of data, which a lot of times it's in a zip file, and it's the package that the UFD is going to refer to that actually has the databases and the information. So you load that into Physical Analyzer. So Cellbrite has a product called Physical Analyzer, and Insights is their newer version. And you can put the data in there, and that gives you access to the databases. And you can actually do some database, like go through the database and break it down inside of that software as well. You can use, it's called App Genie, so it'll go in and it'll look at the app and be like, well, what can we do with this app? Like, what more information can we gather? Because, again, it's a vendor software, so they're only doing what the people in my field are saying, hey, we need this to be adjusted. We're not getting enough information for this. Can you turn your attention to there and try to get more information? So once that's all gathered, you go in, you're starting to do your examination, starting to find all your bits and pieces, finding out what databases you need to explore more, what information is important. And then the requester, which is usually an agent, a police officer, or auditor, whatever the case may be, they'll want to see everything right away. Unfortunately, digital forensics is not a right away type field. It does take quite a bit of time. 6 terabytes is a a lot of time it takes to get through that. So they'll want something right away. You create a reader report, send it out to the requester. That way they have just a first look of like, oh yeah, that's my suspect. Oh yeah, this is a message they talked about. And you can start to get little bits and pieces. It keeps them happy while you're doing the more in-depth stuff. It also allows them to say, hey, I saw a message on this day, but I can't find anything else that's around there. So they reach back to me and say, hey, this date, I need to know more. So then I can hone it in and be able to say, on this date, at this time, looking at these different databases, I was able to determine this or to provide more information. And then from there, you write up a report, you put everything together, and then it goes back to the report goes back into evidence if it's an evidentiary report. Again, you're working off a copy of the data, so the phone's already been put away. You don't mess with that anymore. If the extraction, like you drop a hard drive or whatever and it stops working and you have to re-extract, you still have that. And one of the other things to touch on that, there's a verification. So I know earlier in the trial there was talk about a hash value being a fingerprint. Same thing, whenever it does the extraction, Cellbrite does a hash of the data and you're able to just click on verify hash value to make sure that you're looking at the same data that you were previously.
So, in reviewing this and basing your opinion, what are we looking at here?
So right here we're looking at this is the UFED reader report, and it has different data located there. So you'll see the file system, which is essentially the background of the phone, and it shows the different areas that databases are in. The one database that we'll look at in a little bit, or information that was supplied from that database, you can see I have typed out there the path that has the com.android.providers.telephony and the databases. If you look in the directory on the left-hand side, it does go in alphabetical order. So,
And Mr. O'Brien, if you
Sure.
want to use your mouse,
don't
click on it though, because of the
No
digital
clicking.
click intent, but
all right, no clicking.
yeah, you
So,
go ahead.
right here you see com.android Chrome, com.android vending, like wallpaper backup. So that only 3 com.androids were found, not the com.android providers. Like that whole directory structure isn't there to include the database.
So is this a complete picture of this phone?
It is not.
Okay. So did you also review the Armada infotainment system?
So I reviewed the portions of the Barilla extraction that were provided to me, which were the data locations where the vehicle traveled.
And so I'm thinking that we heard testimony about how Detective Campbell was told, or I'm sorry, it was Detective Good was able to go through and kind of ping along how I'm sorry, Detective Spangler, all these guys with these technology and phones, I apologize. Detective Spangler was able to go and follow the infotainment system of where the car went, when it started, when it stopped. You saw that, correct?
Correct.
And I believe it was brought up that Miss Michaels was at a car wash around a certain time. I believe it was between 8:14 and 8:24, and the state phrased it as a car wash, correct?
Yes.
And we asked you to look at the points at this supposed car wash, and that's what we're looking at here.
That is correct.
Okay, and we see that the kind of the top half of it, it's the gas station, it's a convenience store, it's not just a car wash. But what did you do here?
So the first thing I did was I looked here. This is the car wash. You can tell by the structure and the wet marks. And then if you do street view, you can go in and see that as well. So I noticed there's no pings along this backside or anywhere along the car wash area. I also looked at the date and times and the start-stop time of the vehicle, which also was indicative of not really enough time to get a car wash, not in the right location for a car wash. But it did show that there was activity under this canopy, which is where the gas pumps are, and is also where all the pins happen. The locations are all in the gas station area. Coming in from this side, going around into the area here, and then come out and leave that direction.
And just as a side, you shut off your car when you get gas, right?
Typically.
Usually when you're at a car wash, you leave it on, you're sitting there listening to music.
Or having to drive forward, yeah.
Correct.
Or neutral, let it go on its own.
So, turning your attention to another item, did you review video data at 6505 Taylor Creek?
I did.
And what is your opinion of what was recovered from that address?
So again, I believe it to be incomplete just based upon the type of evidence that it is and the devices that it comes from. There are, as you can see on the screen, 2 of them are labeled ring video, and the other one just has what appears to be a date timestamp and a .mov. The others are .mp4s. So the 2 videos on the right, the washed out one and then the one that's more in color, appear to be videos that were extracted off of either the Ring app or like you can go online to the website and pull it down, download it. You can share via email. There's lots of things that you can do with Ring videos. And the one on the left appears to be a few still shots that were then combined into this video that's there. So the snapshots being put together, I'm not sure how familiar you guys are with the Ring camera, but you can set it up so that it does snapshots. So you can I don't recall the minimum amount of time, but I believe it to be like minutes, maybe even seconds, and then from there you can go into like you can turn it off completely. So the fact that there are what appears to be snapshots would indicate that snapshots were being taken. And if only 1 or 2 snapshots were taken of that area, and I believe this is the one where you can see the house up on the vehicles on the top right. Yeah.
It's this one.
So in this area here is the area of interest. So if you're having a lot of snapshots in that area, you're going to be able to see things coming and going. So you would be able to refer to those snapshots. However, in this exhibit, I did not see multiple. Well, there were multiple, but not a plethora, not a whole bunch of snapshots to look through. It was just, hey, we collected these 2 or 3 snapshots because we see the vehicle there, and then done. But there's so much more that could have been collected on that and more information.
And you weren't provided any document from law enforcement that they were looking for snapshots of this camera?
I was not. I didn't receive any reports or anything on this.
Are you aware that any other videos that had been provided to you, anything else that you saw that was recorded except for what we saw here?
So there were, I looked at a bunch of different videos that were collected.
And let me, from
Sure.
this address.
From this address? No.
And that's because there could have been, but from what you saw, there wasn't anything done about the snapshots or anything. There was just that one.
Correct.
Now, I'm going to turn your attention to one of the phones we asked you to look at, and off of the information that was provided from the state, it was Devyn's phone. Did you review that?
I did.
And I want to get to was it a complete capture of Devyn's phone?
No, same as as previously shown.
There wasn't information about every single app, every single activity that was going on.
There was not.
But even though we had an incomplete picture, you were still able to access some background information, some stuff from the databases that can tell you kind of what was going on.
Correct. I was able to access the reader and what Cellbrite was able to pull out and look at those provided items.
So what are we looking at here?
So here we're looking at on 8/6/2023 at 10:36 at night, there is communications, an instant message that was outgoing from, we're looking at Devyn's phone. So the outgoing would be the from, and then to the phone number related to the device of Devyn. So from Devyn to Devyn, their devices. It says, see you when you get back. I'm going to sleep, girls. So it's part of a text message. And then there's an incoming call at 10:58, which appears to be from Devyn's device to Devyn's device. and it appears that the call was taken and was 44-second long phone call. The last item is at 2:12 in the morning on Devier's phone. There was part of the Android messaging here. There was a icon, so whenever you save a contact, you can add a picture to it, and just so whenever you look at it, it pops up, has the picture. So this is a picture like that.
And this is a little bit more information on that
Correct.
icon.
Same one, it just different slide. Same
Same timestamp.
timestamp,
date.
same messaging, same area.
And this is just a close-up of the photo of the contact.
It is.
So it shows that there may have been some activity going on at that phone around that time.
Correct.
Now, in your experience and investigation and the roles of your work, gaming systems and other devices, not just cell phones or computers, but anything with hard drives, anything that's able to be communicated over, that would be important, correct?
Correct.
You would be collecting those things as you go through and see what's at the scene.
Correct. Depending on what the crime is, depends on what you collect. In a murder case, you're going to collect pretty much everything you can. You can do some field assessments and be able to look and say, well, you know, this device is dead. It's one of the examples was a really old like Nokia bar phone from in the early days. And if you're dealing with a crime right now, there's no power to it. It's stuffed in a box in the back corner and like in a storage unit or something like that. You might not necessarily take it. I mean, you could, but it's more, all right, well, we know that's there if we ever have a need for it. But in general, if you're doing what's considered a major crime, which murder falls under, you're going to want to take as much digital evidence as you can until you start getting more information.
Because in the beginning of an investigation, you don't really know what's going on. You're trying to collect anything that may have evidentiary value to later be examined, or if something comes about the investigation, you have that preserved.
Correct. And even in this case, so there was an additional cell phone, I believe it was Devyn's cell phone, that was, okay, this is too old, the activity is too old, it's not really relevant to the specific focus point of this investigation. So again, collected as it should have been, reviewed, not relevant, set it to the side. So
here's a picture. It's one of the exhibits that has been admitted for the jury to look at. Just looking at this picture, do you see anything here that of evidentiary value that would bring you to preserve some of this stuff?
So I see two items in here that could potentially hold additional information. There is a Xbox on the
And I prepared it a little bit here just for you.
So it appears to be an Xbox here and then a Nintendo Switch here. And the significance of that is that both of those devices you can chat with people. You can communicate. There's multiple ways that you can do that. One of them you'll see in a little bit, like Discord is a really big gamers app. A lot of people that use Xboxes also use Discord as a communication method if the game that they're playing or whatever doesn't have it embedded, or if they just want to save speed or data just to make things more efficient.
But even in like a Nintendo Switch where you can switch out data cards to store things and add more games, or even Xboxes with hard drives to plug in for additional space, it can be just a normal hard drive. Those are things that you'd want to look at and see if they were there.
Absolutely, and they connect to the internet and you can browse the internet as well. So potential for communications that way on top of chat applications.
So going to other things that could have been looked at here, what are we looking at on this exhibit or this slide?
So this is showing that the Discord app was purchased through the Play Store on Devier's phone, and it looks like 4/27/2023 is whenever it was installed. So it just shows that an additional chat application was on his phone that is also found on gaming systems.
And Discord, I know you kind of briefly touched on it. I'll let you explain that because you're more well versed in that. Can we just go through again for the jury what that is?
One more time, please.
What Discord is?
So Discord, a chat application, you can have it on your phone. You can have, there's multiple places that you can hold that, and it allows you to communicate back and forth via voice or text.
And what are we looking at here?
So this is another artifact related. Nintendo Switch was also found there. So there's an application that's listed as Cellbrite flagged it as entertainment and chat application. So it's another indicator. Hey, it's a possibility that the Nintendo Switch has chat on it. The application also allows for chat.
And that would be something of significance if you're trying to determine people talking about potentially a murder or anything, that you would go and look through all these things and all these apps to see which ones could communicate to other people, at least be looked at and investigated or preserved for a later time.
If you had access to those databases, yes.
And what are we looking at here?
We are looking at one of the applications that is related to Discord. And it's at 8/7/2023, 2:31 a.m. So it was an artifact, a Discord. So you can see Discord up here. So it's at that date and time on Devier's phone, the Discord chat, the Discord program was accessed.
And that was at 2:31 a.m. on August 7th.
That's correct. So it says modified. Anytime the system does anything to the file, then it would modify it because it's making changes.
And briefly, you didn't look at any router logs, did you?
I did not.
You weren't provided with any router logs?
I was not.
Nothing from the Porcupine residents about a router?
No.
That would have been helpful if you would have had that at that address, correct?
Correct. So as previously testified, the router holds information of connected devices. That's really important, especially whenever you're looking at an investigation like this, because if you know what devices have been connected, then you know what devices you don't have, or you can verify the devices that you do have. So you could look at it and be like, well, 6 phones show up on here, but I only have 5. Where's the 6th?
And some of these artifacts that we've seen, this could all be indicative of activity on either the phone or gaming systems. There's something going on, but we just don't know because we don't have the full picture.
That is correct.
And now we're looking at slide 18 on our presentation for the jury. What are we looking at here? Oops.
Okay, so you'll see in the next slide, it's the same slide as previously shown with the missing database. This lays it out a little bit more. So the native message here, which is found in this MMS SMS database, which we've already shown is not located on the reader report, it has a message in it here that says headed there now. We don't have a to, a from, a date. We have no other information other than it was deleted, which let me clarify that also. So here you see like messages in white, and then you see it in red. The red indicates recovered deleted items. So if it's red or it has this little red X right here, it means that that item is deleted, but the software was able to pull that out of the database.
But does it show a time or date or to and from?
It does not. And again, I couldn't go back to the database to see if there was any more information in there or related stuff around that time, like around that message, or looking at deletion orders, or there's no way to tell more information in the presented state.
But we know it's deleted.
We do know it's deleted.
And this is the slide that we talked about earlier.
Correct.
And it's about the missing databases and the different types of files, the UFDs, UFDXs.
So UFDX, I think that's a new term for here. So if you have a UFD, it's the initial one, like I had stated about having a device, and you're looking at it's the UFD with the supporting data. If you take multiple devices, so in this case, if I was to take all 3 of the devices that I looked at, I throw them all into Physical Analyzer, I could create a UFDX, which is essentially multiple extractions put into one. So I can open that up, and by doing that, it loads all of the devices, and then I can run searches. Can you go back a slide?
Of course.
Sure. So up here, I can type in a search, and then if I click on this little down here, it will display each device that's loaded in and how many hits there are, and then you can select which device, you can select all, and then you can work your way through it and see where all that search term shows up across all of the devices.
And just because we've heard all these terms and they've been thrown out between yourself and Detective Campbell, what is the most complete extraction that you would like to have had on this?
I would have liked to have the UFD with the supporting files so that I would have access to all of the data and not just the maximum 3%.
And again, you weren't provided with that.
I was not.
Now, when we asked you to review, yesterday we heard from Detective Campbell about it was Detective Good at the cell site location. It was a couple days ago. They said that they only looked until 9 a.m. at that time.
That is correct.
And we asked you to look a little bit further, give or take on both sides. And did anything stand out to you?
There was a location that I was like, this looks interesting. Maybe want to take a look at it. Again, I don't have much more information other than the location at the time that was shown. And so I brought it to the attention
And just because I know it's hard for me to zoom in on this, how we have it set up, but if you could just put the mouse on the two little points that we have on there so the jury sees what we're trying to point out here.
Sure. So here is Jonathan's home. And then here is one in the southern part of the valley, more in a remote area. And that is on 8/7/2023 at 10:25 a.m.
And that's a close-up of what you brought to our attention, correct?
Correct. So it's here, and then you have a lot of these washes, and then over in this area you have lots of open area.
So it's pinging near all these open areas.
That's correct.
And that's, the date of that is the 8/7.
8/7.
In your review of this, and I know I've hit this a bunch, but this is not complete.
It is not.
There's more out there that could have been done.
Absolutely.
And some of the things that we've brought up, these are things that we would have liked to know more about, we just couldn't get into.
Correct.
That could have helped us.
Correct.
Court's indulgence. Ask the witness.
Good morning, Mr. O'Brien.
Good morning.
We just met outside in the hallway.
You did.
Thank you for your military service, sir.
Thank you.
I have a few questions for you, not too much. I just received these items that were shown this morning. You would agree with that?
Yes.
So I'm just gonna kind of go through a couple of the slides and try to make sense of, to clarify what we're actually seeing.
Okay.
So I'm gonna start with the residential neighborhood, the slides you just put up. Mike, can I bug you to get that PowerPoint back up?
And you can click on it too if you need to just use it on here.
Yeah, perfect.
And then you can click on the slides below and it goes up.
Perfect, thank you. So I'm showing the slide, that you'd agree that's a residential neighborhood, correct?
Yes.
And you looked at a whole lot of stuff in this case. Would that include text messages on Devyn's phone?
It would.
We got a bunch of text messages after 9 a.m. On August 7th of 2023 from Devyn's phone.
Correct.
And you'd agree with me, there's text where he's talking with his boss and talking about a job and going to that job?
Yes.
Okay. And you'd agree this is a residential neighborhood, a newer one, kind of out at the tip of the valley?
I would.
And the location data is that you're looking at that caused you to testify that he was in this residential neighborhood was from the CDRs, not from the device.
That is correct.
So CDRs, as a reminder, those give a general approximation. They're not like the breadcrumbs from the Burla or the Google.
It's not the GPS, guys.
Got it. So you're not saying in any way to this jury that his location put him in any of these desert areas, correct?
That is correct.
Okay. You indicated earlier that you reviewed not only the DFLs, which were the actual phone extractions, but you also reviewed the CDRs and the Burla, correct?
That is correct.
Did you also review the Google,
I did.
the geofence stuff?
Yes, I
Okay.
did.
You would agree that there's nothing in any of those sources of information that shows Devier's phone going toward or at the Paladura address between 10 p.m. on the 6th and 8 a.m. on the 7th?
That is correct.
Okay. You would agree that all of those things show the defendant's device, car, and everything at the Paladura address until 2:04 a.m.
That is correct.
So the Google data is separate, and that was a geofence,
Yes.
right? And there, you're familiar with the steps and Google's privacy and
I am
all
the
that.
obfuscated numbers and doing
Yeah.
the 2-3 steps.
Right. So just to narrow it down and like simplify it, a geofence is actually placed on around the home, the Paladura home, and says, the first step says, show us what devices are at that home, but they give general numbers.
Correct.
And if I oversimplify it, you can tell me.
It's good.
Okay.
It works.
And so, in this particular case, it only showed the defendant's device at that home.
Well, it showed multiple, but once you select which one you want that's of evidentiary value, and yes, that was
Yeah.
one of them.
And that would be Yoko's, Yoshida's, and Jonathan's were actually there too.
Yes.
Yeah, and nobody else's.
Not that I recall, no.
Yeah, so it's 4 devices at the Paladura home, not including Devier's.
Correct.
And Devier did have a Google device.
Yes. An Android that,
Yeah, Android is a Google
Yes,
device.
yes.
Okay. So we're in agreement, nothing at all that you went through suggests Devier was at the Paladura address between those time frames.
that is correct.
Okay. The Google data did show John's phone traveling from the Paladura address at around 2:04 a.m. in the same exact path as the defendant's car and phone.
Yes.
Real briefly on the car wash. That information was gleaned from the Burla.
Correct.
Burla is the one with the breadcrumbs.
Correct. It does the GPS locations, which is the most accurate.
Got it. And that shows the Nissan going to what appears to be the gas pumps, not through the car wash.
That is correct.
We're in agreement. Okay. And that would have been about, correct me if I'm wrong, I think 8:30 in the morning?
Yeah, I don't recall.
Well-
It's back a few slides.
Okay. It's after the body's discovered.
Yes.
We agree there. You would agree that people can hand wash their cars, correct?
Correct.
And there were several hours before homicide detectives made their way to the Porcupine Rim address.
Yes.
So, doesn't look like she went through the Funnies car wash?
Yes. Correct.
Fair, okay. Briefly on the Ring videos. Were you here, because I've seen you a couple times, were you here when the detectives talked about those videos?
I'm not sure if I was in the courtroom or if I
Okay.
was watching from another location.
I'm not gonna try to recite what they said about the videos, but simplifying it, they basically said, we got what the homeowner gave us.
Correct.
Okay. You're not suggesting to this jury in any way the cops lied about what they got?
No.
Okay. We're in agreement there.
Correct.
They got what they got from the homeowner, and there's 3 clips, one of which looks like it's like motion picture basically. It's like stills one after another.
Correct.
Which all video actually is,
Technically, yes.
right? And you would agree with me that homeowners or people who have Ring cameras, they can change the sensitivity settings on their device.
Yes.
If they don't want to keep getting annoyed with every time a car drives by, they can lessen the sensitivity just to kind of encapsulate their driveway.
You can set up boundaries. You can set up, there's lots of different
Yeah,
settings. that you
there's a
can
ton
change.
of different settings.
Correct.
You would agree that in the videos from that same camera at night and in the morning, it appears Devier's vehicle is in the same exact spot.
To the best of my recollection, that is
Okay.
correct.
And On top of that, there is video from the entrance, the only entrance and exit a vehicle could go at the Porcupine Rim address.
To my knowledge, that is correct.
And that is continuous record, that's not a motion camera.
I'm not aware of the settings.
Okay, there may have been testimony about that,
Sure.
fair enough. So I want to get to slide 10 and, well,
Do you want me to help you? You just go to the bottom of it
okay,
and slide it over.
thank you. Slide 10. So the 3 rows represent an instant message, row number 1, an instant message from Devier's device to the defendant, see you when you get back, I'm going to sleep, girls, correct?
Correct.
The second one is an incoming call at 10:58 p.m. from defendant's phone.
Correct.
And that one says 44 seconds.
That is correct.
The third one is an image that you brought up today on August 7th at 2:12 a.m.
That is correct.
And I believe the language you used was, I wrote it down somewhere. Did you say accessed? What, just tell us, what does this mean? Like, this,
So that particular picture, the PNG, was the device accessed that. I don't have more supporting information about anything else that was happening at that time, again, because I don't have that database, but something was done with that particular file at that particular time.
got it. So we understand though, when you use that terminology, are you saying the device accessed it or a person accessed it?
Unable to determine.
Okay. If a
I can say that like the device shows that there was some sort of activity on that.
yeah, and just so we're clear, a device can do things in the background, can access, can cache, can do all these different things, correct?
Yes.
If it's the opposite, if it's a person accessing it, you would then agree with me that at 2:12 a.m. a person is with that phone using it.
You stated that a person was to show that a person would have to be there.
Yeah, absolutely. I mean,
Yes.
it seems obvious, but like, there's 2 alternative theories. It's either the device access it somewhere in the background, or a person is actually handling their phone at 2:12 a.m.
That is correct.
Okay. Go to the gaming system. So you pointed out a couple of, a Nintendo Switch and an Xbox, correct?
That is correct.
And there were, to your knowledge, no gaming systems found in the other home, the John's home,
I am unaware.
okay. I guess the pictures of John's home will speak for themselves when it comes to that.
Correct.
You're not taking a position on that. Do you know if the defendant had Discord?
I do not know.
Did we get a full extract on defendant's phone?
We didn't get a full extract on any of the phones.
Okay. What is it that allows you to get a full versus a not full?
So the initial extraction that I talked about, the UFD, is the extraction. What we've been presented with was the UFDR, which is after that extraction is done, then you can either select all, or you can like handpick what you want and then create that reader report.
Okay.
But to clarify, when you're selecting all, it's all the data that piece of software at that time is able to interpret and put into a report.
Got it. And so are you suggesting to the jury that the detectives picked and chose what they took? Or are you suggesting that?
I'm not really suggesting anything other than the full set of data was not provided and I was unable to do a full examination based upon the lack of data.
Okay, and in prior cases, you have a bunch of experience. I have some experience with phones, not nearly as much as you, but there are many, many times in which you cannot get a full extract out of a phone.
Yes,
right? That's not abnormal.
correct.
And you're again not suggesting the detectives like only pick certain things out of the devices.
I have no knowledge what
Okay.
actions they took, but
Okay. So with the text here on slide 18,
okay.
you said this is an artifact with no other information at all.
No other information presented in this manner on the reader report.
Right. So you would agree that there are text messages, call history, all that from Devier's phone, because we've seen a bunch of them,
Correct.
right? There's also that same type of information from the defendant's phone.
Yes, all
Right.
the funds, correct.
Okay. The text history for Devier's phone goes back years, right?
It's quite far, yes.
And he has a bunch of contacts saved in his phone like we all do,
Correct.
right? I don't even know the number, but like dozens, hundreds, I don't know. Can you see it on that?
If you go back a slide, maybe? I'm not sure if it was captured on that or not. So before the bar shows up in the movie?
Let me help you. To get that animation.
Oh, gotcha.
I don't know how to pull it off though. There you go.
There we go, thank you.
No, I didn't capture the contacts on there.
Yeah, but
But-
it is captured somewhere in,
It is part of the reader, yes.
Yeah.
The reader file has that.
and so you agree with this headed there now message? That could be to any number of people, years back, 5 years ago, 4 years, whatever it is.
That is correct.
Okay. But you gotta bring it up, because, I mean, it's something. But you would agree with me, I'm showing you admitted exhibit 666, that, oops, that with,
It's not plugged because I've got the HDMI cord.
gotcha. Can I approach? Yes. Does this appear to be to you one of the, or the text string that the parties admitted between Devier and defendant?
That is correct, yes.
And this shows a relationship text,
8523?
8/5 at 1 a.m. already adjusted from UTC.
Yes.
This next one is from voicemail to Devier,
So voicemail being the owner of the phone.
and it says, "Where the WTF are you? You obviously ain't home, but you ain't cheating!" Exclamation points.
That is correct, I see that. And
August 5th.
2023 at 4:02 a.m.
Okay, and then the next text says, "From Devier to the defendant's voicemail, see you when you get back, I'm going to sleep, girls are in the living room," correct?
That is correct.
Okay, no other text saying, "I'm on my way," or, I'm sorry, headed there.
No.
The CDRs are completely separate from the device. That's the phone company keeping
That is
record.
correct.
And you would agree with me that there is absolutely no record of a text message after the one where he says, "I'm going to sleep," going to the defendant's home between whenever that was, 10:36:24 p.m. and 8 a.m.
Can you repeat the initial question?
The CDRs. So
Okay,
we're-
CDRs,
Yeah,
that is
we're
correct.
away from the phone.
Yep, that is correct.
In the CDRs maintained by an outside source, the company,
Yes.
there is no incoming text to Devyn from Devier, no outgoing text from Devier to Devyn after that one at 10:36.
Based on my review, no.
So this headed there now text doesn't have anything to do with our time frame, based on the CDRs.
Based on CDRs, I believe that is correct.
Just make sure I got through all of them. Yep, that's it. Thank you very much, sir.
Sure.
Just to touch base on the picture being accessed and the gaming data of, I think it was, what's that, a Discord? There was activity the morning of, or the early hours of August 7th.
That is correct.
And do you know if WR had his phone on him?
I have no, I wasn't there. I don't know.
Yeah, we don't know either. Now, the state brings up the Funny's car wash. Let me pull this back on this slide. Now, he brought up the state, and I'm not trying to misstate, I'm just kind of summarizing, is about pulling in a potential hand wash of a car or something like that. You remember that question?
Yes.
Now, the car turns off at 8:17 and turns back on at 8:21. Does that sound about right?
It does. Yes.
Nissan Armada is not a small car. It's not a Honda Civic. It's not a hatchback. It's a pretty big car. Correct? Just from your, I mean, you've seen them on the road.
Yeah.
It's a bigger SUV. It's not a small
Correct.
car.
That's correct.
So to hand wash a big SUV that they've made is super clean. That 4 minutes is pretty quick.
Correct.
To hand wash a car, not drive through a car wash, but to hand wash it at a gas station, unless there's, yeah, that's, doesn't seem to add up.
Correct.
When he asked you about the Ring cameras at Porcupine, Mr. Giordani asked you about the cameras in and out of the development. Remember that line of questioning?
I do.
But we don't know if any person was walking around, say, hopping a back wall on a side of the house. We don't have any of that, right?
I did not see any of that, no.
There's other ways to get into a neighborhood besides just a car coming through the main gate or the main entrance
Correct.
or leave a neighborhood.
That is correct.
Now, there was a call.
Just to clarify, you said car or person?
I'm sorry, there's other ways for a person to get out of a neighborhood besides a car.
That's
coming
what I
through the
thought
main
you were
gate.
saying.
Yeah.
Okay.
And thank you for clarifying.
Sure.
And we do see that there was a call at 10:58, right?
That is correct.
And that was Devyn to Devier.
Yes. Well, to the devices.
Correct. Now, we went into the UFD, UFDR, like I said, I always confuse these, so I'm glad you're here. We were not provided, you were not provided with the full downloads or extractions.
That is correct.
And from Detective Campbell, yesterday he testified that he got his extraction and gave it to Detective Ozawa. It's kind of what you remember, because you've looked at the reports, you're familiar with the case.
Yes.
Do you remember seeing, or do you remember being handed any kind of information from phones that there was a follow-up from Detective Ozawa to get more information on the phones?
I did not see any more.
You were just given the initial or UFDR of the phone.
I have no idea when those, I can look up the time that it was created, but I don't know what order, if there were other extractions done. I have no further information other than I received these reader reports.
So from what you received, it is just, I have this one download, and that seems to be the only thing that was done. From
Correct.
what you've been
From
given.
what I've seen, yes, that is correct.
Now the headed now text, it was deleted, wasn't it?
It was.
And we don't have a time.
We do not.
We don't know what that's in reference to.
No.
And going back to the Ring cameras at Porcupine, or from the address, there's so many. The Taylor Creek address,
Okay.
you don't, not suggesting that the cops didn't, not that they made their own, but there was no follow-up onto subpoena or get any more information on this. You didn't see any of that.
I have no knowledge of that now.
And I'll state it this way, you weren't provided any more than that. This is what we got and we gave it to you.
Correct.
Okay. And just going back to this picture of one of the last pings on Devier's phone, the state suggested that there was this. He had this work schedule, which been throughout the course of the trial. There's been testimony that he had to work, that morning, and he went. But were you able to confirm that by any text message you looked at through the phone? Nothing popped out to you.
No, nothing stood out to me.
It's kind of why this popped out to you by this area at this time.
That's correct.
No further questions.
Yeah, I have to, I apologize. So, there actually is text messages where Devier is talking to his boss and saying, I'm headed to a job out. You saw those, right?
Yes.
Okay, so those do exist.
Yes.
Okay, that's not just testimony, that's in the device.
It's in the device.
And it's
There's
consistent.
multiple occasions that they talk about work. Hey, I'm headed to this side, headed to that side. I'm going to run late.
That morning, August 7th.
I don't recall specifically. No.
Well, I can show you.
Okay.
Can we agree overall that you went through these devices like with a fine-tooth comb?
No. I did the best I could in the amount of time that I was provided
Okay.
with the data that I was provided.
Okay, fair enough. When you go through this, I mean, you're presenting everything that stands out to you as like, this is fishy, or this is something I would bring up, or whatever, right?
Correct.
There's nothing you left out that was something you were like really interested in and didn't present to the jury?
No.
Okay. So,
I don't agree with Carlos' message.
so I'm showing you already admitted Exhibit 4. And I want to kind of show you this just in context of the timeline you just provided to the jury. So we agree that there is an incoming call to Devier's phone at 10:58 from defendant's phone.
Correct.
10:58 p.m. on the 6th.
10:58 p.m. on the 6th, 44 seconds.
And this is already admitted earlier by us. Well, let me back out so you can verify. You would agree that this appears to be stuff from the defendant's phone, correct? The Z-Fold?
Based on the naming,
Yeah.
yes.
And then I'm gonna go into the call log timeline. And you can see that 10:58 p.m. outgoing call from the defendant's device to Devier, correct? Do you see that?
Yes.
And then as it goes on, there appears to be a bunch of missed calls from Michael's home.
That is correct. What's labeled as Michael's home?
Right, but it's a different device from Devier. It's a
Correct.
separate number, yeah.
Correct.
And some of those went to voicemail.
Yes, that is correct. I believe 3, maybe 4.
And you're aware we can recover those voicemails, and we in fact did.
Absolutely.
Opening the folder entitled Audio. Do these appear to be the 3 recovered voicemails?
Yes, it does.
And these are after that 10:58 p.m. call from the defendant to Devier, correct?
Correct. It appears to be about 11:13, 11:18, 11:21.
And if I click on this, is that going to play the audio?
I hope so. It doesn't have the supporting file.
Yeah, I did this before. before, and I think I have to open it in a different way.
Mom, you answered this for me a lot to me. I woke up in the middle of the night, there is a sleepy jet. Please, I can't really fall asleep now when we take a up. Please give me a call back.
Did you hear that?
I did.
You familiar with that?
I am.
That's, sounds to be a little girl's voice.
It does.
And she's saying, Mom, Devier's asleep. I woke up in the middle of the night.
Correct.
Victoria, can we somehow move that up? Because I have the we present on. I don't know why the audio is not playing.
Because you may, because my laptop's plugged in, so.
No, I unplugged it.
May I inquire if the jury heard that?
Yeah, did you guys hear that?
Okay.
Yes. And Mr. Giovanni, if you want to put the laptop next to the microphone, it may make it louder.
That would make sense, wouldn't it?
Yeah. You know,
Mom, I've been waiting for you to come home, and I haven't seen you anywhere. So, if you could, please give me a call. I'm very worried about you. I'm very scared. I don't know if you got in a car accident or any circumstance. And I'm getting very worried. Please call me, please. Everyone's asleep. I woke up in the middle of the night. I can't fall asleep. I've been trying to get everything prepped for school tomorrow. So, the rear's not down, today's not down. I can't fall asleep. He's been telling me what you got here to everything. You said you were going to get some medicine. And then you never got any. So please give me a call back. I'm very worried.
That was voicemail number 2. Sir?
Yes, that is correct.
And you heard the little girl's voice say, everyone's asleep. I woke up in the middle of the night.
Yes, that did.
Devier's knocked out.
I don't think she said that, but
Okay, well, I'll play it again.
Mom, I've been waiting for you to come home, and I haven't seen you anywhere. So, if you could, please give me a call. I'm very worried about you. I'm very scared. I don't know if you got in a car accident or any circumstance. And I'm getting very worried. Please call me, please. Everyone's asleep. I woke up in the middle of the night. I can't fall asleep. I've been trying to get everything prepped for school tomorrow. So, the rear's not down, today's not down. I can't fall asleep. He's been telling me what you got here to everything. You said you were
Did
going
you hear it that time?
I did. Thank you.
Sure.
I've been waiting for you to come home. You never came home. I usually don't come home like this unless you hear them, but I'm getting very worried. Please call me. I'm very worried. You know how you're worried about me sometimes? I'm kind of worried about you scared and everything. I'm really getting worried. I'm like, so, like, are you in a car accident or something? That's not worried. So please give me a call back. I see a car in the neighborhood and it stopped in front of our house. I'm not sure if it's you. If it is, could you call me back?
And that was voicemail number 3.
That is correct.
And then if we back out of that, we go to the report, that would have been, for the record, 11:13 p.m., 11:18 p.m., and 11:21 p.m. in that order, right?
That is correct.
I'll pass the witness.
Oh, it's your vote.
Those messages were around 11 p.m. is what you recall.
That's correct.
There's activity on Devyn's phone around 2 a.m.
That's
Correct. On 8/7.
That's correct.
And on one of the voicemails, it talks about a car out front. Is that what you heard?
Yes.
Now, going back to the wash, the state brought up about his work schedule. Do you remember reviewing any messages between him and his boss regarding that morning?
I really wasn't focused on anything that late. It was just over my review of like going through, like, oh, that's kind of weird. I didn't really do a lot of investigation around that because there was a whole lot of stuff, other places that I was focused on.
Anything about him running late?
Not that I recall.
And we saw those artifacts on the phone around 2 a.m. with the Discord and the photo.
Correct.
And we can't.
The photo, yes. I'd have to see the Discord get one again to verify that time.
Pull it up. Looks like Discord was 2:31. Is that? Am I? Sorry,
I have
it's
no
not plugged
reason
in.
to dispute
I'm
that.
sorry. I don't know what just happened now. There it is.
2:31 a.m. Discord. That is correct. On 8/7.
Court's indulgence. There are no further questions.
Any follow-up statements? Ladies and gentlemen, the jury have any questions for this witness? Okay, Ms. Rice, working on a full sheet of paper with your name and your jury number. Counsel could approach. Does the Discord photo at 2:31 a.m. show someone accessed it from the porcupine home?
There is no indication of where that came from.
I'm sorry, no indication.
No indication of the location of where they.
When you look at the Burla data, did Burla show Devyn going straight into her neighborhood and to her house?
One more time, please, ma'am.
When you look at the Burla data, did the Burla show Devyn going straight into her neighborhood and to her house?
I believe I need further clarification, like what time frame, or if that could be clarified more?
I have to read it directly
Okay.
as they look. Was there any stops in her neighborhood?
None that stood out to me now.
When using chat applications such as Discord or others, if the phone is set to show notifications, will this create activity records even if the phone is not being used?
Yes, it would. It houses it in a database, which again, I didn't have access to that database.
Okay. Mr. Horvath, any follow-up based on the jury question?
Of course, indulgence.
Okay.
So the only question at 2:04 when the Armada leaves Paladura, it goes to the pharmacy, correct? That's what you reviewed?
Yes, that is correct.
And then it goes straight home.
Yes,
That's it.
that is correct.
No other stops.
Not that I saw. Stood up. No.
No further questions.
State any further questions based on the jury question?
Just briefly, you'd agree with me that the Nissan Burla data is specific to the car, correct?
Yes, that is correct.
Nothing about that or the phones is gonna show whether the defendant got out of her car with a basket, with a head in it, walked over to the neighbor's house and dumped it in the trash, correct?
Potentially, Barilla could pull information about weight distribution and, like, you know how if you're in your car and it says, "Hey, there's something in the back seat, make sure to check it." Potentially, that could be there. I didn't see any. Only information I got was location data.
So human head weighs about 8 to 10 pounds, we agree?
Sure,
If a doctor testified to that, we can agree.
sure.
Are you saying that the Burla would show an 8-pound differential? Or,
I'm not really sure. I mean, it's dependent on the car, so I don't know what the setting is on the car, but it's possible.
okay. So you have nothing to suggest that the defendant's car stopped anywhere else?
That's correct.
We've already talked about.
CVS and then
Yeah.
Correct.
And she can, whatever she did after she got out of the car, you have no evidence of that?
that's correct.
Thank you. Pass it.
Any follow-up, Mr. Horvath?
Just real quick, in cars, seatbelts, some, in the newer cars, this car looks like it's a newer car. Sometimes when someone is less weight, it says buckle the seatbelt, or they shouldn't be there. You've seen those at mornings, right?
That's correct.
Do we know if this car had this?
I don't know. I was not
Didn't have
provided
a full-
information.
And then just like the car, if you don't have your cell phone on it, you can't track that person if it's that person's phone, if they're supposed to have it on them.
Say one more time, please.
You can't track a person by their phone if they don't have their phone on them.
That's correct.
Thank you. No further questions.
Any follow-up statement?
No, thank you.
Do the ladies and gentlemen of the jury have any further questions for this witness? Okay, seeing no response, we will excuse. Thank you very much for your testimony here today.
Thank you, ma'am.
All right, ladies and gentlemen, we are going to take one brief recess for the morning. During this recess, you must not discuss or communicate with anyone, including fellow jurors, in any way regarding this case or its merit, either by voice, phone, email, text, internet, or other means of communication or social media. You must not read, watch, listen to any news or media accounts or commentary about this case. You must not do any research, such as consulting dictionaries, using the internet, or using reference materials. You must not make any investigation, test, or theory of the case, research any aspect of the case, or in any other way investigate or learn about the case of your own. You must inform or express anything regarding this case so it's consummated to you. Ladies and gentlemen, 10:25 will be a recess to 10:40.
All rise for the jury.
Just gonna skip ahead a little bit. Pause it here, 2 minutes and 9 seconds. What is this little thing right here?
That's an audio recorder.
That's your backup there?
Correct.
Yeah, so we're gonna take your handcuffs off and then we're gonna move it from. Okay, so it's a little more. Okay? So just, maybe that's that word a little bit. Let's see, I know you want to get your name on board or something. Yeah. Just give it a minute, some person back and we'll talk, okay? Need water or anything? Put them all in. Do you know what's going on, or do you understand what's going on? But you understand severity and what's actually occurring. Just it is August 15, 2023. It is 6:04 p.m. We met once before. Obviously, you don't remember. You can't go on the school worker and prisoner. Earlier today, you were advised what your rights are. I'm just going to advise you again, just so you fully understand that. All right. You do have the right to remain silent. If you give up that right, anything you say can will be used against you in court of law. You have the right to speak to an attorney before answering any questions and have the attorney present while you answer any questions. If you cannot afford an attorney will be provided at no cost to you. If you decide to answer any questions now, you may stop at any time and ask to speak with an attorney before questioning continues. If you decide to stop answering questions once you have begun, all questioning will stop. You understand that? Okay. So, you've given a handful of different statements and a handful of different stories along the way, and that's just what we're trying to clear up some. Okay? You understand that? So, do you want to start from on the 6th? You were hanging out with John and doing some shopping? Yes? Yes. Okay. Describe that day to me. You know, the clip number.
Simple day.
Okay.
Shopping, got girls some supplies.
then at night, John was moving in with you?
John was moving the girls' stuff to my house. It wasn't until he had actually moved everything over so I realized he was moving some of his things over.
Okay.
I'm gonna pause there, 7 minutes, 18 seconds. And Your Honor, if I may inquire with the jury, if everyone can hear all the voices?
Can you guys hear the voice now?
Okay. Detective, you had just asked about John and the moving situation, and is it true that the subject said that she had just learned that he was actually moving in, essentially?
Correct.
And you can see 3 people in the room. You are on the right.
Yes,
On the left is Detective Richard Christopher.
correct.
In the center is whom?
Devyn Michaels.
And do you see that person in court today?
I did.
Can you please point to that person, describe an article of clothing she's wearing today?
Black and white shirt.
Would the record reflect identification, Judge?
The record is on the
Thank you. I will resume.
I had been telling me he was gonna move, but that had been months of told back and forth that he hadn't actually moved in yet. I didn't put any stock into it. So when he moved some of his things over, that's when I realized he was actually moving his things. Yes, I remember talking to John about it. Yes, I remember talking to other people about it. But until that moment, it really wasn't something that was going to take place.
Okay.
Because at one point, a few times, he said he wasn't going to move. And it had happened more than one time, so I just took it as it was.
Okay. So you said earlier that you're shopping. You invited him over to drop off a last load for the night?
Yes.
Okay.
He assisted in his truck.
Okay. And you rode with him?
We worked with him all.
Okay.
He wanted to take his truck because the trailer has his information on it and it says free advertising.
Oh, it was the trailer loaded as well, or just the truck?
And at that time, the trailer was loaded later on that evening by John and John alone.
Okay. And did that make his way over to your house?
Yes. And that's when I found out what he had actually loaded up. It was supposed to have been the girls' things up on the bed, dressed for some clothes, and it turned out to be a lot more than that.
Okay. How did you feel?
Jimmy buildings were right. There was more tools, and Jimmy didn't say anything. So it really wasn't too much to feel bad about. It just a bunch of extra crap I had to.
Were you shocked or surprised that he was actually moving?
Yeah.
Okay. Was it somewhat confrontational or anything like that? Because now he's moving stuff that you didn't expect?
No, because like I said, it's tools, DVDs, and she brought his guns over.
Okay.
That was for the most part.
Okay. So after you have those, what happens?
We went back to his house.
The both of you? Okay. About what time was that?
About 9.
About 9? Okay, and then now you're going back to his house? Are the girls with you or are they at home? Okay. And what happens then?
We went to the gas station, had a couple of drinks, some chips and stuff, I think. Went back, John cooked, ate, took a shower. I loaded up some more of the girls' small items,
In what?
the back of the car.
That Nissan SUV? Okay.
I was at 80, smoked, drank some more. Vehicle.
after you left. Okay?
Going home, showering, going to bed.
Okay. So, he wanted some sort of sexual encounter with you?
That wasn't going to happen to him. He was not dead.
Okay.
That's when the girl came down. I spoke with her. And I guess afterwards I left.
Okay. Have you recently had a sexual intimate relationship with him?
Recently,
Well, in the past like month, obviously you can go back in, you were speaking, have
he's
you?
asking for sexual favors, yes, but we have not had intercourse, no.
Okay. Well, because part of the reason we've been told otherwise by other people that he was telling other people that we do that. That's why we're trying to clarify some of this up.
No, we have not had intercourse.
Okay, and you got other things like cunnilingus, any type of foreplay or anything like that.
Most he's had was a hand job.
You two moving in together, was there a expectation that you were going to be in a relationship together? Or?
Certainly expected it, but he's hard at work and I'm not able to do anything. I was not trying to have sex with him.
Okay. So he's asking for sex, you say no.
As usual.
Okay. And then from there, what happens?
I gave him a back massage off his back.
I mean, it's obviously you're quite a bit smaller than he is. How do you pop his back?
He was laying on the ground and pushed again, 4 1, 37, physical soft.
Okay, so you're straddling his lower back area, something like that, or standing up, something?
Yes.
Okay, and you're just pushing his back, he's out. Okay, and where was that? In the bedroom or the?
Floor of his room, yes.
I'm sorry,
On the floor of his room.
before his room? Okay. And then from there, what happens?
He went to go slowly in. When he came back in, he was laying on his bed, and he had me rubbing his back. That's when I was rubbing his back. And that's when Hugo was coming down the stairs.
So you're rubbing his back, are you using anything? Like,
How was he positioned on the bed when you were running fast?
Laying down and
But how, like, is he up next to the headboard? Is he laying long ways? Is he laying opposite of the headboard?
he's laying more towards the bottom of the bed.
Okay, so let's do this. Let's have you draw the bed and show us, I stick figure, how he's laying on the bed.
So then,
where's the head of that?
Yeah. Okay, so I'm just gonna freeze, I'm just gonna say, that's the bed, and this is the headboard, okay? So obviously, for headboard purposes, these would be pillows, this is where somebody would lay their head. So you draw a line across. Now, I don't know words from your mouth, so I want you to correct me if I say something that's wrong. He's lying across the bed, is that right? Okay. Which side would be his head? This side, so closest to the edge of the bed, or your left, laying on it, the right side.
There's like a wall and like a makeshift closet on this side, right?
So I'm just gonna circle for it. Is that right? So he was laying this way. Where exactly were you while you were getting him the back rub?
on this side.
So you were on the bed,
Yes.
between the headboard and him.
Yes.
So I'm drawing the X for you. Does that sound about fair?
Yes.
Were you on top of him, kind of sitting on his butt, or?
Pausing at 16:01. Approach. Showing you states 12, sir, do you recognize that?
I do.
What does that appear to be?
The hand-drawn photo that was just depicted right there.
I move for admission of that.
Any objection to that?
No objection.
That'll be admitted.
So Detective, we just witnessed this, but I just want to clarify, as Detective Christopher was assisting, obviously Miss Michaels was in handcuffs up front. He was kind of helping her
Correct.
and asking for her instruction on where everything went, right?
Yes.
And this up here being the headboard where the pillows are,
Correct.
what does the X represent?
Where she was sitting?
And then this at the bottom represents where John was, correct?
Correct. With the circle being his head.
With the circle being his head. Now, there is a folder sitting on the table as you're interviewing her, correct?
Yes.
That folder was closed.
Yes.
That contained a couple of the photos of John dead, missing his head in the bed.
Correct.
Those were not shown to her prior to this drawing, correct?
No, they were not.
They're shown later, we'll see that. And that
Yes.
will be the first time she will have seen those.
Correct.
Sorry, guys. Yeah, I had to get on the phone, and the testimony had ended in the live. Yeah, the kids' school. I tell you, they have sent a thing out in regards to evacuation. Everything's safe. Everything's fine. I guess somebody must have rang the fire alarm, and they had sent a message to my phone, and I was like, okay, well, I need to call and check up and make sure the kids is okay. Sometimes they don't send the text messages back telling you that everything is to the good. And I don't like to play those games. Please tell me about mine and tell me about mine immediately. Who do I have to hold? But it looks like they back in court. So I am going to put us back into court. We have gained a little bit of TiVo time, with that 15-minute break. Share. Sorry, guys. So I guess in regards to, let me see where y'all at in regards to this poll. So 53% said tonight. Some people say Sunday. I don't know. Let's see what time we get out of court today. Hey, Frank. Yeah, let's see what time we get out of court today. Because, in Vegas, we may not get out of court until about 5. I'm thinking my time. So if we get out of court at 5, then that means that we will start after dark, maybe about 8 my time, which is going to be about 10 East Coast time, and which will be 9. So I don't know. Do we do it like a Sunday fun day and kind of do it like maybe about, because Sunday seemed like it was the next biggest day. Okay, Drunky, pick me up a slice too. If we do like a Sunday fun day and do it like early evening time, like 5 or 6, that way it's not so late. So I guess we'll see what the court date has for us. You said that sounds good. The Sunday fun day one. So maybe I'll put out another poll and y'all can kind of like tell me so we can narrow it down. Only because I'm thinking we may get out of here too late. Okay, let me go ahead and put us in. Yeah, because I kind of like Sundays too, right? Because nobody's really streaming on Sundays. So Sundays maybe that'll be our ticket. Can you schedule it whenever you're going live Sunday? Yeah, I mean, I would send out a notification the same way, and yeah, because Sundays don't nobody really be doing that much. Oh, what's been happening here? Oh, just Shamrock, I'm sorry to hear that. Wow. Oh no. I know, and Lynn said the same thing. Oh gosh. My heart goes out to everyone. I know it's really, 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 really hard. I can't deal with you, Pretty Brown, talking about you like Sundays, but you never there. I can't deal with you. I cannot deal with you. Well, I hope that us keeping your mind off of it. Hey, Macro, thanks for stopping in. I know you probably been here. Um, yeah, it's just be so much. Yeah, let's try. We'll try doing this on Sunday. We'll do it on Sunday. We'll do it on Sunday because that one Sunday that we streamed, we had it going on. So yeah, let's do it on Sunday because a lot of people not streaming. A lot of people ain't in court. They just getting ready for the week, and they can get ready for the week with us. All right, let me put us back into this testimony.
Please be seated. Your Honor, the jury's all present and accounted for.
We are back on the record at scene. 377-239, State Level, Devyn Michaels. May the record reflect that Ms. Michaels is present her attorney, Deputy District Attorney on behalf of the state, and both parties stipulated to the attorney.
Yes, Your Honor. Housekeeping matter, we have stipulated medical records.
Okay.
If I can make part of the record.
Okay, what are the exhibit numbers?
Okay. There's
C4 and D4? Okay, C4 and D4 will be admitted pursuant to stipulation. Defense, you may call your next witness.
Thank you. The defense calls Dr. Larry Sims.
Do you solemnly swear or affirm the testimony you're about to give in this action to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Can you please be seated? Please state and spell your name with the record, please.
My first name is Larry, spelled L-I-R-Y. My last name is Sims, spelled S-I-M-M-S.
Thank you. Dr. Sims, if you could tell us a bit about yourself, beginning with your education.
Well, I graduated from high school in 1970. I graduated from college in 1974. I went to medical school at Oklahoma State University and graduated from there in 1978. I did a rotating internship as a physician in Dallas from 78 to 79. And I was a general practitioner for 10 years, 3 years in rural America and 7 years in Detroit. I had about 55,000 patient contacts, delivered about 100 babies. Then I went back into training at Michigan State University in pathology for 4 years. Then I did a 1-year forensic fellowship at Cook County Medical Examiner's Office in Chicago. Stayed on there for some years, and then I came out here and was at the Clark County Coroner's Office for 19 and a half years. I maintain a licensed medical license in Nevada, and I'm board certified in anatomic pathology, clinical pathology, and forensic pathology.
Doctor, so you were a coroner here in Clark County?
Yes.
19 and a half years.
Yes.
Would often be called by the state of Nevada in prosecutions of murder cases.
Oh yeah, I probably testified over 500 times during that period of time.
You were contacted and were ultimately retained by the defense in this case, the state of Nevada versus Devyn Michaels, correct?
Correct, yeah, I was contacted by the Special Public Defender's Office, it's been over a year ago.
Okay, and just for the record's clean, I mean, I'm not part of the Special Defender's Office, nor is Mr. Horvath, but that was who was initially on this case.
That's who
Okay.
initially contacted me.
After being contacted, were you provided with certain materials, specifically an autopsy report and other things of evidentiary concern, photos and the like?
Yes.
To your knowledge, was it the entire file?
Well, what I was provided, which is all the forensic important stuff, yes.
Have you had an opportunity to review the autopsy report prepared by Dr. Stephanie Yagi?
Yes.
And that autopsy report is dated August 8th of 2023.
Correct.
Did you review the pathologic findings in the autopsy report?
Yes.
And what are they?
Well, okay, have you got a copy of the autopsy report? I can go.
Absolutely. May I approach with the copy? State any objection?
Not at all.
So the main two findings is she classified the death as homicidal violence, and then she noted that he had a fatty liver.
And those were the two findings?
Correct.
Now, are there certain standards of practice that are employed by pathologists, specifically coroners?
Yes.
And what are those, and if you could please describe those to the jury?
Well, there's a number of practice standards, but there's a specific published practice standard in relation to using homicidal violence without any specific cause. It was published in 2010, and it has 5 separate criteria that all 5 have to be present before you use a non-specific cause of death, such as homicide by unspecified means or homicidal violence.
And doctor, what are those 5 criteria, and if we could just have you break them down, please?
Well, one of the important ones is that there can't be any other cause of death present. In other words, there can't be any natural disease present. There can't be any toxicologic explanation of death. There can't be any environmental explanation of death, such as drowning or cold. And there has to be an indication that the body was altered in some way. And there's one other criteria. I can look at the paper. I can't remember what it is.
Okay, if I may approach the witness.
And then a specific cause of death can't be brought out of the whole entire data set, which means all the findings that are available.
So from the get-go, we have this pathological examination done, and we have these pathological findings. The first being homicidal violence. And you had discussed these 5 criteria. Let's focus on 2 of them, specifically no atomic cause of death. How is that a concern, and how did this examination and this opinion not follow the standard practice?
Well, there are, in this particular case, that he actually has 2 natural diseases that could cause his death. His heart was enlarged, and he had a fatty liver.
And those are obviously borne out through Dr. Yagi's analysis and review of the body, correct?
Correct.
There's another criteria I'd like to draw your attention to, and that's no toxicologic cause of death. If you could please explain that and the significance in this exam.
Well, there has to be drugs can be present, but they have to be at low enough levels not to cause the death. is kind of the main thing to take away from that. Or there can be drugs present that are not known to cause death, like a medicinal type of drug.
So in this case and on this examination, there was a toxicology report, correct?
Correct.
And what were the findings of this toxicology report?
Well, the main findings, he had a low level of alcohol below the legal limit for driving. His marijuana level was substantially above the legal limit for driving. And he had quite a bit of alcohol in his stomach, but not really very much in his blood, which indicates just that he had drank a significant amount of alcohol just prior to his death before he died.
Let's break that down just a little bit, and let's start with the alcohol, where you just left off, Doctor. Are there different places where these draws are taken in order to arrive at the alcohol content of the body?
Correct. It's very important to, without going into a lot of explanations, to take the blood from a certain region, because that region is more characteristic of the level of whatever drug prior to death. If you take it some other regions, it could actually be higher or lower.
So in this case, was there both a blood draw from perhaps a leg or an ankle and from the stomach?
Yes, they did both of those.
If you could please explain those processes and the findings to the jury.
Well, the blood was taken appropriately, and so I have good confidence in the alcohol level of the blood and the. Have you got a toxicology report, just so
Yes.
I make sure I don't say anything wrong?
I believe, oh, absolutely, Doctor, I believe it's attached
Part
to
of this?
the back of the report.
So the alcohol and marijuana was done on peripheral blood, which is the appropriate thing. They also took urine and gastric fluid, and they did take heart blood, and they did measure the GHB level in the heart blood rather than the peripheral blood, which is not a good thing to do. It should have been done on the peripheral blood. Those are the main things.
And focusing in on the alcohol content, you had testified that in the blood it was not particularly high, correct?
Correct.
But then you made reference to the alcohol in the stomach. If you could please explain the significance of that. Did that denote recent drinking, heavy drinking? What would that indicate?
Yes, he had, it was about 30 times higher in the stomach fluid than in the blood. So he had drank, a couple of, some significant alcohol that had not been absorbed yet into his blood.
Now, if the THC content, it was significantly above the legal limit, correct?
Correct, yeah, the legal limit is 2 and his was 26.
So over 10 times the legal limit.
Correct.
THC. So if an individual were to have ingested alcohol, as we have evidence of, and smoked marijuana, could you opine, was that person intoxicated?
Oh, definitely, yes.
If we had heard testimony that this person had gone to sleep or shouldn't be driving, a family member was concerned about him driving, would that be consistent with the findings of this pathological report?
Yes.
In reference to the GHB and the drawing from the heart, you had said that was of concern. If you could please explain why.
Well, because heart blood is notorious for being inaccurate as far as a true level of the antemortem prior to death level. I'm not saying it's completely inaccurate, but it would be better to do that on the peripheral blood, which is what the other toxicology was done on, than the heart blood. But even given that, the DHB level wasn't into any significant toxic range.
Turning your attention back to the findings concerning cause of death, manner of death, and specifically the standards of practice, these 5 criteria. Is it fair to say that homicidal violence is an incorrect designation?
Yes.
What should it have been?
The practice standards are clear about this. If those 5 criteria aren't met, then you classify the death as undetermined.
As now we've covered cause of death, manner of death, it states homicide. Is that incorrect?
Correct. Yes, it's not correct, no.
What should it have been?
It should also be undetermined.
So based upon the science, the examination of the body, fair to say that this was an inaccurate pathological conclusion, homicidal violence.
Yes.
Finally, I'd like to address, there's an issue concerning obviously a missing head. Fair to say that that complicates matters.
Definitely.
And how so?
Well, you know, if you have incomplete remains, it's very risky to make conclusions about something that you haven't examined. You don't really know. Worst case scenario is the head turns up and there's no cause of death with that either. So in this particular situation, that would preclude you from scientifically, objectively assigning a cause or manner of death.
Now, obviously, one of the criteria concerns death under suspicious circumstances.
Correct.
And I don't know if you have had an opportunity to review the file because we haven't discussed it all that much, but obviously we have some fairly suspicious circumstances surrounding this death, correct? And is it fair to say that Dr. Yagi perhaps relied upon that outside the practice standards, but relied upon that in finding a cause of death and a manner of death?
Probably so.
Okay. I mean, we're humans, we make mistakes, fair to say.
Oh, definitely, sure.
In a strictly scientific sense, okay, doctor, and based upon the data, the empirical data, is it possible that this gentleman died of natural causes?
It's definitely possible. That's why you would classify it as undetermined. Before you come to a conclusion, especially one of homicide, which is going to have significant effects, you want to base it on provability. You want to be able to prove it. And in this particular situation, he actually had, in the body that was examined, he actually had causes of death that could cause his death. And the fact that the head is gone precludes you from making a scientific determination.
And again, we've discussed somewhat in this jury's heard for a week and a half, perhaps suspicious circumstances, but from merely the science, he could have died.
Correct.
Natural death.
Correct. As a forensic pathologist, that's the role that we're talking about. That's the role I play. You have to base your conclusions on objective evidence, not just suspicion.
Finally, in reference to the decapitation, you obviously reviewed the photos, you reviewed the examination of the body. It was clear that this body was decapitated.
Correct.
Any opinion was it post-mortem? Does he indicate that this happened after death?
Definitely. It was examined by an anthropologist, or an anthropology team, I guess it was, and they concluded that it was a post-mortem decapitation, which I don't disagree with.
Based upon the circumstances, you reviewed the evidence, fair to say it probably happened close in time of death and decapitation.
That's an excellent question. It might be very, very difficult to say that. There's no doubt that the blood was still liquid, but that would be liquid for a number of hours. So it's more likely that it was, but as far as being able to objectively prove it, you'd have to do a substantial number of kind of uncommon tests to do that.
And in reviewing Dr. Yagi's report, in fact, she enlisted an anthropologist to do further analysis on C2 and C3, correct? The findings of that anthropologist was that the head was severed using 2 instruments, correct?
Correct.
A handheld knife and a mechanical powered saw.
Correct.
Do you take issue with those findings?
Well, the After reviewing all the pictures and looking at them, there was an area in the skin that had in my experience, the characteristics of a chainsaw. But it was only in an area of the skin, which that would be enough for me to be concerned that was part of what was used.
A chainsaw.
Correct.
So while we have the anthropological findings on the bone, did you view any follow-up evaluation or analysis on the skin that you're referring to?
No.
In reference to this idea concerning the cause, the undetermined cause of death, and we have a post-mortem decapitation, and the time of death, we agreed that it's fairly close in time. You'd made reference to the blood, and there's been several questions last week asked concerning witnesses and this idea of cast-off. Would you anticipate there having been cast-off given the evidence that you reviewed?
Oh, especially if there was a motorized weapon used, yeah, you would expect substantial cast-off also on the people or the person that did it.
So would you expect, based upon your evaluation of the evidence, for that person to be covered with blood?
Well, there would be a lot of blood splatter, yes.
Okay. We had heard testimony concerning, bodies are dissected in the morgue. There's not a great deal of cast-off. We're obviously talking about different circumstances here, correct?
Yes, that would be different circumstances, yes.
Here, we're not talking about a refrigerated body.
Correct.
Here, we're not talking about a specialized instrument that may be used, let's say, in a coroner's office to dissect a body.
Yeah, we don't use chainsaws, but, so no, that's a whole different thing. So.
Okay. There had been questions asked concerning the arteries, carotid arteries, and you'll agree with me, the anatomy of the neck is fairly complex in reference to a decapitation.
Yes.
I mean, we have obviously the muscle system, we have the vascular system, we have the spinal cord with all the vertebrae, we've heard are complex and quite strong.
Correct.
We have the thick ligaments, cartilage. Can you give an opinion as to would it be difficult to effectuate a decapitation?
Oh, yes. Especially if you're just using a handheld knife, would be very, very difficult.
And in this case, we've made reference to a handheld knife and a mechanical powered saw. Again, it's an undertaking.
Correct.
We would expect to see cast-off and blood, correct?
Correct.
Would you expect to find cast-off and blood at the scene where this had occurred?
Wherever it occurred, yes. Unless somebody cleaned it up or something. But yeah, you would, during using a motorized type thing, you would expect a large amount of blood splatter.
So we're not talking about a morgue, we're talking about perhaps in a bedroom, correct?
Correct. Yeah, I've never even considered a morgue anything near a scene of a crime like that.
So that would be inappropriate to make comparisons to what happens in the morgue as opposed to what happens at perhaps the scene of a crime.
Well, I've never done that. I've never heard about that because it's a completely different environment, and so I don't even. There's not even an analogy there. No.
We could have the court's indulgence just one moment. Thank you very much for your testimony, doctor. I pass the witness.
How are you, Dr. Simpson?
I'm okay. How about yourself?
Good. Good to see you, sir. I'm not going to disagree with you too much. I just want to clarify a couple things. We're in agreement, sounds like, that it's difficult to determine cause of death when the head is missing, correct?
Yes.
We're in agreement that it's a postmortem decapitation.
Yes.
We're in agreement, you weren't at the scene, nobody here was at the scene, well, maybe except one person, right?
That is. Yeah, I definitely was not at the scene. No.
Yeah, so you don't know if someone covered it up while they're doing the sawing with the knife or the saw. We can agree there.
That's a good point, and I was not at the scene, nor did I. I've never visited the scene,
Yeah.
And so no, I don't know that.
Fair enough. And you mentioned cleanup goes without saying. You can't say whether the person may have gotten blood on them, took a shower, any of that.
That's correct.
Use chemicals to clean up or anything like that?
That's correct.
Okay. Are you familiar with the term hesitation marks?
Yes.
What does that mean?
So those are primarily in relation to sharp force injury, and they can occur in somebody trying to kill themselves or when they're going to kill somebody else. And it's a mark where you're considering making a cut, and you become afraid, or there's some reason that you don't, and so you leave just a superficial injury.
And you mentioned some of the cuts to the back of John's neck.
Correct.
You're not telling this jury that it was in fact a chainsaw used, correct?
No, I just talked about one area that was, that I picked out, seeing the photographs, that was concerning to me.
Sure. But you'd agree there are hesitation marks?
Definitely.
It looks like somebody who went to do it was like, oh my God, I can't believe I'm doing this kind of thing?
Definitely. There were multiple hesitation marks, yes.
And with regard to the tools, that was sent out to a forensic anthropologist, and there's tool mark experts, et cetera, right?
Correct, yeah, that is a specialized type of analysis, and I thought they did a pretty good job.
Okay, and that was gonna be my next question. Are you calling into question Dr. Burns and her associates' work?
No, I read it. They took very good photographs. They made the proper, in my opinion, the proper descriptive statements. So if that report would have came back to me, I would have adopted the report.
Sure. And it's a report, you didn't prepare a report, I've been told, in this case.
No, I didn't. I was never asked to prepare a memorandum or an email or anything about anything. I was just, the reason I was originally contacted with this from the Special Public Defenders, they were puzzled about the cause of death. They didn't quite understand it. So.
We are in agreement that the decapitation is not the cause of death.
That is correct.
You would agree with me, we've had cases together before back in the day. You would agree with me that a single blow to the head with a large blunt object can kill a man?
Yes, they can.
And you've probably seen lots of those cases.
Blunt force injury is a common mechanism of death, yes.
And there is a difference between the terms homicide and murder, correct?
Definitely.
Homicide is a medical legal definition, and you know it better than me, I think it's death at the hands of another?
Correct. It basically talks about a mechanism. Murder is a legal conclusion, because there can be justified homicides.
Sure.
Or unjust. Murder is an unjustified homicide.
Right, gotcha. My point is you're talking about whether or not it's a homicide. You're taking issue with Dr. Yagi's terminology.
Based on the published practice standards, it did not follow that. I wouldn't have came to this conclusion at all.
Okay, fair enough. And I'm not arguing with you about that. I'm just trying to say, you're not saying to this jury that John was not murdered.
I don't know.
Okay. Murder can be proven by other means, not just your narrow medical legal determination.
Oh, definitely it can. The jury can come to whatever conclusion based on all the data.
Yeah, phones, video, even confessions.
Correct?
Murder and homicide, two different things.
Correct.
Pass the witness. Thank you, sir.
Any follow-up, Mr. Justice?
Yes. Suffice it to say that based upon the evidence available, you could not say this person died of a blow to the head, could you?
No.
That would be reckless.
Yes. There would be no evidentiary basis for that, so I wouldn't say that.
Something I'd like to address on my redirect of you is we've heard from other witnesses involved in the investigation of this case that this was the first time that they'd investigated, been involved with a case involving a beheading.
Okay.
Have you had experience with beheadings?
Yes.
Multiple?
As far as just in the general term of dismemberment, it's probably around 24 out of my whole career since doing forensic cases starting in 1991. So.
Thank you. Finally, a follow-up question that I'd like to address, and if you don't have any specialized knowledge concerning this, we completely understand, but there's been some discussion of chloramine, the mixing of bleach and ammonia. It was referred to in the autopsy report concerning smoking body, things like that. First of all, can you give testimony concerning chloramine?
No, I don't. That's a criminalist. A criminalist gives testimony about that. I mean, I've definitely been in cases involved in that, and they've talked to me about it. I mean, I can tell you what they told me, but I have an independent. That's not something that I include in my reports or in my estimations, because there's somebody that are better experienced and better knowledgeable than I am.
So you have no opinion as to how long this chloramine may exist? Let's say you put bleach and ammonia together, it's on a body. No time frame, how long that'll be, nothing, can't give any testimony concerning that.
No, I mean, you can tell that it caused discolorations in the skin from a pathologist's point of view, but I don't have any opinion about that, no.
Thank you, doctor. I have no further questions.
Any follow-ups, sir?
Nope, thank you.
Ladies and gentlemen, the jury have any questions for this witness? If you write a question on a sheet of paper with your name and your jury number. Counsel Hirsch? Dr. Sims, if the handheld knife were described to you as a meat cleaver, would it be better to understand that the head could be removed easier than using a knife?
Yes.
Okay. I'm sorry, Mr. Blaskowitz, any follow-up based on the jury?
But in addition to this knife and again, the findings were of a handheld knife, correct?
Correct.
Would you expect a cut to be different from a handheld knife versus a meat cleaver?
No.
Similar?
Yes.
However, in addition to a blade, based upon the findings, we're to understand that a mechanically powered saw was used.
That is correct. Yeah, whether it was a reciprocating saw or a rotary saw or whatever, they didn't go any further than that, but it was some kind of powered instrument.
Thank you. I have no further questions.
State any follow-up based on the jury question?
Nope, thank you.
Do ladies and gentlemen, jury have any further questions for the witness? Yes, if you can write a question on a sheet of paper with your name and your jury number. Okay, Dr. Sims, is it a regular practice for the medical examiner to call in a criminologist and chemicals are used?
It would be, if that is an issue, a recognized issue in the case, it's not some just minor finding, and that is correct, yes.
If alcohol is in the stomach and not absorbed in the bloodstream, does it affect the person's ability to function?
No.
When you talk about natural causes, would you expect to see physical signs of a heart attack or cardiac enzymes?
That's a very excellent question. Because there was no microscopic analysis of the heart, there was no microscopic analysis of the liver to actually fully assess the amount of pathology and whether there was something acute or longer, which should have been done in this particular case.
In terms of the liver, if fatty liver disease progresses, would you expect to see signs of jaundice or bad enzyme levels?
That's also an excellent question. So in his particular case, it had not progressed to cirrhosis as yet, but without getting into a lot of pathology, the storage of fat in the liver disrupts the liver's ability to function, and the function is the main metabolic organ that takes care of all toxins in your body, whether they're drugs or anything else. And so when you lose that, then you allow a higher level of those toxins to be in your bloodstream, which can cause death. And that's how it operates.
Mr. Pastor, do you follow up based on the jury?
Yes, just briefly, in reference to the question, the alcohol, based upon your test in the stomach, based upon your evaluation of this person was clearly intoxicated.
Well, the marijuana was really high, and it also worked with whatever little alcohol was present. Both of them are central nervous system depressants. So there's what's called a synergistic effect.
So we would expect then alcohol in conjunction with the THC, this person was pretty loaded.
It was definitely under the influence of marijuana for sure, yes.
Finally, in reference to this cast-off post-mortem, you'd expect under the circumstances of this case for there have been significant cast-off.
If there was a motorized, there can be cast-off even with a handheld knife, depending on how the person is using, but it's going to be very small compared to the cast-off from any kind of motorized cutting instrument.
Thank you. I have no further questions.
Any follow-up statement?
No, thank you.
Do the ladies and gentlemen of the jury have any further questions for Ms. Witness? Okay, seeing no response, sir, you are excused. Thank you very much for your testimony here today.
Thank you.
Does the defense have any further witnesses they wish to call?
We have no further witnesses that we are going to call. We are going to arrest. However, we do have a housekeeping matter. Did we get those other exhibits? She might be in right now. Okay.
We'll stipulate to that.
We'll stipulate the defense arrests.
Okay, what are the exhibit numbers? E4 through N4 are going to be admitted pursuant to stipulation. The defense will arrest at this time. Do you have any other witnesses?
No, thank you, Your Honor.
All right, ladies and gentlemen of the jury, we have now reached the conclusion of evidence in this case. We have now reached the portion of the case where I'm going to read you the instructions on the law that applies to this case. You guys are the fact finders, so it's very important that you understand what I'm reading to you. So we're going to give you your own packet so you can follow along as I read them to you, just in case I read too fast and you guys, we don't want you to miss anything. Instructions to the jury. Instruction number 1, members of the jury. It is now my duty as judge to instruct you on the law that applies to this case. It is your duty as jurors to follow these instructions and to apply the rules of law to the facts as you find them from the evidence. You must not be concerned with the wisdom of any rule of law stated in these instructions. Regardless of any opinion you may have as to what the law ought to be, it would be a violation of your oath to base a verdict upon any other view of the law than that given in the instructions of this court. Instruction number 2. If in these instructions any rules, direction, or ideas repeated or stated in different ways, no emphasis thereon is intended by me, and none may be inferred by you. For that reason, you are not to single out any certain sentence or any individual point of instruction and ignore the others, but you are to consider all the instructions as a whole and regard each in the light of all the others. The order in which the instructions were given has no significance as to their relative importance. Instruction number 3, a third amended indictment is but a formal method of accusing a person of a crime and is not of itself any evidence of her guilt. In this case, it is charged in a third amended indictment that on or about the 7th day of August 2023, the defendant committed the offense of murder with use of a deadly weapon. Count 1, murder with use of a deadly weapon. Did willfully, unlawfully, feloniously, and with malice aforethought kill Jonathan Millette, a human being, with the use of a deadly weapon, to wit, a wooden stick and or other unknown object, by striking the said Jonathan Millette with the said wooden stick or other unknown object, and or through other means, the said killing having been 1, willful, deliberate, premeditated, and or 2, committed during the perpetration or attempted perpetration of a robbery. It is the duty of the jury to apply the rules of law contained in these instructions to the facts of the case to determine whether or not the defendant is guilty of the offense charged. Instruction number 4. In this case, the defendant is accused in a third amended indictment alleging an open charge of murder. This charge includes and encompasses murder of the first degree and murder of the second degree. The jury must decide if the defendant is guilty of any offense, and if so, of which offense. Instruction number 5. Murder is the unlawful killing of a human being with malice aforethought, whether express or implied. The unlawful killing may be effected by any of the various means by which death may be occasioned. Instruction number 6. Malice aforethought means the intentional doing of a wrongful act without legal cause or excuse, or what the law considers adequate provocation. The condition of mind described as malice aforethought may arise not alone from anger, hatred, revenge, or from particular ill will, spite, or grudge toward the person killed, but may result from an unjustifiable or unlawful motive or purpose to injure another, which proceeds from a heart fatally bent on mischief or with reckless disregard of consequences and social duty. Malice aforethought does not imply deliberation or the lapse of any considerable time between the malicious intention to injure another and the actual execution of the intent, but denotes rather an unlawful purpose and design in contradistinction to accident and mischance. Instruction number 7. Express malice is that deliberate intention unlawfully to take away the life of a fellow creature, which is manifested by external circumstances capable of proof. Malice may be implied when no considerable provocation appears, or when all the circumstances of the killing show an abandoned and malignant heart. Instruction number 8. The prosecution is not required to present direct evidence of a defendant's state of mind as it existed during the commission of a crime, and the jury may infer the existence of a particular state of mind from the circumstances disclosed by the evidence. Instruction number 9. Murder of the first degree is murder which is perpetrated by means of any kind of willful, deliberate, and premeditated killing. All 3 elements, willfulness, deliberation, and premeditation, must be proven beyond a reasonable doubt before an accused can be convicted of first-degree murder. Instruction number 10. Willfulness is the intent to kill. There need be no appreciable space of time between formation of the intent to kill and the act of the killing. Instruction number 11. Deliberation is the process of determining upon a course of action to kill as a result of thought, including weighing the reasons for and against the action and considering the consequences of those actions. Instruction number 12. A deliberate determination may be arrived at in a short period of time, but in all cases, determination must not be formed in passion, or if formed in passion, it must be carried out after there has been time for the passion to subside and deliberation to occur. A mere unconsidered and rash impulse is not deliberate, even though it includes an intent to kill. Instruction number 13. Premeditation is a design, a determination to kill distinctly formed in the mind by the time of the killing. Instruction number 14. Premeditation need not be for a day, an hour, or even a minute. It may be as instantaneous as successive thoughts of the mind. For if the jury believes from the evidence that the act constituting the killing has been preceded by and has been the result of premeditation, no matter how rapidly the act follows the premeditation, it is premeditated. Instruction number 15. The law does not undertake to measure in units of time the length of the period during which the thought must be pondered before it can ripen into an intent to kill, which is truly deliberate and premeditated. The time will vary with different individuals and under varying circumstances. Instruction number 16. The true test is not the duration of time, but rather the extent of the deflection. A cold, calculated judgment and decision may be arrived at in a short period of time, but a mere unconsidered and rash impulse, even though it includes an intent to kill, is not deliberation and premeditation, as will fix an unlawful killing as murder of the first degree. Instruction number 17. There are certain kinds of murder which carry with them conclusive evidence of malice aforethought. One of these classes of murder is murder committed in the perpetration or attempted perpetration of a robbery. Therefore, a killing which is committed in the perpetration or attempted perpetration of a robbery is deemed to be murder of the first degree, whether the killing was intentional or unintentional or accidental. This is called the felony murder rule. The intent to perpetrate or attempt to perpetrate a robbery must be proven beyond a reasonable doubt. In order for the felony murder rule to apply under the robbery theory, the intent to take the property must be formed prior to the act constituting the guilt. Instruction number 18, robbery is the unlawful taking of personal property from the person of another in his presence against his will by means of force or violence or fear of injury immediate or future to his person or property, or the personal property of a member of his family, or of anyone in his company at the time of the robbery. Such force or fear must be used to 1, obtain or retain possession of the property, 2, to prevent or overcome resistance to the taking of the property, or 3, to facilitate escape with the property. In any case, the degree of force is immaterial if used to compel acquiescence to the taking of or escaping with the property. Such taking constitutes robbery whenever it appears that although the taking was fully completed without the knowledge of the person from whom taken, such knowledge was prevented by the use of force or fear. The value of property or money taken is not an element in the crime of robbery, and it is only necessary that the state prove the taking of some property or money. Instruction number 19, robbery may spread over considerable and varying periods of time. All matters immediately prior to and having direct causal connection with the robbery are deemed so closely connected with it as to be part of the occurrence. Thus, although acts of violence and intimidation preceded the actual taking of the property and may have been primarily intended for another purpose, it is enough to support the charge of robbery when a person takes the property by taking advantage of the terrifying situation she created. Instruction number 20. It is unnecessary to prove both violence and intimidation. If the fact be attended with circumstances of threatening word or gesture, as in common experience, and is likely to create an apprehension of danger and induce a man to part with his property for the safety of his person, it is a robbery. It is not necessary to prove actual fear as the law will presume it in such a case. Instruction number 21. While a verdict must be unanimous, you need not be unanimous on the means or the theory of first-degree murder in arriving at your verdict. Instruction number 22, murder of the second degree is murder with malice aforethought but without the admixture of premeditation and deliberation. All murder which is not murder of the first degree is murder of the second degree. Instruction number 23, when it is impossible to commit a particular crime without committing at the same time and by the same conduct another offense of lesser greater degree, the latter is, with respect to the former, a lesser included offense. If you are not satisfied beyond a reasonable doubt that the defendant is guilty of the offense charged, she may, however, be found guilty of any lesser included offense, if the evidence is sufficient to establish her guilt of such lesser offense beyond a reasonable doubt. The offense of murder, which actually charges the defendant with first-degree murder, necessarily includes the lesser offense of second-degree murder. If you are convinced beyond a reasonable doubt that the crime of murder has been committed by the defendant, but you have a reasonable doubt whether such murder was of the first or second degree, you must give the defendant the benefit of that doubt and return a verdict of murder of the second degree. Voluntary manslaughter is a lesser included offense of both first and second degree murder. Thus, you may only return a verdict of voluntary manslaughter if you first rule out both first and second degree murder. Instruction number 24. Voluntary manslaughter is the unlawful killing of a human being without malice aforethought and without deliberation or premeditation. It is the killing upon a sudden quarrel or heat of passion caused by a provocation sufficient to make the passion irresistible. The provocation required for voluntary manslaughter must either consist of a serious and highly provoking injury inflicted upon the person killing, sufficient to excite an irresistible passion in a reasonable person, or an attempt by the person killed to commit a serious personal injury on the person killed. For the sudden violent impulse of passion to be irresistible, resulting in a killing, which is voluntary manslaughter, there must have been an interval between the assault or provocation and the killing sufficient for the voice of reason and humanity to be heard, or if there should appear to have been sufficient time for a cool head to prevail and the voice of reason to be heard, the killing shall be attributed to deliberate revenge and determined by you to be murdered. The law assigns no fixed period of time for such an interval, or leaves its determination to the jury under the facts and circumstances of the case. Instruction number 25. The heat of passion which will reduce a homicide to voluntary manslaughter must be such an irresistible passion as naturally would be aroused in the mind of an ordinarily reasonable person in the same circumstances. A defendant is not permitted to set up his own standard of conduct and to justify or excuse himself because his passions were aroused unless the circumstances in which he was placed and the facts that confronted him were such as also would have aroused the irresistible passion of the ordinarily reasonable man in likewise situated. The basic inquiry is whether or not at the time of the killing the reason of the accused was obscured or disturbed by passion to such an extent as to cause the ordinarily reasonable person of average disposition to act rashly or without deliberation or reflection, and from such passion rather than from judgment. Instruction number 26. You are instructed that if you find the defendant guilty of murder or voluntary manslaughter, you must also determine whether or not a deadly weapon was used in the commission of this crime. If you find beyond a reasonable doubt that a deadly weapon was used in the commission of such an offense, then you shall return the appropriate guilty verdict reflecting the use of a deadly weapon. If, however, you find that a deadly weapon was not used in the commission of such an offense, but you find that it was committed, then you shall return the appropriate guilty verdict reflecting that a deadly weapon was not used. Instruction number 27. A deadly weapon is any instrument which, if used in the ordinary manner contemplated by its design and construction, will or is likely to cause substantial bodily harm or death, or any weapon or device, instrument, material, or substance which, under the circumstances in which it is used, attempted to be used, or threatened to be used, is readily capable of causing substantial bodily harm or death. Instruction number 28. The state is not required to have recovered the deadly weapon used in an alleged crime or to produce the deadly weapon in court at trial to establish that a deadly weapon was used in the commission of the crime. Instruction number 29. To constitute the crime charged, there must exist a union or joint operation of an act forbidden by law and an intent to do the act. The intent with which an act is done is shown by the facts and circumstances surrounding the case. Do not confuse intent with motive. Motive is what prompts a person to act. Intent refers only to the state of mind with which the act is done. Motive is not an element of the crime charge, and the state is not required to prove a motive on the part of the defendant in order to convict. However, you may consider evidence of motive or lack of motive as a circumstance in the case. Instruction number 30. The defendant is presumed innocent until the contrary is proved. This presumption places upon the state the burden of proving beyond a reasonable doubt every element of the crime charge and that the defendant is the person who committed the offense. A reasonable doubt is one based on reason. It is not mere possible doubt, but is such a doubt as would govern or control a person in the more weighty affairs of life. If the minds of the jurors, after the entire comparison and consideration of all the evidence, are in such a condition that they can say they feel an abiding conviction of the truth of the charge, there is not a reasonable doubt. Doubt to be reasonable must be actual, not mere possibility or speculation. If you have a reasonable doubt as to the guilt of the defendant, she is entitled to a verdict of not guilty. Instruction number 31. The evidence which you are to consider in this case consists of the testimony of the witnesses, the exhibits, and any facts admitted or agreed to by counsel. There are two types of evidence, direct and circumstantial. Direct evidence is the testimony of a person who claims to have personal knowledge of the commission of the crime which has been charged, such as an eyewitness. Circumstantial evidence is the proof of a chain of facts and circumstances which tend to show whether the defendant is guilty or not guilty. The law makes no distinction between the weight to be given either direct or circumstantial evidence. Therefore, all the evidence in the case, including the circumstantial evidence, should be considered by you in arriving at your verdict. Statements, arguments, and opinions of counsel are not evidence in this case. However, if the attorney stipulates to the existence of a fact, you must accept the stipulation as evidence and regard that fact as proof. You must not speculate to be true any insinuation suggested by a question asked the witness. A question is not evidence and may be considered only as it supplies meaning to the answer. You must disregard any evidence to which an objection was sustained by the court and any evidence ordered stricken by the court. Anything you may have seen or heard outside the courtroom is not evidence and must also be disregarded. Instruction number 32. The credibility or believability of a witness should be determined by his manner upon the stand, his relationship to the parties, his fears, motives, interests, or feelings, his opportunity to have observed the matter to which he testified, the reasonableness of his statements, and the strength or weakness of his recollections. If you believe that a witness is lying about any material fact in the case, you may disregard the entire testimony of that witness or any portion of his testimony which is not proved by other evidence. Instruction number 33. A witness who has special knowledge, skill, experience, training, or education in a particular science, profession, or occupation is an expert witness. An expert witness may give his opinion as to any matter in which he is skilled. You should consider such expert opinion and weigh the reasons, if any, given for it. You are not bound, however, by such an opinion. Give it the weight to which you deem it entitled, whether that be great or slight, and you may reject it if in your judgment the reasons given for it are unsound. Instruction number 34. Although you are to consider only the evidence in the case in reaching a verdict, you must bring to the consideration of the evidence your everyday common sense and judgment as reasonable men and women. Thus, you are not limited solely to what you see and hear as the witnesses testify. You may draw a reasonable impetus from the evidence which you feel are justified in the light of common experience. Keep it in mind that such impetus should not be based on speculation or guess. A verdict may never be influenced by sympathy, prejudice, or public opinion. Your decision should be the product of sincere judgment and sound discretion in accordance with these rules of law. Instruction number 35. In arriving at a verdict in this case as to whether or not the defendant is guilty or not guilty, the subject of penalty or punishment is not to be discussed or considered by you and should in no way influence your verdict. Instruction number 36. You are here to determine whether the state has proven beyond a reasonable doubt the guilt of the defendant from the evidence in the case. You are not called upon to return a verdict as to the guilt or innocence of any other person. So if the evidence in the case convinces you beyond a reasonable doubt of the guilt of the defendant, you should so find, even though you may believe one or more persons are also guilty. Instruction number 37. You have seen trial exhibits that have been redacted. Those redactions have occurred either by agreement of the parties or by court order pursuant to Nevada law. You are not to consider the fact that an exhibit has been redacted for any purpose whatsoever. Instruction number 38. It is a constitutional right of the defendant in a criminal trial that she may not be compelled to testify. Thus, the decision as to whether she should testify is left to Ms. Michaels on the advice and counsel of her attorneys. You must not draw any inference of guilt from the fact that she does not testify, nor should this fact be discussed by you or enter into your deliberations in any way. Instruction number 39. When you retire to consider your verdict, you must select one member to act as a foreperson who will preside over your deliberation and be your spokesman here in court. During your deliberation, you will have all the exhibits which were admitted in evidence, these written instructions, the forms of verdict which have been prepared for your convenience. Your verdict must be unanimous. As soon as you agree upon a verdict, have it signed and dated by your foreperson and return with it to this room. Instruction number 40. During the course of this trial and your deliberations, you are not to, 1, communicate with anyone in any way regarding this case or its merits, either by phone, text, internet, or other means. Read, watch, listen to news or media accounts or commentary about the case. 3, do any research such as consulting dictionaries, using the internet, or using reference materials. 4, making investigation, test the theory of the case, recreating an aspect of the case, or in any other way investigate or learn about the case on your own. Instruction number 41. If during your deliberation you should desire to be further informed on any point of law, or hear again portions of the testimony, you must reduce your request to a writing signed by the foreperson. The officer will then return you to court where that information sought will be given to you in the presence of and after notice to the district attorney and the defendant and her counsel. Playbacks of testimony are time-consuming and are not encouraged unless you deem it a necessity. Should you require a playback, you must carefully describe the testimony to be played back so that the court reporter can arrange her notes. Remember, the court is not at liberty to substitute the evidence. Now you listen to the arguments of counsel who will endeavor to aid you to reach a proper verdict by refreshing in your minds the evidence and by showing the application thereof to the law. But whatever counsel may say, you will bear in mind that it is your duty to be governed in your deliberation by the evidence as you understand it, remember it to be, and by the law given to you in these instructions, with the sole fixed and steadfast purpose of doing equal and exact justice between the defendant and the state of Nevada. All right, ladies and gentlemen, we do not want to break up the closing arguments for you, so we're going to take our lunch recess now, and then when you guys come back, we will have the closing arguments by the parties when you return from the lunch recess. During this recess, you must not discuss or communicate with anyone, including fellow jurors, in any way regarding this case or its merits, either by voice, phone, email, text, internet, or other means of communication or social media. You must not read, watch, or listen to news or media accounts or commentary about the case. You must not do any research, such as consulting dictionary, using the internet, or using reference materials. You must not make any investigation, test the theory of the case, recreating the aspect of the case, or in any other way investigate or learn about the case on your own. You must not express any opinion regarding this case unless it's given to you. Ladies and gentlemen, it's 11:40. We'll be in recess until 1 o'clock.
All rise for the jury.
I don't know. That just made my ears and my ears hurt. OMG. So we got about 58 minutes to closing arguments, guys. What do you guys want to do? Do y'all want to look at some old testimony? Y'all let me know. Y'all know I'm down for anything. Do y'all want me just to sit up here and talk? Y'all know I'll talk to y'all. Yeah, so we got about an hour. Y'all want me to talk? Talk. Y'all think we can get 2 guilty verdicts? So they gotta, okay, so they'll come back in an hour. I'm thinking closing arguments probably be an hour apiece. Should we look at opening statements to see what each team promised us? To see if they came through on their promises? You know, I really like to see if they gave us what they promised. You want to talk? You want to talk, SD? What you want to talk about? What you want me to talk about, SD? Oh, yeah, champ. Yep. Yeah. I guess that I guess maybe because she told him to cut off the recording. Maybe. You want to talk about, you want me to drop the link? You want to come up here? I think it's because she told him to cut off the recording. I don't know. I think that's maybe why that didn't come in. And the polygraph. Remember, we didn't get the polygraph information either. Is she guilty? Not guilty? I got to pull a poll out for that. Considering that we have all the evidence now. Oh, you don't want to be seen. You can just talk. You want to just talk? You don't have to come on camera. I know it's you. I'm saying you don't want to just talk. You ain't got to turn on your camera. Oh, polygraphs are never allowed. Okay. That's good to know. Okay, here, I'll drop the link and you can call in. You can just talk. You ain't got to put your camera on. You good. Even though I do want to see your hair, but whatever. I know you went to the hairdresser the other day, unless you done messed it up already. Who knows? During one of your medicated episodes. You forgot to wrap it up. So I'm dropping the link for anybody. As Dee says, she gonna get on the phone with me and tell me what she got going on. If anybody else want to join, definitely there's the link to join, so I don't have to talk the entire time. Y'all know I ain't on it. I mean, ouch. Yeah, that judge, she like irritated me. I don't know why she did. Okay, SD has entered the stage. Let me put her up here. Y'all won't see her. I'm gonna have to show her how to add a photo. That way, when she's not there, she'll have something up here. Can you hear me?
Yes, I can hear you.
Awesome. Our SD super girl, Earth girl is up here. We
Here
got
I
a
am.
picture on your now. We gonna have to
Waving at everyone.
I'm gonna show you how to do it. We're gonna figure out. Therapist gonna show you. I asked therapist if she could show you, but everybody can hear you. So what you got to say?
Well, first I got to say my hairdresser told me to wash my hair twice a week, and I'm struggling with that. Tomorrow's my wash day, so no looky. Okay, and about hair, the defendant's hair, I think she's guilty for that.
You think she's guilty?
Yeah, guilty of really bad hair days.
Yeah. Well, we know that. We definitely know she's guilty of these bad hair days. She is so pretty. Like she is somebody I feel like supermodel, pretty. Unfortunately, she got hooked up with that old Robert B. It probably just turned her life just upside down, just a road to disaster for no reason at all. I don't even think that's a wig. I think that's her hair. Like it is really, 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 really bad.
She has the kind of hair that you would just dread and forget about it.
Yes, definitely a mess on top of her head. I don't honestly understand it. I guess by her guys as attorneys, nobody is helping her. And then my other thought is what I don't understand is how sometimes like when we watch Donna's case, is it like in certain cases they have somebody that be over there like comforting them, like because even in our case with the little boy,
Oh,
I want to call him a little boy, but the case
little stabby.
Yeah, little stabby. With stabby, he didn't have anybody over there kind of like like showing him courtroom decorum, like trying to help him like a Donna.
Like a priest.
I don't know. He needs something.
Yeah. Whoever could volunteer for that, I don't know.
Yeah, and I just wonder why she don't have no lady or nobody over there kind of like helping her.
Yeah. She does look pretty small and alone. But do you think she did it? Pretend you're in the jury and you can't see the part where they tell you the camera was supposed to be off. So you can't see that part. What do you think?
Um, I think that I'm kind of like in between. I don't know if I'm all the way guilty with her.
Yeah, I mean, we all saw what she said. We saw the video. So we know she did hit him on the head.
Yeah, but then she recanted all of that right there in that same video.
Yeah, because I think she thought the camera was off.
Yeah, I think that she recanted, and I think that I don't know if she felt pressure because of certain fact that she wanted to go home and see her kids.
Yeah.
They were, trying to tell her to, because that's what the defense brought up.
What is the jury also allowed to consider?
You say that again?
The jury, I heard something in openings about circumstantial evidence and common sense and stuff. So are they allowed to consider other things? Because she has a hell of a backstory.
No, what they only can consider was brought into the actual trial. So if it wasn't brought into evidence, then they can't use it, right? With that being said, I think that the husband, son, like his testimony was crap. If they
Mhm.
anything about his testimony,
Mumbles.
I don't think that
Bro, husband,
yeah,
son.
yeah, that person right there, like that, I don't understand. Um, the phone person that we listened to earlier, I know you say he was boring. I don't even remember nothing that he was talking about.
Boring.
He helped her or hurt her, but we did have
Yeah.
a phone expert today. And
I
another
think,
important.
sorry.
No, you fine.
Oh, okay. I think the son went up there and blamed her just in case he gets brought into this thing, right? And all he did was mumble. So I kind of don't, I think he was there to hurt her case, but I'm not sure how much he did damage her case.
Yeah, I don't think he damaged her case. I think that it just depends on. I don't think he really damaged her. I just think that he just kind of like supported the fact that hey, she did some bad things with me, right? And we were married, and I'm a liar, and I tried to hide a relationship, and yeah, I was banging my dad's girlfriend, and no, I really didn't want him to come move in. Like I really
Right.
move in because then that means that I got to move out or I got to figure out something different because what I don't understand is even though we're talking about that she wanted custody of her kids, it seemed like Jonathan was giving her all opportunities to be with the kids, even with the whole fact that she had them over the summer, right? So it wasn't
Yeah.
like keeping them away from her. So
Maybe she wanted to be with them during the school days. I don't know. Maybe Yoko did it.
yeah, all I
But
can think.
I gotta go because my phone is dying and I gotta go get my other phone.
How dare you?
I know. I ran out of battery with all this fun chat and stuff. But I'll
Okay.
be in the room on another phone.
Oh, I'm gonna get on you. Get the charger next to the phone, SD. She gotta leave us because she don't have her charger. You say it was the ninjas. It might have been. Thank you so much for coming up here and chat with me, SD. Does anybody else want to come up and chat? Hey, Hey, ninjas do swords and stuff, and they didn't never test the swords. So it could be. And you know what? Quiet as kept, guys. When I went back and listened to the when we were listening to the boy, the husband, bro husband, when we was listening to his testimony the second time, I was actually able to understand more of what he was saying. I don't know if y'all felt the same way, but the first day when we watched it, I guess because we wanted to hear so bad, I couldn't hear him. But when we went back and we was watching it the other day, I think it was maybe yesterday, I was like, oh, I can hear some of the stuff that he's saying. Or was it just me? I don't know. Yes, no, totally. Yeah, that's right. Ninjas use swords. Cause I don't understand how didn't nobody hear him getting his whole head cut off. Hey, dang. And now we didn't have a doctor testify saying, hey, he was still alive at the time of the beat. I don't know what the doctor was saying. Yeah. And see, that's what I'm saying. Like, were we that bad off up here in the chat? I'm telling you, when we went back the other day and I really wasn't expecting to hear anything from him, Macro, I was able to hear. Yes, get that AC DC get get your adapter and charge your phone. I really appreciate you coming up here, SD. You know I love you. You have to tell me how your hair wash day go tomorrow. When we wake up early in the morning. We did decide that early in the morning we gonna look at this McDonald's preliminary hearing. That should be pretty good. I like when they give videos and stuff. Oh, and she took her quick weave out and everything. Things is getting tough. This is gonna be another one. She gonna bite the dust. I don't even know why we in here. I don't even know why they doing a preliminary hearing. I guess maybe she pleading not guilty for reason of insanity or something. Okay, Baca said the doctor did conclude that he was named before postmortem. So I guess my question is guys, do we want to watch the opening statement? Is there any testimony that y'all want to re-listen to kind of before we go into our closing arguments? You say you started the day on 100%. I know you have been at court on time. Openings? Okay. Yeah, because I forgot what they promised us. You know, I like to know what they promised us. And we've been in this trial a long time. I thought the defense would have more. I even thought that the defense would have her testify, but they didn't. And remember, she is the same person that said that she could prove her innocence. Why didn't she get up there and testify? I do not know. That is weird to me. All of that stuff that she wanted to say when she was doing her plea deal. Why wouldn't you say that? Why wouldn't you discuss that at that point in time? Like, why wouldn't you take the stand? They must don't believe that she can do this. Like, they must really, really, really don't think that she could do this because she's the same person that told us this. So I'm like expecting like there is going to be some kind of breakthrough news or breakthrough evidence or something that said aha. Like I wanted a aha moment. And we're not getting that. And we're not even getting that from her. So I don't even know how she could say that. And she should have just took the 15 years. Man.
All of us are depending on you to follow these rules so that there will be a fair and lawful resolution to this case. You may not declare to your fellow jurors any facts relating to this case of your own knowledge. And if you discover during the trial or after the jury has retired that you or any other juror has personal knowledge of any witness or fact in controversy in this case, you must disclose that information to me outside the presence of the other jurors. The evidence in this case will consist of sworn testimony of witnesses, all exhibits received in evidence, regardless of which side introduces the evidence. If the attorneys on both sides stipulate to the existence of a fact, you must, unless otherwise instructed, accept the stipulation as evidence and regard that fact as proven. I may take judicial notice of certain facts or events. If I take judicial notice of a fact or event, you must accept that fact as true. In every case, there are two types of evidence, direct and circumstantial. Direct evidence is testimony by a witness about what the person saw or heard or did. Circumstantial evidence is testimony or exhibits which are proof of this badge lets everyone know the jury.
With what she preteen young children. On August 7th of 2023, the defendant, Devyn Michaels, brutally murdered and savaged the body of her ex, Jonathan Willett. But the story did not begin on August 7th of 2023, and all I can say is buckle up because you're in for a wild ride. This is Jonathan in life. It's Jonathan's two young children that he shared with the defendant. Both girls, faces blocked out, they're preteen young children. You will learn during the course of this trial that John had a son from a prior relationship named Devyn, that after Devyn was born, he split with Devyn's mother, eventually getting into a relationship with the defendant. They then had these two children together. They separated. And there was a custody agreement that was ordered by the family court in which the victim had full physical custody of the girls. You will learn that the defendant was not happy about that situation, that the defendant wanted to have control of her girls, and she wanted to start a new life with Devyn, the same Devyn that is John's son. On August 7th of 2023, Yoko Willett, an elderly woman, woke up to find her dead son in his room with what she referred to as his face and neck missing. This is the 911 call she plays.
Yes, this is Yoko Willett. My number is, its address is 2698 Aradura Drive, Henderson, Nevada. Yeah, 702-203-8975.
Tell me exactly what happened.
Okay, I went downstairs and my son is on the bed, all bloody. I opened the cover. It's all bloody. I don't know. Can you come over?
Yeah, we're coming help you. What happened to him, you know?
I have no idea. And so was the outside this morning.
Is he awake now? Is he awake?
Yes, I think he's dead.
Listen to me, I already have a call in for help, okay? How old is your son?
About 46, I think.
Is he breathing?
Oh, bloody all over. Huh?
Where's he bleeding from, him?
I don't know, some leg or something.
Do you see any weapons around him?
No.
Would he have harmed himself? Can you tell?
What?
Did he look like he hurt himself at all? Like, maybe shot himself?
No idea. Those was on the yard. I told him, I didn't know he was trying to move out from my house.
Okay.
And his girlfriend was here yesterday.
Okay. When's the last time you saw him? Yeah, when's the last time you saw him okay? How long ago?
Last night.
Last night?
Yeah. I think somebody has come to eat.
Okay, yeah, we're already on the way, okay? We're gonna try and help them before we get there. Do you have a defibrillator available inside your house?
Huh?
Do you have the defibrillator available at your house, the shocking machine?
I don't get, I'm sorry, I don't.
That's okay, ma'am. What I want you to do is see, do you feel safe to get right next to him so we can try to just...
That is what police found when they arrived at the Willette residence. Jonathan on his bed in his bedroom. As you can see, his head is missing. Large blood stain at the foot of the bed there, and a large amount of blood underneath where his head should be. Officers eventually removed the cover from his body and noted several chemical burns, or what appeared to be strange chemical burns on his body. And a very clean decapitation that you can see there. Henderson Police Department was responsible for the investigation. After first responders arrived on scene, clearly couldn't render any medical aid to the victim, they locked down the scene. Homicide investigators are then enlisted and take over. Along with the homicide investigators, they bring out an army of crime scene analysts and treat this case obviously very seriously, and they go into the home after executing a search warrant. When they go into the home, they obviously focus on the bedroom, but they do a pretty thorough search of the entire residence, the curtilage, the backyard, the front, the trash cans, the upstairs bedrooms, the kitchen, the living room, and these are the items that they find. A couple of chemical bottles, obviously relevant for the potential chemical burns on the victim's body. They find some interesting writings that you'll see a little bit more of later, demonstrating that there was a contentious custody case going on between the victim and someone, at that point, someone. They see out front John's moving truck, the victim's moving truck. You will learn that he had a moving business. There's a trailer on the back. It's parked a little cattywampus, going the wrong way on the street and poking out into the street as though he may have planned on moving after he last parked that car or truck. But the items that weren't found are what was particularly notable for the investigators. They didn't find a murder weapon. They didn't find whatever this person used to cut his head off. They did not find his head. They did not find his wallet. They did not find his truck keys, and they did not find his phone. They interviewed Yoko, and the gentleman above Yoko's photo is Yoshida, her partner. According to Yoko and Yoshida, the defendant, who they referred to as Nikki and knew as Nikki, ultimately identified as Devyn Michaels, was the last person to see Jonathan alive. Nikki and John had been moving the girls and John's items from this Paladura address to Nikki's address on Porcupine Rim that she shared with Devier, and for a temporary period over the summer, the young girls. They learned that Nikki and John returned to this address, the Paladura address, for the last time at 10 p.m. on August 6th, or around 10 p.m. They learned from Yoko that about 1 a.m. she was going downstairs for a glass of water and ran into the defendant, who she will describe to you when you hear from her as she appeared to be startled to see me. The defendant and Yoko have a conversation. It's relatively brief. Yoko's in the kitchen cleaning up some dishes. The defendant has now entered the kitchen, and they begin to talk when the defendant tells Yoko, John's asleep. Don't go in there. Those aren't her words. You'll hear this through the course of the trial. She says, John's asleep. He's passed out. We have plans for him to move some more stuff in the morning, kind of don't bother him kind of thing. Yoko then noticed that the lights were on in John's room, but decided, hey, if he's asleep, I'm not going to go in there. She returns back upstairs. Yoko went to sleep, leaving Nikki, or the defendant, alone in the home. You will learn very clearly that there were only 4 people in the home at the time of this incident: the victim, the defendant, Yoko, and Yoshi. Yoko also will tell you that around 8 a.m. she found John without a face. You probably heard from the 911 call, there's a bit of a language barrier. She'll do her best to describe what she initially saw and the shock, obviously, that ensued. So the defendant is the last person to see him, so investigators are very curious to speak with her. Homicide detectives summon her to the scene. They get a hold of her via a phone number given by a neighbor. She answers that phone. It's her phone. She agrees to come to the scene, leaving Devier and the girls are with the defendant as well. She, in her initial interview, says John is her ex. They share the 2 children together, that they spent the whole day together on August 6th, moving, shopping for the girls' school supplies, etc. Everything's normal from her perspective. That evening, they were moving the girls' things into her home on Porcupine, and she was, in fact, at the Paladura residence last night doing that. She would go on to describe it's a normal night, there's nothing out of sorts, and that John was alive and well in the garage when she left. Remember that. Further investigation, of course, occurs. Homicide detectives are treating this very seriously. You will learn from many of them that when a homicide such as this comes in, they divide duties. There's too much for one person to do. And so, although there is a lead detective who goes by the name of Dennis Ozawa, Detective Ozawa was not in any way the only person investigating this case. He had an entire team, and you will hear from many of those people. You will learn that one big thing in the modern days of investigation is videos, video cameras. They're everywhere in our valley, so they canvass all around. The Paladura residence is kind of right in the middle of all those yellow markers. They canvassed all these different addresses for anything who saw, heard anything, and anyone who had a camera. Some of those were fruitful, some of them were not. They knocked on the doors where video cameras were visibly present. They even knocked on doors where they weren't present in the hopes that maybe someone saw or heard something. And they gathered a lot of footage. We're going to do our best during the course of this trial to streamline it for you. There's hundreds of hours of footage, and we're going to present it in the best way we can. They also learned that there is a neighbor directly to the left of the homicide scene who had a motion-activated Ring camera, which will become important later in the trial. There also was an autopsy, of course. The Henderson Detective Ozawa attended that autopsy. You will hear from the medical examiner in this case, Dr. Stephanie Yagi with the Clark County Coroner's Office, who enlisted the assistance of a forensic anthropologist, Dr. Burns, who works out of UNLV. You will learn that Dr. Yagi surmised that the cause of death was homicidal violence and the manner of death was homicide. You will learn that she noted the non-thermal chemical burns on the body, which did not contribute to his death, but were notable for investigative purposes. Something important I want you to keep in the back of your mind is there were no bleeding injuries anywhere else on the body, so everything was focused neck and above. You will learn that the decapitation occurred post-mortem. There are histological reactions that the body has if this type of thing happens while you're still alive and your body is trying to actively repair itself. None of those were present during the course of the autopsy, and so the doctor will testify that this was a post-mortem decapitation. As I mentioned, she enlisted the assistance of a forensic anthropologist, Dr. Burns. You will hear from her as well. She will talk about the science behind what she does, and in this particular case, she was enlisted for the main purpose of determining what was used to cut off Mr. Willette's head. She will tell you that she did microscopic examination. During the course of that thorough examination, she determined very clearly that there were 2 separate instruments used to chop off his head. She even can narrow it down by time because of the layering of the artifacts on the bones. And so she will surmise and testify that first, a serrated or non-serrated knife was used, so a knife, whether serrated or not. When that was unsuccessful, the defendant then used a powered saw of some sort. She can't narrow it down to class. You will learn, or class of tool. You will learn that the bones in the neck, the cervical spine, are very small. There are areas on it which would reflect these markings, but they are so small that she can't really surmise what type of saw. She'll testify that if it's a long bone, she has seen cases with dismemberment, involving dismemberment, but not a decapitation. But with dismemberment of larger bones, you can see more, which allows you to narrow down the type of saw that was used, but here that's not possible. Nonetheless, she will testify clearly that it was two different instruments, knife first, saw second. Further investigation also revealed what Mr. Draskovich alluded to in jury selection, a very non-traditional family situation. And I kind of mentioned this a little bit earlier. The investigation revealed that the defendant, after splitting with John, ultimately married his son, Devyn. Devyn moves in with her. They are together for an extended period of time. The defendant loses custody of the girls, and eventually the girls end up for a short period of time over the summer of 2023 before school starts, living in the home with the defendant and Devyn, with Jonathan living back at the Paladura residence with his mom and Yoshida. This is Clark County Department of Family Services document showing the parent placement verification letter describing that John was awarded full physical custody of the girls on October 27th of 2022. That Jonathan, as I said, and the girls were living at 2698 Paladura at the time. You can see in the document that the defendant had weekly supervised visitation with the girls for an extended period of time. And you will learn through various witnesses that John kind of bent the rules with that and allowed her to see the girls a little bit more than was court ordered. You will also learn that John allowed the girls to stay with the defendant and Devyn, as I mentioned, at the Porcupine Rim address over the summer of 2023, and that Jonathan was going to move in with the defendant and the girls to try to stabilize their lives and basically try to get everyone under the same roof. The girls were having a real hard time with the custody situation, and his main focus was the girls. Obviously, with all this information they have gathered, the defendant is now a person of interest. She's the last person to see John. She's been over there very close in time to his murder. There's all these ties. There's the custody paperwork I showed you earlier, the writings that were in his room. And so they respond to Porcupine Rim. I can't remember if I put a map in here, but I'll just tell you we'll have a Google map for you that shows the distance between the homes. They're about 30 minutes apart. Paladura is in Henderson. Porcupine Rim is in Las Vegas, and it's a pretty good distance, about 30 minutes. The detectives will tell you, and this is Detective Ozawa and Detective Carrie Skinner, that when they go to the residence, they observe the defendant. She's kind of either moving stuff or moving back and forth between the home and the vehicle, and they note a couple of things before they approach and make contact with her. You see the Nissan Armada, which is the defendant's vehicle, looks pretty clean and shiny. You will see that cell phone on the right. The detectives observed that when they first drove up, kind of sitting in the rocks near the driveway. Thought, okay, that's weird, but we're not going to touch it. We're not executing a search warrant yet. They leave it be, and then they make contact with the defendant to interview her again, because now they know some more things, and things aren't quite adding up, and they want to know a little bit more. They make contact with the defendant, and this is prior to them going into the home and executing a search warrant on the home. They get a little more information, but the story generally remains the same, that John recently dated Andrea. This is extra information. but that last night he threw away his engagement ring in the trash can at Paladura, which, remember that. That John wanted to get back together with her romantically, this is new information, and move in, which we already know to provide stability for the girls. She mentioned that Yoko does not know Devier and I are married. She claimed that her marriage with Devier was one of convenience for insurance purposes and non-romantic and not sexual in nature. You will learn, and you'll actually hear it, the interview. During this interview, out in the police vehicle in front of Porcupine Rim, the girls walk up, and you can hear them, their sweet little voices, and they're like, "This is Daddy's phone, this is Daddy's phone, this is why he wasn't answering." The detectives realize that's kind of important. They take the phone from the girls, or the girls give it to them, and the detectives note blood on the phone. Something important. They ask the defendant, "Well, how did this get here?" And she responded generally that he must have left it here earlier in the day when he was moving, and I don't know. I mean, there's a cigarette butt over there. I know he smoked cigarettes. It's by where the phone was. He probably left it. And the detectives are a little suspicious of that. They ask her a few more questions. Again, you're going to hear this stuff in the audio recording, so I've summarized it. And then ultimately at the end, she again sticks with this: John was alive and well in the garage when I left. As I mentioned, the detectives then obtain a search warrant and execute that search warrant on the home. They also get the warrant for the vehicles. You'll learn that that white moving van is Devier's work van. He was a home security installer. He did various jobs for a legitimate company. They searched that vehicle, nothing of evidentiary value found in that vehicle. You can also barely see behind the van. There's a small sedan that's inoperable, but they search it nonetheless. They find nothing of evidentiary value. When it comes to the defendant's Nissan Armada, they photograph it on the outside, but then they apply seals to every opening, and then they tow that to have it searched later at their lab. You will learn they find in the garage the Ring cameras from John's home. A little weird. They grab them up, they seize them pursuant to the search warrant, in the hopes that maybe since these are the cameras from John's home, it captured something. There is no footage, unfortunately, associated with it. They issued administrative subpoenas and attempted to obtain footage from Ring. There was no footage because he didn't have the right account to store the Ring footage in the cloud. And I'm butchering the technical terms, I'm sure, but you'll hear all of this from witnesses. They also noted that there was no SD card in the cameras themselves, but nonetheless, they took them, they seized them pursuant to the search warrant, just to make sure. You will also learn they find several of defendants' writings throughout the home describing kind of the relationship with Devier, not exactly how the defendant described it to them to begin with. Very importantly, they find the defendant's purse. Inside her purse, they find the victim's social security card, along with one of her work cards. This is the defendant's bedroom. What I've circled there is basically her underwear drawer. When you execute a search warrant, you go through everything. You basically toss the place. And when they were searching the defendant's underwear drawer, they found something. And my mouse is freezing on me here. Very important. They find several layers of knotted plastic bags, and inside they find the victim's wallet, current identification, and his only set of truck keys. After the search warrant, they speak with the defendant again. They learn that the defendant's version regarding the phone is that she has no idea how it ended up there. They confront her with the blood on the screen. She initially says, oh, I don't know, and then she says, he cut himself moving. Remember when I talked about the autopsy earlier, no other bleeding injuries on the victim's body, remember that? She claims he cut himself while he was moving. There's no evidence to suggest that. They learned John wanted to move in with the defendant so we could have the girls under one roof and parent them. They further learn, although they already kind of know this, that John has physical custody of the girls, and the defendant claims she plays nice with him to kind of keep access to the girls and keep things kosher. They also learn, which is very important, that John was moving in quicker than she expected. They learn not only from the defendant but other witnesses that this idea of them reuniting for the children had been discussed for several months, but that on this night, on August 6th, John began loading stuff into the truck when the defendant is loading up the girl's stuff into the truck. And she kind of realizes for the first time he was serious about this and this is going to happen. And you'll learn that that's when the walls start closing in on the defendant and she makes the decision she made. The detectives confront her with the fact that there is no notifications on the phone when the girls provide it. It's black, they open it, and there are no notifications on the screen. But that she had contacted him several times the night before and that those notifications should be there based on the timing of the phone arriving in her house. They ask her, before telling her what they have found in the home, they ask her, hey, do you have any idea where John's wallet would be? She says very unequivocally, no idea. They then say, well, hey, we kind of found this ID and this wallet in your bedroom. And she then changes her story and she provides a version, again, you will hear this, an audio recording, in which she says it was back at the Paladura residence. She held the plastic bags open and John placed his items into the bag and she tied them up right in front of him. And they confront her when the story doesn't make sense over and over. And that's kind of the story she sticks with regard to that. You will learn there was an extensive follow-up investigation after that interview. Although things weren't adding up, although things looked very strange, the detectives did not rush to judgment and arrest her right there. Although all of the victim's property is inside her home, his blood is at her scene, they don't arrest her right there. They choose to do follow-up investigation. You will learn there was fingerprint analysis that was done. Nothing really of evidentiary value comes of that. You will learn that DNA processing was done, that the victim's blood was in fact on the phone at her house, and that the defendant's DNA was on the knot of those plastic bags where his property was found inside. You will also learn that an extensive digital investigation was done, and that was in the form of video surveillance, digital forensics, meaning phone dumps. They take the actual devices found. There's 11 found inside her home, including the victims. They plug it into a machine. They'll talk about the technology. They're able to extract the data from the phone, and they find several things of note. They also do a call detail record investigation. That is the records that your cell phone maintain or are maintained on your cell phone, everybody's cell phone, with the company you use for service. And those records not only show incoming and outgoing messages and calls, but they also show location data, because every time you place a call or receive one, you are pinging on some kind of tower and leaving a trail of where you've been. Not a precise trail, but a general trail of where you've been. They also pull Burla. Burla is a lot more precise than the cell phone towers. That is an infotainment system inside the Nissan Armada. And they're able to extract that data, and I'll show you that in a moment. They very clearly get a timeline based upon the Burla. The defendant's vehicle is at the victim's home by 10 o'clock at night. The vehicle activates but does not move at about 11 o'clock at night. The vehicle leaves the home for good at 2:04 a.m. 2:04 a.m. on August 7th, and you'll see that in a moment. I've noted here that the video surveillance, DFL, and CDR rule out Devier. Obviously, he was interviewed. You will hear from him during the course of this trial, but they treat him as a suspect. Obviously, there's some fishy circumstances. They're not just pinning this on the defendant because what she's saying doesn't make sense. They're looking into both the defendant and Devier and others. The video surveillance that I'm referring to is kind of wide-ranging. There is one particular camera you're going to learn about that was near the Porcupine Rim residence, the defendant's home. That is a full-time camera. It's not a motion-activated camera. That allows them to see the home, see what vehicles left, came and went at any given time, and they clearly rule out Devier from that video. In addition, I mentioned earlier, there's video surveillance from next door to the victim's home that captures the defendant at around 11 a.m. going to her vehicle, moving it slightly, and then ultimately leaving. Gotta love technology. Here are a couple of additional clips from video surveillance. The one on the left is the defendant with the victim the night before when they're doing the moving. It shows us that they are together, that no third party is present, it's just them. They go into a store, they buy an item, and they leave. And then 2:28 a.m., the defendant is alone. It kind of clipped off on this particular picture, but the defendant is alone in her vehicle after she leaves the residence and goes back to her home, ultimately landing there about 2:46 a.m. Those digital forensic examinations I mentioned become relevant, especially when it comes to Devier. There's much more than this, but I'm trying to narrow it down for the opening statement. This particular message was sent from Devier to the defendant. As you can see, at 10:36 p.m. See you when you get back. I'm going to sleep. Girls are in the living room. And the video surveillance supports that. This image you're seeing now is the CDR cell tower location data. There is much more to it when the witness testifies. There's a bunch of animated videos you're going to see. Just for this purpose, I did a screenshot. The blue and red represent the victim and the defendant's phone, and the green represents Devier's phone at our operative time period, showing him across town when that last message was sent and throughout the evening. You'll also see the burla that I referenced earlier. As I mentioned, burla leaves actual GPS breadcrumbs, like by the foot. So as opposed to just a tower you're hitting on, this is actually showing the track. And you're going to see very clearly when the defendant came and went from the victim's residence on the night of August 6th, as well as when she left on August 7th. After all of this information is gathered, it's very clear that the defendant did this to the detectives. They make the decision to place her under arrest for murder with use of a deadly weapon. After she is arrested, she is interviewed again. This time they try with two different detectives. Obviously, the statements she gave earlier were inconsistent, and so they send in a couple of other detectives, and you'll hear from that detective as well. In this particular interview, the defendant acknowledged that she realized John was actually moving in, that at the time of the murder, she was giving John a massage on the bed. While he was lying on his stomach, the defendant got up, walked over to the fireplace, and grabbed a large, what she referred to as a stick or maybe a candle holder. It's a large, heavy object. John was lying on his stomach, not a threat, in the midst of a massage, face down, unexpected, and the defendant admits that she returned to the bed, bashed him over the head with that club or stick, and that John went limp at that time. You will learn that the defendant refused to acknowledge what she did next. You can make your determination as to why someone might do that as this trial goes on. that she refused to tell detectives what she did with John's head or with the weapon, that those items were never recovered. And so you need to put together the pieces, as the judge just described with the rain example. You will learn that this is the reality of the situation before John was killed, and that the defendant wanted John out of the picture. This is the future that she saw, that she wanted, and the only way to have that future was with John out of the picture. Thank you for your time and attention this week. We truly do appreciate it.
Is the defense going to give an opening statement?
Yes, we are, Your Honor, and if we could.
So just for the record, they are still waiting. You on a walk? I know. I want to have my I don't know which one we should listen to. Cause okay, so we can do law and crime. Maybe we'll do law and crime. Let's see where they at with law and crime. Yeah, I made me a like a chicken salad. Yeah, and I think that half my problem be that I wait so long to eat, right? That I be starving and I be just trying to like stuff my face. So yeah, I got stuff all over me. All it takes is for one piece of lettuce to yeah, when you talk about some El Polo Loco avocado, that sounds very spicy. That sounds like me going to the what is it called? The Mexican restaurant for, Loco Patron or something. Woo! I tell you. I told you yesterday, let's get physical. That's what that sauce sound like. That sound like we about to get physical out here. Like I be wanting all the stuff in my salad. I got croutons. Oh, I got more croutons than salad, y'all. Like I don't even have no lettuce. My salad consists of literally croutons, and I be croutons. It is drowning in dressing. Oh my goodness. The best dressing in the world is country French. It is drowning in this dressing. Like, oh, I'm telling you, I got more toppings than lettuce, like, and chicken. That's all it is. But I mean, I got carrots and eggs and I got cucumbers. I don't have any lettuce in this mess. It should be so illegal. The way this, I shouldn't even be able to call this a salad. This should be called sweet goodness, aka fake salad. Yeah, this is a fake salad, but I'm gonna call it a salad because today is Friday. So Wendy's have free French fries, so I gotta taper some of this off in some type of way. Okay, let me see. I'm just looking at the feed to see where they're at. I did see the judge head, but that's all I did was see her head. So now we have seen what the prosecution team has offered us. I don't know, guys. Do y'all think they gave it all up? Do you think we got all the goods? I'm gonna let us start the defense testimony, the defense opening statement for all of y'all that want to see that old big D pic. I blurred it out, so y'all won't be able to see that, but whatever. We'll watch what we can watch. They didn't even, I don't even know if they showed the big D picture during the trial. Oh, wait a minute. They may be back in court. Yep, they are back in court. Good. Here we go.
jury's all present and accounted for.
We are back on the record at C 377239, State of Nevada versus Devyn Michaels. May the record reflect that Ms. Michaels is present with her attorney, Deputy District Attorneys on behalf of the state, and both parties stipulate to the presence of our jury.
Yes, Your Honor.
All right. Ladies and gentlemen, we have now reached the portion of trial where closing arguments will be given. Since the state has the burden of proof, the state will get to begin and close the closing argument. State, are you prepared to give your closing argument?
Yes, Your Honor.
All right, whenever you're ready.
The truth is the truth. It shouldn't change. And the truth is, the walls were closing in on Devyn Michaels and the fantasy that she had put together. And what was her response when her children were taken away? Jonathan had custody, and this was in danger. She did the unfathomable. She murdered Jonathan Millett. The crime charged in this case is murder with use of a deadly weapon. We heard from the judge. She did read that to you folks prior to our break. So what it is willful, unlawful, felonious, and with malice aforethought, the defendant killed Jonathan Millett, a human being, with use of a deadly weapon, be it a wooden stick and/or an unknown object, by striking the said Jonathan Millett with the said wooden stick and/or other unknown object, and/or through other unknown means. The said killing having been 1, willful, deliberate, and premeditated, and/or 2nd, committed during the perpetration or attempted perpetration of a robbery. Let's start with the easy one, the deadly weapon. You heard from the defendant that she hit Jonathan Millett with a stick, and he died. So this is clearly showing that that stick that she described to you is a deadly weapon because it resulted in the death of Jonathan Millett. Now I want to point out something very important that's in your instructions, and it's not something to gloss over. The state is not required to have recovered the deadly weapon used in the crime in this case. So keep that in the back of your mind that we are not required to do that. However, we have the confession from the defendant that that is what she used. So that being said, you'll have your verdict form when you go back to deliberate. So I think it's helpful to sort of walk through that. So based on knowing that there was a deadly weapon used beyond a reasonable doubt, we're able then to eliminate guilty of first degree without the use of a deadly weapon, and also guilty of second degree murder, and guilty of voluntary manslaughter. So all that we are left are those charges with use of a deadly weapon. Let's talk about murder. Your instructions tell you that murder is the unlawful killing of a human being with malice aforethought. Whether express or implied, the unlawful killing may be effected by any of the various means by which death may be occasioned. So let's talk about malice aforethought. What does that mean? That is the intentional doing of a wrongful act. So I don't think anyone is going to get up here and say that this was not a brutal first-degree murder. Knowing that, defendant's actions were not voluntary manslaughter. Voluntary manslaughter is the unlawful killing of a human being without malice aforethought, without deliberation or premeditation. It is a killing upon a sudden quarrel or heat of passion caused by a provocation sufficient to make the passion irresistible. That is not what we have in this case. The defendant said in her statement to the police, told the police, that she was giving Jonathan a back massage while he was laying face down on his bed. She was next to him. She got up off the bed, made the conscious decision to then walk over to that fireplace that we all saw, grab what she described as a candlestick, an object, right? Walks over, makes a conscious decision to then walk over, goes to the bed, and while Jonathan is still face down, with his head facing away from her, as she told us, she took that stick and bashed the victim in the head. He had no clue that this was coming. Conscious decisions every step of the way. His body goes limp. This is not voluntary manslaughter. The instruction also tells you if there should appear to have been sufficient time for a cool head to prevail and the voice of reason to be heard, the killing shall be attributed to deliberate revenge and determined by you to be murder. The defendant did mention that the victim, Jonathan Willett, had rubbed on her leg. And then she kind of just shooed it off. It was like, okay. And then, after that, he seemed happy, right? His face was turned away, thought he was getting more of a massage. But instead, the defendant made those conscious decisions that I just went over and bashed him in the head. This is not voluntary manslaughter. So that being said, when you go back to deliberate, you'll have this form again. We've already crossed off the ones that don't apply, so let's cross off the other one. Voluntary manslaughter with use of deadly weapon. Because no one's going to get up here with reasonableness and say that this was voluntary manslaughter. So then what are we left with? First degree murder. You were instructed that murder of the first degree is murder which is perpetrated by means of any kind of willful, deliberate, and premeditated killing. What are those three elements? Willfulness, deliberation, and premeditation. And I do have a graphic photo here, so I just want to warn everyone, including in the gallery, that there will be a graphic photo. This is first degree murder. What is willfulness? Willfulness is the intent to kill. There needs to be no appreciable space of time between formation of the intent to kill and the act of killing. What is deliberation? Deliberation is the process of determining upon a course of action to kill as a result of thought, including weighing the reasons for and against the action and considering the consequences of those actions. This is very important, and I am going to spend some time on this. A deliberate determination may be arrived at in a short period of time. The best way to illustrate this is the stoplight example. So all of us drive to work, we're on our way to work, and there's a stoplight. Sometimes that stoplight turns yellow. And when it's yellow, you're making some conscious decisions at that point, right? Either you're taking the decision to press on the brakes, but during that you're deciding, well, is someone going to rear end me, right? If I just stop on my brakes, right? Is my coffee that I just bought from Starbucks going to fly all over the car and I'm not going to have coffee at work if I slam on my brakes? Is my purse going to fly off the seat and I'm already running late for work, so how am I going to have time to put all the items back in my purse so I can walk into work? If I press on the brakes, I'm going to then potentially be late for work. And I've already been written up a couple of times, so this may be the time I'm fired. All of this is going on in your head when you're faced with that yellow light. You're also thinking, well, I obviously can't press on my brakes, right? So I'm going to have to blow through this light. But what are you thinking about when you're going, making the decision to run that yellow light that's about to turn red? You're hoping there's no cop, right? You're hoping that a motorcycle doesn't come out from nowhere and you hurt someone. There's no bicyclist that's just somehow hoping that you're going to stop at the red light because they see that it's yellow. All of these are conscious decisions that you're weighing, and that is all deliberation in a short period of time. We do it every day. Again, it need not be for a day, an hour, or even a minute, this premeditation, this decision making. It may be as instantaneous as successive thoughts of the mind. The stoplight example. No matter how rapidly the act follows the premeditation, it is premeditated. That is what happened in this case. When the defendant made each conscious decision ending Jonathan Willette's life. We also have another theory of first-degree murder. That's called felony murder. There are certain kinds of murder which carry with them conclusive evidence of malice aforethought. Therefore, a killing which is committed in the perpetration or attempted perpetration of a robbery is deemed to be murder of the first degree. So what is a robbery? You are instructed that robbery is the unlawful taking of personal property from the person of another, or in his presence against his will, by means of force or violence or fear of injury, immediate or future to his person or property, or the person or person or property of a member of his family. Such force or fear must be used to 1. Obtain or retain possession of the property, 2. To prevent or overcome resistance to the taking of the property, or 3. To facilitate escape with the property. We heard a lot of evidence over the past 2 weeks, which is why I'm slowly going through this today. We have evidence that the defendant took multiple items of Jonathan's belongings. Social security card, a wallet, his only set of car keys. Why did she want those things? How was she going to enroll the girls at school without having Jonathan's documentation? This all goes into her motive. The defendant obtained Jonathan's property by means of force or violence, i.e., she killed him, and took his wallet, his only set of keys, and his social security card. This is another easy one. That being said, you'll have your verdict form. And between both theories of murder, we are confident that you'll be able to check that first box and at this point eliminate the second-degree murder. But that being said, any way you look at this case, this is first-degree murder. And this is important to note, because when you go back there, you're doing an important thing. But what is also important is that while a guilty verdict must be unanimous, you need not be unanimous on the means or the theory of first-degree murder in arriving at your verdict. What do all those words mean? That means when you go back there and you're carefully weighing the evidence in this case, if 6 of you decide that the state has proven beyond a reasonable doubt the felony murder theory, and 6 of you decide that it's the premeditated deliberate, that doesn't matter. The verdict would be guilty of first-degree murder. You need not be unanimous on the theory of first-degree murder. So there's been a lot of talk over the past 2 weeks about Devyn, and we're not shying away from this. You saw him testify on the witness stand. There is overwhelming evidence beyond what he told you that Devyn did not murder his father. Let's go through that. We'll start with Devyn's testimony under oath. He tells you that he saw his father, Jonathan Willette, at that Porcupine Rim address, the house that he and Devyn shared, briefly on August 6th. You'll recall that he saw his dad in the garage and just went right back inside. They never had a discussion. And he was home at the Porcupine Rim address on August 6th. He told you that he was helping the girls, his sisters, Devyn's daughters, with homework. The defendant, Devyn, tells him that she's going to help John move some things. He goes on about his night. He stays at the house, he watches a movie with the girls, he puts them to sleep. This is what he's telling us. He goes to sleep around 10 p.m. He woke up, he recalls around 2 a.m. to see Devyn getting in bed, which they shared at that time, and he just went back to sleep. He woke up at 6 a.m. the next morning on August 7th. He gets dressed, he goes to work. Even if you don't want to take his word for it, which we believe you should, we also have other evidence to corroborate what Devyn told you. This is a text message that Devyn sent to the defendant, Devyn Michaels, where he texted her, "See you when you get back. I'm going to sleep. Girls are in the living room." corroborating that he put the girls to sleep, and he was going to sleep as well. This was on August 6th, 2023, at 10:36 p.m. We also have video surveillance to corroborate this. No video surveillance shows Devier's vehicles in Paladura's neighborhood, Paladura being the murder house neighborhood. No vehicles belonging to Devier are seen. And we spent a lot of time going through that video surveillance on that lengthier day of trial, showing you that there is no indication that Devier's vehicles are in that neighborhood on the night of the murder. There's no video surveillance showing Devier's vehicles entering or exiting Porcupine Rim neighborhood, the neighborhood he lives in with Devyn. Remember that fixed camera? There was no indication that his vehicles left that evening, or entered, for that matter. Devier's vehicle was in the same position overnight. You recall there was sort of that catty corner home that had that footage showing the daytime and the nighttime, and the van, Devier's van, remaining in the same position, to a T. There's also no video surveillance showing Devier jumping a back wall to get in another vehicle. There is no evidence of that. What we do have is Devier leaving in his work van at 7:31 a.m. on August 7th, because that's what happened. We also have the CDR mapping, which also rules Devier out, beyond his word. If you recall, there was that Detective Good testified pretty in depth. He had color-coded the different phones so that you could see with ease which phones were popping up at which times. You recall Devier's was green. We see green popping up at that Porcupine Rim Street, which is his home, throughout the night, and more importantly, during the time period of the murder, which we'll talk about later, because we are able to narrow that down. At no point do we see Devier at the murder house the night of the murder, and even more importantly, during the murder. Again, I explained this, I just want to show it. This is that footage of the nighttime. We see, if you recall, up in that top right-hand corner, we see the victim's truck, Jonathan Willette's truck. We also see right next to it, Devier's work van. This is the night of August 6th. This is the next morning of August 7th. There's that same work van, Devier's work van, in the same position. Nighttime, daytime, nighttime, daytime. Never changing. Physics also ruled Devier out. A lot of discussion about how he jumped a back wall, he took the road that's one house over that, not the road, but the little dirt path, right, to get all the way across town. 7.5 hours? No. That's not common sense. I also think it's important to highlight Devier and the defendant's relationship, Devyn's relationship. Devyn is a master manipulator, and that is shown through the evidence. This is a woman in her late 30s that decided to begin a sexual relationship with her 19-year-old stepson, who had just lost his virginity. I'm not going to get up here and say that the 19-year-old teenage boy, this wasn't his dream to be with Devyn Michaels, who was an older, more sexually experienced woman. But what I am going to say is that the defendant is the one running the show here. This was her fantasy, and he went along with it. For a while, though. Because remember, he tried to move away to California on multiple occasions, and somehow she was able to spin her web and bring him back. The most glaring portion being when she uses a supposed pregnancy against Devier to bring him back to Las Vegas. When she threatened him, I will have this baby and tell everyone whose baby it is if you don't move back to Las Vegas. So what does young Devyn do? He moves back to Las Vegas. He doesn't want a kid at his young age, and even complicate his relationship with his family that doesn't know about their relationship or their sexual engagements. There's also messages that show that Devyn was in charge of this relationship. He tried to get out multiple times. So now that we've talked about this could not be Devyn, let's talk about who's on trial today. Devyn Michaels, the defendant, and how there is overwhelming evidence that she committed first-degree murder. I'm going to go over a roadmap of all the different evidence that you heard in the past 2 weeks and sum it up as much as I can. We'll start with Yoko and Yoshida's testimony, Devyn's inconsistent statements, so her own words, the scene, the DNA, the burlap, which we heard about today again, CDR mapping, video surveillance, the phone contents, and we'll also talk about the custody case and those witnesses we heard yesterday. I think it's very important to start with the timeline because, as Mr. Giordani said, this one's a wild ride and we have to buckle up. So let me start with the timeline here. The timeline starts August 6th of 2023. Devyn, John, the girls, they're all shopping for the girls' first day of school. At 8 p.m., Devyn arrives at the murder house in her vehicle, and Yoko confirms this. At 8:42 p.m., Devyn, the defendant, and John drive to Devyn's home. At 9:40 p.m., Devyn and John drive back toward the murder home. 10:04 p.m., Devyn and John they get to Chevron. They're there for a few minutes, as we saw, and then return back to the Paladura neighborhood at 10:12 p.m. And that's even confirmed by Yoko saying that she saw Devyn and John, and that's when John began to prepare a meal for himself. At 11 p.m., a person places something in the Nissan Armada, Devyn's Nissan Armada, moves the Armada in front of the murder house. And what's notable about that, and I think it's important to highlight, is it went from being in front of the camera to being out of the camera, but more importantly, closer to the house, right in front of the driveway, and nose to nose with Jonathan's truck, which we see was in the same position the next day based on the surveillance, as well as the testimony from the officers in this case. We then turn to August 7th, 2023. At 1 a.m., Yoko runs into Devyn for about 15 minutes or so. At 2:04 a.m., Devyn leaves the murder home in her Nissan Armada. At 2:39, she's at that CVS drive-thru that we saw the surveillance video for. And then at 8:40 a.m., there is that 911 call from Jonathan's mother when she discovers her son dead. We can then safely say on this timeline that the murder that Devyn committed occurred between 10:12 p.m. and 2:04 a.m. So knowing this time frame, we're able to look at the corroborating evidence. Let's start with Yoshida's testimony. The day before the murder on August 6th, he sees Devyn at the murder house. And more importantly, he also saw her vehicle at Paladura. We heard from Yoko. Again, around 8 p.m., Devyn arrives at Paladura in her Nissan Armada. Devyn and John then leave in John's truck. Around 10 p.m., Devyn and John return to Paladura. Yoko sees them. After seeing them, she goes upstairs. At 1 a.m., she goes back downstairs. She runs into Devyn, and what did she describe to you? Devyn looks surprised. Why? Importantly, Yoko also says that the light was on in John's room. Of course, you also heard that the way the bed was situated, you would have to walk into the room, down, and go around to actually see the bed. But regardless, she sees that the light is on in the room. Devyn tells her that John started drinking and he went to bed. Yoko told you that she didn't hear anything from John's room. The light was on. Didn't really think anything of it. And that she and Devyn talked and washed dishes for about 15 minutes. Because that's when Devyn told her that Jonathan, the next morning, was going to meet her with the girls, and they were going to go ahead and go enroll the girls at school and take them to school. She confirmed to you that there were only 4 people at the home. Yoko, Yoshida, Devyn, and the victim, Jonathan. At 1:15, she goes upstairs. She goes to sleep after having that conversation with Devyn. Around 2 a.m., she wakes to the dogs barking in the backyard. And if you'll remember, that was abnormal. The dogs, when John was asleep, or at night in general, were not in the backyard. So why were they in the backyard barking? She also heard a thud. She then goes back to sleep. At 8 a.m., she goes downstairs, sees John's truck is outside, which is a little weird because Devyn had told her that the plan was for him to already be gone by that time in the morning to go enroll the girls. So her antennas were up a little bit. She calls him, calls John, he doesn't pick up. Prepares her coffee, goes back upstairs. She called him again, no answer. So now her senses are heightened even more. So she goes back downstairs. She looks around John's room, couldn't see him, because again, the bed is sort of around that corner, as you saw in the photos. She then goes upstairs again. After going upstairs, again, feeling even more heightened concern, she goes back downstairs. And it's at this point she goes deeper into John's lower room, a makeshift bedroom. She sees the doggy door is down, and the dogs are still outside, abnormal. She saw inside the garage door, inside garage door was half open, the one leading into the garage, abnormal. The big garage door was open as well, as you all saw in the photos. It had an opening there, abnormal. So then she investigates more. She goes to his bed, and she sees John wrapped in a blanket. She opens the blanket, and she saw feet. She then goes around to the other side of the bed and sees the amount of blood that's on the other side. Goes upstairs, tells Yoshida, they call 911. Devyn also made several inconsistent statements. The truth is the truth, it shouldn't change. What were those inconsistent statements? The first one, Jonathan's engagement ring. If you recall in interview 1, Devyn tells the officers, we threw his engagement ring in the trash last night. Okay. Interview 2, threw away John's engagement ring. We kind of made a joke of it, 2 points, threw it in the trash type thing. So it should be in the trash, right? We saw pictures of the trash, of multiple trashes in the Paladura address. Not just one, but multiple. 1, 2, 3, 4, 5. None of them containing a ring that were searched by officers. Ladies and gentlemen, there was no ring that was thrown in the trash. Inconsistency 2. her marriage to Devyn. We learned from interview number 2 that this was a marriage of convenience, not intimacy, which we know is not true based on other evidence in the case. Interview number 3. Her marriage to Devyn is just on paper. Rings aren't significant. Me and Dev haven't been intimate in years. That's not true. Inconsistency 3. The gun safe. In interview number 1, Devyn tells officers, "We took the guns last night, but we didn't bring ammunition because there's no safe at my home for them." Ladies and gentlemen, we saw pictures of a safe. There was a gun safe in the home. There's a close-up of it there. And there's guns and ammunition. Gun safe in the home. No safe. Inconsistency 4, Jonathan's wallet. In interview number 2, she tells officers, John lost his wallet yesterday. He leaves stuff around a lot. Minimizing. Then we have interview number 3, which is after the search warrant of Porcupine Rim, where they start to confront her with the fact that there's Jonathan's items in there, more specifically his wallet. She tells them, at first, nothing of John's is in my house. John's wallet wasn't at his house, so do you know where it is? No, sir. I have all of his old driver's licenses. The license you found is an old one. We know that's not true. I tucked the wallet away in bags. I knew, but how would she know that the wallet was wrapped in bags in her underwear drawer? She wasn't confronted with that. Nothing of John's in my house. But there was. His only set of car keys. His current driver's license. His wallet. And what was found inside her purse? Jonathan Willette's Social Security card. Why would she have those things? But nothing of John's at her house. Again, the license you found is an old one. And if we look here close up, it expired November 7th of 2025. The murder happened August 7th of 2023. This was his active driver's license. His old one? I tucked his wallet away in bags. Remember, ladies and gentlemen, this wasn't one bag. This was 8 bags, and you heard in the interview with Detective Weinoff, that were tied over and over and over and over again. Not just one bag. What was she trying to hide? Also, how would she know? Inconsistency 5. Where was John? In interview 1, she tells officers that John was in the garage, awake, smoking when she left. He was smoking when Yoko came down. But remember, Yoko said Devyn told her John was sleeping off his alcohol. So which one is true? She says she said goodbye to him, pushed out a box under the garage, went out the front door. Then the next interview, last thing she did with John was pop his back. He went to smoke. She talked to Yoko. She finished loading. He told her what to take, and that was it. All inconsistent. And not the same story. Inconsistency 6. John's bloody phone found at Devyn's home. There's a lot of discussion about this during the trial because it's important. And it shows that Devyn committed the murder. And why? First of all, she told us in interview number 3, he told me he cut his hand. Okay? He said he was moving a table and one of the parts fell and took a chunk of his hand. She offers this to police. I didn't see it, but I do know he mentioned bleeding on his hand. Very descriptive. Then interview number 3. He must have been smoking and set his phone down. Again, no notifications are found on John's phone, as if someone manipulated it. Because as we know, John was called and texted multiple times, especially when people were trying to find him. Why would he have no notifications on his home screen? That's because the phone wasn't left by John. You know that his blood was on the phone. And we know that it arrived after the murder based on those CDRs. Based on that raw data, we know when John's phone made it to Devyn's residence. And that's when she took it there because, as you know, it traveled with her after she committed the murder back to her home. This is also an important one. She tells detectives that it was dark in the room and she couldn't see when she committed the murder. In interview 4, we finally get her confession. She hit him. And that's when we get the details. But she tells us that she couldn't really see what she grabbed off the fireplace because it was dark, but she could see him breathing. She tells the detectives, because they're a little confused by that statement, because she can't describe the object in her very hand, but she's able to see Jonathan breathing. She tells him, well, your eyes can adjust. And remember, Yoko said the light was on in John's room when she came downstairs. It wasn't off. It's also important to note that he was wearing boxers. He had his boxer briefs on, she tells the police. And we know that's not true. The boxers were found at the foot, next to the side of the bed, as shown right here. She also can't really account for the time after seeing Yoko at 1 a.m. And this one's really important. In interview number 4, she initially tells detectives, well, I wasn't there for an hour after Yoko came down. That's not true. But then she's confronted that no, there is evidence that you were in fact there until 2:04 in the morning. So detectives trying to solve this case for the family is asking, what were you doing? What were you doing in that time frame? She remembers every detail before. She remembers every detail after. You heard the interview. But she doesn't remember this time frame. Why? Because she did it. She was decapitating Jonathan. I can't remember. I remember talking to Yoko, getting my stuff, leaving, going to the pharmacy, and going home. But she doesn't remember the time frame that she was decapitating Jonathan. Why? She's told this has got to be eating you up. And this is why videos are so important. This is her response.
This has got to be eating you up. This has got to be eating you up.
She's nodding.
This has got to be eating you up.
This is eating her up.
This has got to be eating you up.
Ladies and gentlemen, she admitted to the murder. She said in her interview, when she confessed, that she took that object, the stick, the wooden stick, and bashed Jonathan in the head. That is the murder. But there was a head missing, and that was important to the detectives to give closure to the family. So what about the decapitation?
Well, you have to have something for the outer report, that's where it's being murdered. That you were in the house. That's it. That's the only time you don't remember.
I didn't know I was there that long.
It doesn't matter if you know.
It doesn't say I don't remember being there that long. I didn't know I left.
Okay, so is it possible you did it, you don't remember?
Yes, sir, it is very possible.
Okay.
Yes, sir. It's very possible. The scene does not lie. Defendant can lie, but the scene can't. So what's the hard evidence as well, in addition to her statements that are inconsistent, other than the confession? As we know, John was found on his bed, and there was blanketing. And we also noticed that there were 2 blood spots specifically on that sheet that he was wrapped in. One on one side and one on the other, as you can see in that right-hand photo. She rolled him to the edge of the bed to complete the decapitation after she had realized she murdered him by hitting him, as evidenced by the 2 blood spots that we see there. In that last interview as well, there was a drawing, there was a diagram, there was a sort of a back and forth a little bit with the defense talking about that the detective was the one drawing, but I will leave it up to you to sort of see how that was going down. Devyn drew that line there, and the detective told her multiple times, correct me if I'm wrong, is this where you were, where the X is? Yes, that's where I was. She drew him in the exact position she left him in. There's some truth. The DNA can't lie. We heard that Jonathan's cell phone was found at Devyn's house during that search warrant of the Porcupine Run residence. And we heard from CSA Nicole Merriam, who testified twice, that she swabbed that blood spot right there on the phone, and the testing revealed presumptive positive for blood. It also revealed Jonathan's blood. It's also important to note that Jonathan's blood was found in the driveway of the residence. We have that marker A, which you can see there, the blood spots with the cone. And we also have marker B, which was that Jonathan's bed frame, where they saw those droplets of blood. All Jonathan's blood. It also is interesting where these blood spots are, because they're in the driveway in the same exact place Devyn would have walked to go back to her vehicle to drive home, as we know occurred at 2:04 in the morning. Devyn's DNA is on that knot of the plastic bag containing the wallet and John's only car keys. They also tested inside and outside of the wallet, including all the pocket openings. So the inside of the wallet also contained Devyn's DNA. This wasn't Jonathan dropping it in a bag. Why would Devyn's DNA be inside the wallet? Devyn and John's DNA are on his Social Security card swab. Not shocking that Jonathan's DNA is on his Social Security swab, or Social Security card, I should say. But remember, this is Devyn's bag. You see her wearing it in the surveillance video with the chevron. She also described it to police during one of her interviews. And what's found inside is that Social Security card belonging to Jonathan Millett. And not only is it found, but it's found with the defendant's DNA on it. She handled it. She wanted to enroll the girls at school. and knew that she needed documentation because the father of the children was dead. We also heard from the coroner, Dr. Yagi. The cause of death, homicidal violence. The manner of death, homicide. The internal exam, and this is important, decapitation occurred post-mortem. Jonathan was decapitated by the defendant after she bashed him with the stick and killed him, based on the science. No one's disputing that, not even Dr. Sims today. This is also important. No bleeding injuries on John's hands were found. None. She did discuss slippage, which she explained what that was, where, after death, the skin tends to shed a bit in different areas. But again, no bleeding injuries on John's hands. Then we had testimony from Dr. Burns, who passed around those cool exhibits. Cass, I should say. And she explained that there were 2 implements used to decapitate the victim. As you can see in the picture there, this is her annotated version showing that there were 2 implements that were in fact used. A hand-powered serrated or non-serrated knife was the first. Then a mechanically powered saw, because it's very difficult to cut through human bone. Not only did Dr. Yagi and Dr. Sims agree today, but also Dr. Burns told you that the impacts that she saw on the neck were consistent with post-mortem dismemberment. Jonathan's head was decapitated after he was murdered. There's a lot of discussion during trial about whether it's possible for a woman to do this. I think it's important to note, as Dr. Burns highlighted, a mechanical saw is made for anyone. Women can do anything, especially ones that have a clear motive. Moving on to the burlap. Where was Devyn's vehicle during all of this? Her Nissan Armada shows she's at Paladura during the time of the murder. We have at 11:05 p.m., there's that short activation that we saw on the burlap, which I'll go ahead and play for you. And it is not very long. It's at 11:05 p.m. on that August 6th, 2023, which is corroborated by the video surveillance where we see her vehicle moving up right in front of the driveway of Paladura, nose to nose with Jonathan. Then we have 2:04 a.m. This is when Devyn's Nissan Armada leaves. And we saw that in the burla. She goes from the Paladura address, she goes to CVS, then she returns home to the Porcupine Rim address. I won't play this all for you, you'll have this back in evidence. You've seen it during the trial. We also have that call detail record mapping. Where was everyone's phones during all of this? More importantly, where was Devyn's phone during this? And we had Detective Good testify that the defendant's phone was at the murder scene when the murder was occurring. And what's also interesting to note, which you kind of have to get close to see, but there's sort of this blue dot that is now traveling with Devyn's red device all the way back. And this was at 2:04 in the morning. So that's how we know that the victim's phone was taken by Devyn back to her home, because we have that Google geofence highlighted by that blue dot there of Jonathan's phone, showing when it actually got to Porcupine Rim, and that's when Devyn got it. We also heard phone content evidence, which demonstrates Devyn's intent in this case. I worry as much as you probably won't believe. I miss us. I'm glad you appreciate what we once had. We will have it all again, Jonathan says. I want our family back. We've got to do as great as we can for the girls to have a good life. The walls were closing in. We have the video surveillance that was played for you in depth during trial. And there's some important notes from that. We saw how much video surveillance was canvassed in that Calendar neighborhood. There was a point where the detective even said he couldn't pinpoint the address that I needed him to because of all these contacts here. Then we have that next door residence to the murder house, that 2696 Talladega Drive. Again, next door. And this is that video I talked about earlier where we do see the Nissan activated and we see it move in front of the driveway of the murder home, 2698 Talladega. We also see in this vantage point of the video when Devyn and the victim returned home from that trip from Chevron. When they were coming from Porcupine Rim, stopped at the Chevron, got some items, then came back, and we actually saw those shadows of two figures, which would be Devyn and Jonathan, getting out of his truck to go inside of the Talladega residence. This camera gives us that as well. And again, 11:05 p.m., we get that activation, and we see that the Nissan Armada is moved up closer to the residence. Why would she want to move it closer to the residence? She's concealing her crime. Then at 2:04 a.m., we also get from this residence that the Nissan Armada leaves, putting sort of a bookend on the timing of the murder. We then have the video surveillance from the Chevron. We've also called it the Terrible Herbs. And in there, I talked a little bit about this. We have that they're there at 10:10. That's Jonathan's truck pulled by a trailer. They then leave at 10:11 p.m. And we know that Yoko, as well as the video surveillance from the Talladega neighborhood, they're arriving into that neighborhood around 10:12 p.m., all corroborating, giving us our time frame. We have the video from the CVS pharmacy, the drive-thru, 2:28 a.m. on August 7th of 2023. This is after the murder, where she's at CVS. Again, giving us a time frame. There's no one in that vehicle but Devyn. You can see with your eyes. We then have the 6621 Gray Juniper surveillance video camera from Devyn's neighborhood. This is that one that was fixed where you could see the only entrance and exit of the Porcupine Rim neighborhood, and it was constantly running. We were able to see different things from that. Remember, it was 3 minutes slow to real time, but accurate. At 8:57 p.m., we have John's truck entering the neighborhood. And this is on August 6th. Then at 9:29 p.m., John's truck leaving the neighborhood. further corroborating the timeline. Then importantly, at 2:39 a.m. on August 7th, after the murder, we see Devyn's Armada and Devyn returning back to her residence. At no point was Devyn or Devier's work truck or that sedan seen entering or exiting. Very important. We don't see his work truck or any of his vehicles leaving until 7:31 a.m. on August 7th. So now let's talk about Devyn's motive and intent, which is very important.
Okay, are y'all hanging in there? Oh gosh. I'm like, oh gosh, let's not. Okay, I typically don't like to break up our statements or anything like that because I be, trying to get us through it so we can stay on task. But God, this is like she don't have no excitement in her voice. She not changing it. She not doing anything extra. Like I need her to do something. I need her to do something for me, like something. I don't know. Hit the thing. Tell the jury to wake up. Do something. I know the jury got to be sitting up there like for fucks. They got to be saying FFS. Ugh. Yeah, I got to make sure my crew's still woke. Like, good grief. At least when he gets up there, he gonna be, he gonna be around there. Like, or talk fast like the judge. I don't know, but we need something. Dang. Raise your voice. Get me excited. Say, Devyn knew. What was she at the CVS for? Raise your voice. Have some kind of inflection. Something. Do something. Dang. You talk about good. And she look like she young. Like she don't look like she like. It's just so the same dry tone. I'm like, oh gosh. She been talking for the last 56 minutes. Good grief. 56 minutes. We almost at an hour. So yeah, I'm only cutting in because I know I'm like, dang, I'm gonna fall asleep. I done had my good chicken salad. I done played on my phone as much as I could play on my phone doing shorts and stuff. And I'm about to go to sleep. So I know the jury got to be sitting up there like, watch. Watch. The judge gonna be looking over there like, do anybody need to stand up and stretch? Oh my. Shut the up. Showing us this same old stuff. Oh my goodness. I don't even want to. I honestly I want to see the defense. I'm lost on her. Like I tuned her out. She sound like a Charlie Brown. Womp 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 womp. You would say Monica Simatilli closes argument was 8 hours. I can deal with that. It was some excitement. I want somebody to object. I want her to say something that she ain't supposed to say. Do something. Do something. Oh gosh. You say this was going. I don't think they're gonna come back with a verdict today. The judge got line dancing at the MGM. She does not have time to be doing no court after no 5. Like she gotta get to the MGM for her line dancing. So, with that being said, considering that these closings are taking hours upon hours, we won't find nothing out till Monday. This judge is not staying late. She don't even start working till 12. She only started at 9 today because it was a chance that they was gonna be done. All right, I'm putting this back in. Darn.
We heard from individuals that knew about the child custody case during this trial. And they told you that Jonathan had been given full primary physical custody of the two girls, Tamaya and Jamea. And this happened on October 27th of 2022. So at the time of the murder, Jonathan technically still had full physical custody of the girls. He had something he could hold over Devyn's head. The walls were closing in on her. We also heard from Elizabeth Lemons Woods, who also had worked on the child custody case and sort of the placement of the girls after Devyn was arrested. She meets with Devyn on August 17th of 2023. She wants to tell the defendant, hey, heads up, I just want to notify you, the girls are being placed somewhere else because you're not there, and their father is no longer around. And what Elizabeth Lemons Woods testified to is that defendant then started giving her more information, more than the scope of what the original conversation was supposed to be about. And what I think is notable is that Elizabeth says that throughout the conversation, Devyn appeared that she was trying to cry. Why would you try to cry? Devyn said during this same conversation, she had to do it. She had to do it. Now, ladies and gentlemen, it's very important, and you're in fact instructed on this, to use your everyday common sense and judgment as reasonable men and women. Do not check your life experience and what you know to be true at the door. Bring that with you when you deliberate. The evidence in this case is overwhelming. It's hard, and Mr. Giordani hit the nail on the head when he said, buckle up, this is a wild ride. This is unfathomable. But this is what happened. We are confident as the state that having all of this evidence in front of you, that you are going to go back to that jury room and you are going to check guilty of first-degree murder with the use of a deadly weapon, because the defendant committed first-degree murder under both theories: premeditation, deliberation, and also felony murder. Thank you.
All right, ladies and gentlemen, we need a moment to set up the technology for the defense's closing argument. We're going to take a brief recess. During this recess, you must not discuss or communicate with anyone, including fellow jurors, in any way regarding this case or its merits, either by voice, phone, email, text, internet, or other means of communication or social media. You must not read, watch, listen to news, or read accounts or commentary about the case. You must not do any research, such as consulting dictionaries, using the internet, or using reference materials. You must not make any investigation, test the theory of the case, recreate any aspect of the case, or any other way investigate or write about the case on your own. You must inform or trust anything regarding this case of fines paid to you. Ladies and gentlemen, it's 2 o'clock. We'll be in recess till 2:15. All rise for the jury.
To 2:15. Yes, we need a moment. If you say so to the juror in the back, they probably like, I would tell you. Okay, well, we got to 2:15. Good. I mean, so I guess my question to you guys would be, I know she don't like the cameras on, so they ain't about to do nothing. Get your head out the way. So I guess my question to y'all would be is, what do y'all think the jurors got out of that? Did they get anything out of that? I don't know. It's after lunch. We in Vegas. Viva Las Vegas. Viva Las Vegas. I like Vegas. They don't like me. I did. Oh, wait a minute, Cynthia. Hey, Cynthia, I see I just timed you out. Oh, I was on my phone. Gee whiz. Okay. Okay, let me bring. How long did I time you out for? What's 86? What's that? What is that? How many seconds is that? Gee whiz. I done deleted messages and all types of stuff. Wait a minute, y'all. Dang. Okay, I'm bringing her back. I'll just make you a moderator for the day. I'm sorry, Cynthia. I didn't know I was on my phone. Oh gosh, this phone is driving me crazy when I do stuff. Cynthia, if you can hear me, you should be able to come back. I made you a moderator, so you green. You should be blue or something. Just I don't know how to bring you back no other kind of way, but I'll bring you back as a mod for right now. Oh gosh, what a mess. Yeah, yeah, and I don't know how to do it. Yeah, I don't know, and I don't know how to do it to take them out. I didn't figure it out from when I did. I've timed somebody else out. I can't remember who I timed out before, but I timed somebody else out, and I just made him a mod. So she should be able to chat as a mod. If you hear me, Cynthia, you should be able to chat as a mod, boo. It was just an accident on my phone. I don't know. Yeah, I was in the chat and I had wrote that chat, and if I didn't know any better, yeah, Rachel Rachel told me, because other than that, I didn't even know. I'm telling you, I gotta do better. Sorry, but that's okay. You can come back. You can come back as a mod. At least I think I did make you as. I think I made it a mod. I'll make sure. Yeah, and I know because we all chatting and we all doing our little thing, and I don't want anybody to feel that way. Oh gosh, it's how I deleted messages and all type of stuff. I wasn't trying to delete no messages. Yeah, yeah, they gotta have better ways for me to do this. Well, I'm gonna have to stay off my phone. Yeah, so yeah, and we couldn't figure out how to bring you back, drunky, that day. Until I don't know, I timed somebody else out, drunky. Besides you being timed out, did somebody else and couldn't get them back. I gotta make sure y'all stay woke. Y'all stay on y'all P's and Q's. Cynthia back woke now. She like I can't chat, but she should be able to chat now. At least that's what happened the last time. It brought the person, when I made them a moderator, it brought them back. Like lemon squeezy. So Cynthia, if you're out there, I need you to put a 1 in the chat. I want to make sure you have a wrench and that you're able to chat with us for today up under a mod thing, because I accidentally, what's the luck of the draw? Barb sent out 60 memberships yesterday, y'all, trying to hit Cynthia. She could not hit Cynthia. But I be damned if I'm on my phone and she chat at the right time and I block her from the chat. What is the luck of the draw? What is the luck of the draw for something like that? And she probably like, what the hell? What did I do? All I said was, this jury is asleep. What can we say? Live, learn, and laugh. Laugh, live, and learn. learn, live, and laugh. One of the two. Okay. So we got a couple more minutes in regards to our break. Um, we don't have any TiVo time, unfortunately. What do you guys think so far? She should be okay, I think. I think, Lynn. I made her a mod, so I don't think mods can be blocked. I went back in here and kind of, I think, I don't know. I don't know. I caught myself trying to make, let me see. Yeah, I made her a mod. I don't think mods go into time out. I don't know. I thought it was another way you could do it too. But we'll see. Maybe she don't notice. No, she would notice because she would be listening. She'll probably come back. I'm sure she'll come back. Yeah, she'll come back. She'll either be listening or she'll hear me. Or one of the two. So I guess I am going to put a poll up just so I can kind of see and feel out where everybody's at. Oh, let's see. I'm yarning. They done made me tired. So I'm gonna put a poll up. So y'all have to let me know what y'all think in regards to where we're at. Now we only didn't heard the prosecution's closing arguments. I don't know what you want to take from that, but I don't know. Some of y'all still may be confused. And confused is a good thing, right? When we on the defense end of this end of the table, because confusement means that there's some reasonable doubt. There is some reason that you are not completely sold on what the prosecution is trying to sell you. No matter how fast the judge talks and no matter how slow the attorney does her closing statements. And I hope she is not doing a rebuttal, because I'm sure they're going to have a rebuttal. I'm assuming that they both have an hour. They must both have an hour in regards to it. Well, let's keep our fingers crossed. Let's keep our fingers crossed in regards to it may be an hour for each person and that she does not do the closing. Let me see. Wait a minute. Wait a minute. I need to give me 1 second. I need to update something really quick. Hold on, I did something and I ain't do it right. Oh Lord. Oh Lord, oh Lord, oh Lord, oh Lord, oh Lord.
All rise for the jury. Please be seated. Your Honor, the jury is all present and accounted for.
We are going to go back on the record and see 377239 State Development versus Devyn Michaels. Make the record reflect that Ms. Michaels is present with her attorneys, deputy district attorneys on behalf of the state. Do both parties speak in the true presence of our jury?
Yes, sir.
Yes, Your Honor.
Okay, Mr. Justice, are you prepared for your closing argument?
Yes, Your Honor. Thank you.
Whenever you're ready.
Thank you. This case is entitled The State of Nevada versus Devyn. Proof beyond a reasonable doubt is the highest standard in the American justice system. It shows an adoption of a belief that we took from the old common law from England, that it's better to let 10 guilty men go free than to wrongfully convict an innocent person. I would also submit to you that it shows a belief and an understanding from the Founding Fathers that very few people have the resources, the opportunity, or the ability to prove their innocence. You've seen that through the course of this trial. You have officers come in, collect evidence, and officers are people. I'm not going to stand before you and say this officer's a bad person. We talked about it through jury selection. But officers make mistakes. People are subject to biases, to confirmation bias, where they reach a conclusion first and then kind of work backwards. And I would submit to you that that is what happened in this case. And our Founding Fathers understood that. And that's why they placed the burden upon the state, and the state alone, to prove its case, each and every element of its case, beyond a reasonable doubt. I'd like to talk a few minutes about the jury instructions. We had a few technical difficulties, but you all have the same packet. I'd like to discuss just a few of these instructions. I'm not going to tell you which boxes to check. You're smart. You paid attention, very close attention throughout the entirety of this trial. You are the sole judges of the facts. You alone will decide what will happen to Devyn Michaels. Instruction number 3 talks about murder with use of a deadly weapon, and that's what the state wants you to convict her of, first degree with use. But the pleading document is telling. Instruction 3, it states, murder with use of a deadly weapon did willfully and lawfully, feloniously, with malice aforethought, kill Jonathan Blair, a human being, with use of a deadly weapon, to wit, a wooden stick, and or other unknown object, by striking the said Jonathan Willett with said wooden stick, and or other unknown object, and or through other unknown means. And then it lays out the mental state. It has to be deliberate, premeditated, or, of all things, committed during the perpetration or attempted perpetration of a robbery. The following instructions in this packet lay out, after you've assumed that Devyn has killed somebody, her mental states. Instructions 6 through 16 talk about all the different mental states required. That's after you've determined that this person did the killing. There's even a number of instructions concerning robbery. It's instructions 17 through 20. You see, in the state of Nevada, we have what's called this felony murder rule. It's a shortcut. It's maybe basically getting to the shortest distance between 2 points to convict her of first-degree murder. There are, however, other instructions that I would like to spend a little more time on. And again, you are the sole judges of facts. You will review these instructions. But unlike us, who had this case for some time, this case is new to you. You were introduced to this case when we all met and began talking at the beginning of last week. There is an instruction concerning expert testimony, instruction 33. Please look at that. There is a common sense instruction. And I'm going to flip to that. It's kind of telling. Both parties generally point to this idea of common sense. Again, shows the wisdom. Instruction number 34. Although you are to consider only the evidence in the case in reaching a verdict, you must bring to the consideration of the evidence your everyday common sense and judgment as reasonable men and women. Thus, you are not limited solely to what you see and hear as the witnesses testify. You may draw reasonable inferences from the evidence which you feel are justified in light of common experience, keeping in mind that such inferences should not be based on speculation or guess. A verdict may never be influenced by sympathy, prejudice, or public opinion. Your decision should be the product of sincere judgment and sound discretion in accordance with these rules of law. As I go through my comments, and trust me, I'm going to leave things out. It's inherent in the process. Please use your common sense. You've taken good notes and you've paid attention. Please review the exhibits and don't take my word or that of the state of Nevada. Reach your own conclusions. Review the evidence. There is an instruction that I think is of paramount importance in this case, and it's instruction 32. It concerns the credibility or the believability of a witness should be determined by his manner upon the stand, his relationships to the parties, his fears, motives, interests, or feelings, his opportunity to observe the matter to which he testified, the reasonableness of his statements, and the strength or weaknesses of his recollections. If you believe that a witness has lied about any material fact in the case, you may disregard the entire testimony of that witness or any portion of his testimony which is not proved by other evidence. I read this instruction to you with Devyn in mind. You know, we started this case talking about motivations. Motivations dictate actions. Devyn is not on trial. You know, this case is not going to be, well, did we prove our case against Devyn better than they proved their case against Devyn? Devyn is the only person that's on trial. We have gone through the evidence in good faith, and I'm going to discuss that a little bit with you today in my summation, that there is evidence to believe that Devyn committed this crime. But you don't have to believe that to acquit my client. But I would submit to you that you should take that into consideration. The ultimate determination that you will make is the sole judgment of the facts, whether the state has proven this case beyond a reasonable doubt. Through the course of this case, and as you know, when we talked about it, we wouldn't have to ask a single question, present a single line of testimony. If state fails to prove their case, she's entitled to a verdict of not guilty. But as this evidence has unfolded, I would urge you to see that perhaps the detectives in this case, the Henderson Police Department, were basically trying to choose the shortest distance between 2 points. I mean, hey, we knew, and we all know, and we're not making issue that she was with him on the night in question. It's easy to reach a judgment like they did. She's guilty. But you, as jurors, must consider all of the evidence. Because unlike when you read in the paper, so-and-so's caught, oh, and you think, yeah, he's guilty, she's guilty, you determine whether a person is guilty, not the police and not the state of Nevada. I would urge you to read the reasonable doubt instruction. A defendant is presumed innocent until the contrary is proved. This presumption places upon the state the burden of proving beyond a reasonable doubt every element of the crime charged and that the defendant is the person who committed the offense. And again, this is why we have addressed what the evidence reasonably shows concerning Devyn. A reasonable doubt is one based on reason. It is not mere possible doubt, but is such a doubt as would govern or control a person in the more weighty affairs of life. And what more weighty affair of life do you have than to sit on this jury on this type of charge? If the minds of the jurors, after the entire comparison and consideration of all the evidence, are in such a condition that they say they feel an abiding conviction of the truth of the charge, there is not a reasonable doubt. Doubt to be reasonable must be actual, not mere possibility or speculation. If you have a reasonable doubt as to the guilt of the defendant, she is entitled to a verdict, not guilty. Since this is a charge of murder, I'd like to begin my comments, and I won't be long. I mean, we've been here a long time, but this is important. Let's begin at the autopsy. We had Dr. Sims. He was the lead coroner here in Clark County for 19 and a half years. You heard his testimony. It wasn't much of a cross because he didn't say much to be disagreed with. We did, however, hear from Dr. Yagi. Do you recall the question that was posed to her? Would you agree with me that a decapitation is difficult to effectuate? Remember her answer? I don't know, I've never done one. We heard from Dr. Sims that yes, it would be difficult. It takes a lot. It's involved. Dr. Yagi missed the tattoos. It was in the report. We had Oriental John. That kind of goes to the weight that you should give her testimony and the thoroughness of her examination of the body. The state's relying upon Dr. Yagi's statement, her testimony that there was no injury on the hand. You got to consider the source. Dr. Sims testified that the cause of death cannot be determined without evidence of injury, and he was talking about standard practices. Obviously, these are very suspicious circumstances. In fact, if John was murdered, it's very reasonable to assume, common sense would dictate, that the person that killed him decapitated him. And through the course of this evidence, they have not shown a scintilla of evidence that she was involved with the decapitation. She didn't do it. Determination of homicidal violence cannot be used when in large part that fatty liver or drugs and alcohol are present. He was talking basically about the industry standards, what experts in this field collectively agreed upon. And we saw a variation in this case from Dr. Yagi. In this case, we did have a combination of all three. You heard the testimony about 20 times the level of THC, alcohol in the body. 0.02 was the alcohol in the blood, but Dr. Sims testified that that, in conjunction with this high level of THC, would cause a person to be intoxicated. That's important in this case because you will hear testimony concerning her concern, Devyn's concern, about not letting him drive. As you recall, we went through all those texts beginning back in 2018 concerning Yoko's concern. And again, I don't want to speak ill of the dead, and it was no showing of disrespect towards her, but it was an ongoing concern that she had. She didn't want her son driving drunk, and that concern was shared by Devyn. She had his key. She took the key to the house. That's not evidence that she committed a murder. This is extremely important, and there's been a great deal of issue made concerning this video evidence. As you recall, through the course of Devyn's testimony, I read it to you at the beginning of the trial and read it to him, where basically we had a detective, it was the 12th of September, telling him, you're under the radar. We're here to clear you. I mean, when you look at the radar, when you look at this net that was cast, it has so many holes in it. The state would have you believe that both homes were under 24-hour surveillance is just not true. The evidence of Detective Lippisch and the other detectives showed that. The state expects you to accept representations made by Detective Lippisch regarding the true time of the videos from this residence, and I want to start there. This concerns the state's timeline, which I would tell you flies in the face of common sense, but it's important to take into account how this evidence was gathered. You recall the list of times or the videos that were shown? He supposedly didn't, it was on a neighbor's cell phone. We saw no logs. We saw no indication of the veracity or the accuracy of those times. The state's basing this idea that she's pulling up in front of the Talavera residence and is somehow moving her car at 11:04 to avoid detection. You have to take this detective at his word. And again, I'm not necessarily saying he's lying, but he did a sloppy job of collecting that evidence. And this is the video evidence that I'm referring to. Remember, there was no embedded data here. We don't have time. He would have you believe that the vehicle is moved at 11:04. We don't know what time this is occurring. We do know that the vehicle perhaps was moved from the Burla, but we don't know the sequence of events. As you recall, and you will have the evidence, there was various blue lines showing triangles, and we heard that through the positioning of the GPS, you have movement, even if a vehicle is in one place. We don't have specific times, and we really don't know the order of how things occurred. We would urge you to believe and to consider that common sense would dictate that this was when Devyn left the residence at 2:04. There's going to be a close-up here. You'll have a computer screen. Zoom in on it. Here you see the interior of the vehicle. You see Devyn getting in. You see a bag on the passenger seat. And she leaves. Please pay close attention. And again, not that I'm trying to tell you to do it. We've had this case for much longer time than you have. Look at the video evidence from 6505 Taylor Creek. Detective Lippisch testified several times that he could only speak to items that he canvassed for, but he was happy to testify concerning other detectives who went unnamed that collected this evidence. It's clear from the testimony of a forensic examiner, O'Brien, whose credentials and whose testimony went unchallenged that we presented to you today. He testified that one of the three videos was compiled from a series of screenshots, which the Ring camera is set to capture by default in the absence of video activity. Where are the other screenshots? They only gave us 3. I'm not going to stand here and point the finger and say that this was done in bad faith. It was done out of sloppiness. Why weren't subpoenas issued? Why don't we get the complete record? This woman is on trial for murder. We heard nothing concerning them going to the third-party providers, Ring, Google, other parties. No, they're relying upon the cooperation of neighbors. who are living their own lives and who very well may be indifferent to the gravity of this situation. Didn't give us the full picture, and that was the video that had constant, I mean, you got a good scene into or a good view of the residence. It's incomplete. We just have these three. And again, this is at the new residence where it's been referred to. Porcupine here, we've got the truck. You know, there's been an argument made that Devyn had to have been in the home the whole time. Based on what? Because the entrance to the neighborhood with the continuous camera doesn't show a vehicle. There's other ways to leave that residence. There's a walkway next to one house away. There's over the fence. This is something that's been discarded by the state, but again, I would submit to you that it goes to what Devyn is thinking. It goes to her innocence. She starts trying to contact Jonathan on the morning of the 7th, starting about 4 a.m. She'd left him. She'd left him at the residence. The plan was that they were going to take the girls to school that morning, and we have evidence, and you've heard uncontradicted evidence that that's what she did. The message she leaves him is concerning the girls' school supplies. She's letting him know that their daughter was sick, because we know that she's at that pharmacy, and it's a 24-hour pharmacy at 2:28 a.m. That's what went on. She hadn't killed him and decapitated him. She was worried about getting her daughters to school that morning. She sends messages of concern when he doesn't respond. The state claims, and again, this is where common sense comes into question, the state claims that Devyn was answering Jonathan's phone from the house the morning of 8/7/2023. You heard the argument concerning the notifications. We did hear from Detective Skinner that they didn't put it on airplane mode. Those notifications wouldn't have shown up. That evidence, like so many other pieces of evidence, were mishandled. But the state's going to have you believe that she purposely took the phone from Paladera to Porcupine Rim and leave it out on the driveway, and at the same time be calling it and answering it and leaving it on the driveway. That flies in the face of common sense. She took it and left it there, and then is answering it and calling it to provide some sort of an alibi. She's lucky that in this very slipshod investigation that she has as much evidence that she does to present to you that she didn't commit this crime. Crime scene, the footprints. There are footprints in the backyard. And we have, and I'll show you the photos, we marked them and had them admitted. We have this, the Henderson Police Department documenting these footprints, but then trying to basically throw shade on that, saying, well, they could have been there for some time. They weren't important. When you look at the photo, you can see that they're fresh. They wanted to argue that they're male or female. They didn't do any follow-up. There was no footprint comparisons to anybody's shoes in this case, much less Devier's. You recall Yoko's testimony, there were 4 dogs in the backyard. If that footprint had been there for very long, common sense would dictate that the dogs would have walked through it. They would have been sullied. They weren't. They were fresh. Again, they were not analyzed or tested. And there it is. And Detective Ozawa just kind of discounted that and said, well, we don't know how long they were there, but apparently no one really looked at Yoko's testimony and Yoko's statements. 4 dogs were out there for most of the night. This was a big point of contention. And again, these aren't red herrings. These go right to the very heart of the case. There was no blood cast off in the bedroom. In spite of evidence, uncontroverted evidence, that a mechanical powered saw was being used to decapitate Jonathan. You recall Coroner Yagi went so far as to try and compare a beheading by a mechanical tool there at a crime scene, and Dr. Sims took issue with this. She tried to compare that. These crime scene analysts tried to compare that to the dismemberment of a body under controlled conditions by specialized tools in the morgue. Bodies that have been refrigerated, but nonetheless, she testified that they still wear protective goggles and aprons to protect themselves from this cast-off. Luminol, we heard no testimony whatsoever that luminol was used by the crime scene analysts. That would show indications of blood or attempts to wipe it up. Nothing. What's clear, and it was kind of laborious at the beginning of this trial, was Yoko's testimony, because her testimony was so crucial to the timing of this case. There were some difficulties with the interpreter. However, I'd submit to you, she speaks pretty good English. It was important to memorialize what she told officers the morning of in the 40-minute conversation, as well as what she testified to the grand jury. She testified that she saw Devyn at 1 a.m. and Devyn didn't have any blood on her. If you follow the state's timeline, it's sometime around then, and it's unclear. She's involved in this murder and decapitation. She stated that no gloves were worn by Devyn when she met her at 1 a.m. And you recall the testimony concerning the dishes and the alcohol bottles. And there were some issues concerning Jonathan's level of drinking. 15 minutes. She testified that the light was on. That brings to question the veracity and the reliability of the statements through her multiple interviews that Devyn made to the detectives. There was no blood visible on Devyn's shirt at the CVS drive-thru pharmacy. And thank God that she stopped there. Because again, we have real time. We have real evidence that shows that she didn't commit this crime and not some detective's opinion. There's another issue concerning this, the mixture of ammonia, bleach, the stench. Remember that? We heard that the first responders, that they said that the smell got worse the longer they were there. If we're to believe the state's timeline, this is smoking for 9 hours. That flies in the face of common sense. Ammonia evaporates quickly, and again, your common experiences. The state never, and one of you posed a question to Dr. Sims. Again, it's the state and the state alone that bears this burden. Where was the expert to talk about that? That was important. This case was out of the ordinary. It's clearly gruesome, but because it's gruesome doesn't make that woman guilty. It isn't evidence that she committed this crime. Here we are, 2:27 in the 24-hour pharmacy, and you'll have this. Look at her. She's sipping her water. Apparently this is after she's murdered a man and decapitated him. She's reaching out of the vehicle. No marks, no blood, nothing. And Sims testified that this would have been messy. So she's just decapitated, she's murdered and decapitated Jonathan, and she's making sure that she picks up her daughter's medications on her way home. There was a very good question that was asked concerning, was there any stops? There wasn't. Her vehicle didn't go to any isolated areas, to any trash bins. There's been times when I've gone through moves and I've gone behind the bonds and dumped trash out in their dumpsters. There's no evidence of that because it didn't happen. The state will have you believe that there's this bucket of blood that's the reciprocal of all this blood that's squirting out when she's sawing his head off. What did she do with that? Yes, she did. The car didn't go anywhere. She went home. There's no rags. There's nothing in that vehicle. We do know that they recovered, and this is based in part of the video that we saw from the terrible herbs. Again, I don't want to point fingers, but her life is on the line. They didn't do their job. There was no direction of what to get and when to get it. We heard from Detective Lippisch that he got that video evidencing her clothes around the 11th of August. That warrant was served on the 7th, and we didn't hear much about what they picked up on the 15th. They made a big deal about the shoes, the swoosh, but we showed you evidence in the photographs, and it's in evidence of the black shoes with the white soles. I mean, she gets arrested on the 15th. Game over. It's done. According to Yoko, and this is important, and I read the statement to her because it was so dispositive. She said Jonathan's room was a mess. And there's this kind of a feigning of not understanding, and I said, ma'am, these are your own words. And I read her own words to her. During her initial interview, she stated that there were 2 chairs flipped upside down. That's evidence of a struggle. But then we don't see that on the body cam. What happened? We don't have that in any diagrams of the crime scene. But when she spoke to police and thank goodness it was recorded, she talked about 2 chairs being flipped upside down. And obviously her memory would have been far better at that time than it would be now. But again, there were some questions by the state. You were traumatized, things were terrible. I'm sure it was. But the veracity of the statements and the accuracy of the statements shine through. She was trying to help law enforcement and give them clues concerning who committed this murder. There's no reference made in Devyn's statements about chairs, about a struggle. Jonathan was killed after she left. What's kind of weird is that there were 2 belts tied together on the ground near the bed. There's been no explanation by the state, and we can't give you one, but something's going on in here. Crime scene GPS. Devyn's car is trackable. We know that she didn't stop. She was there that night, and that's why she was charged. Her phone is trackable clearly. No deviation is made to some remote location. She went to the pharmacy and went home. There's no anomalous stops, and this was brought up by you. She gets the medication and gets home because her girls have school early the next morning. The timing, and this is obviously where timing is very, very important. We do know when they leave the terrible herbs. You see 22:11. We know that when they got home, they spoke to Yoko. We don't know how long they spoke, but do you recall Yoko's testimony? Her words were, it was a very good day. She'd known for months that they were getting together. They were trying to unite the family. And you know what? No union is perfect. Hey, we all know that. There are ups and downs, but she and Jonathan had a union. The state in their first closing, they're going to get a second one, try and paint her as this devious, manipulative, conniving temptress. But think about that, the flip side, a 19-year-old. When we talk about motive, What drives a person to murder? Is it not passion of a young man? His first love? His first love that's coming to an end when dad's coming in and moving him, the dad that he said was never there for him. He was kind of an archetype, you know, the father that's killed by his son. I mean, it's in, I believe it's Isaiah 38:18. We've got these Greek stories of it, Oedipus. I mean, there's various variations of that, but it's an archetype. Saturn. It's known, and it's as old as the human condition. Fathers are sometimes killed by their sons, and that's why we wanted to underscore, and we spent a great deal of time in our opening statement, because we didn't know where it was going to go with Devyn, but we knew that they'd had a relationship that had been kept clandestine. Devyn covered for Devyn, and Devyn covered for Devyn. This is important. I would submit to you that this is a more accurate and a more reasonable timeline. Yoko was awake. 10:58. There's a 44-second call to Devyn from her phone. You recall, we get the text, and you want to talk about an alibi-type text, putting the girls to sleep. It's at 10:36. I'm going to bed. That has been refuted by facts. He testified here that, well, maybe he woke up at 2. That was the first time. Previously, he had testified before a grand jury that he got home, put the girls to bed, went to sleep, woke up, Devyn was there. That is a lie. Why would he lie? What motivation would he have to lie? He's a fairly smart young man. I mean, he was kind of catatonic here, understandably so, in the witness chair. But again, we need to look at motivations, because motivations, they author actions. At any rate, and we knew the night before that Devyn had been there late with Jonathan. But after we were to believe that he's asleep at 10:36, we've got a 44-second call from Devyn's phone to Devyn. 8 minutes pass. 11:05, we get that 10-second burla in the Nissan Armada. It may have been moved. You're to determine that, because I'll tell you, we really don't know. The evidence is not reliable. Whether it pulled up and stopped, or what we saw there was Devyn leaving, we don't know. States to provide that to you, the timeline. They haven't done that due to this slipping through the cracks in the slipshod investigative work. Now, an hour and 55 minutes pass. Yoko is awake. There's no suspicious noises or activities. And we have a 15-minute timeline. Because you recall, Yoko's into time. She corrected me. She looks at the clock. They talked for 15 minutes. And it was kind of like pulling teeth. She admitted about the dishes and the alcohol. They talked for 15 minutes. We're to believe that, and again, this goes to Devyn's statement and reliability after she's subjected to interview after interview. Yoko says the lights are on. The state would have you believe, apparently, that Jonathan's dead. She struck him in the head and he's dead. Meanwhile, she has this 15-minute communication. Again, no blood, gloves, chemical smell, any of that on Devyn. At 1:15, Yoko goes back upstairs. And you recall yesterday, that was kind of rebutted Lana's testimony. They kept hitting her with that hour and 4 minutes. That's why you don't talk to the police. That's why you have a right to remain silent. One thing that we have learned is don't talk to the cops, especially if you're the target, because they're going to take what you say and they're going to twist it. Yoko was equivocal in her testimony when she testified before us. This time, and she's just testified once before a grand jury, she's equivocal. She was awake the whole time. She looked at YouTube. She went to sleep. It's equivocal. But at 2 a.m., for the first time here, she says she hears the bang. And I think we had the prosecutor bang his hand. She'd never talked about that before. but still, may have happened. 2:04, Devyn's leaving. Maybe it was the door closing. We don't know. That's her testimony. But you have to evaluate her testimony. But again, this is really kind of shedding light on this timeline. She previously testified that she heard dogs at 3 a.m. She brought it up 3 times during her police interview. Apparently she felt it was noteworthy, and she testified to that September 14th before the grand jury. Yeah, the dogs are barking. It's 3 a.m. Someone's put the dogs outside. The facts, taken as a whole, and not this little piece here and this little piece there, show that this murder, and you know, it's silly to say a murder didn't occur. Obviously it did. It happened after Devyn left. The facts, taken as a whole, bear that out. Again, you heard, and it's uncontroverted, Devyn leaves at 2:04. You know, what's of note is that presumably Yoko went to sleep after she went upstairs. Part of her testimony previously is that she was awake during this whole time. Where's the testimony of a mechanically powered saw? It happened. It's more reasonable to believe that that happened after 3 a.m. We don't know when it happened. She didn't do it. The dogs were outside barking. Somebody's in that house. Somebody has killed Jonathan and somebody is cutting his head off. Again, what kind of passion does that take? Not an on-again, off-again relationship that Devyn had with him. It's a person that's enraged, you know? We all watch the TV, the police stories. They talk about stabbings are personal versus a shooting. What's it going to take to cut a head off? And what kind of anger and what kind of resentment is that going to cause to for someone to do that? You know, there's been a great deal of argument made and points attempted to be scored that Devyn did that because she'd do anything to get her kids. It was uncontroverted that regardless of what was going on with the family workers, she had those girls from May 27th on. She had them all summer. And when we talk about motivations, we know that Jonathan was moving in. There was talk of marriage. And you know, they want you to believe that the rings weren't there. Look at this investigation. Look at the photographs of the trash cans. I believe one was Exhibit 68. We have no evidence and nothing to show that they emptied that. And no, why would they take a picture or preserve a ring? They didn't preserve anything else in those trash cans. It's easy for them to come in years later and say, I didn't see a ring, there was no notations, and they'd go through hundreds of crime scenes. When they were there, you know, when Miss Wilson was there, they were looking for weapons. They were looking for evidence of a murder. They weren't looking for rings, and they're asking you to convict her on this shoddy police work and have you believe that Devyn's lying about these rings when there is no indication that they were looking for rings. This is the state's only evidence that she committed this murder and this decapitation. Because you got to put them together. Common sense would dictate whoever did one did the other. The interviews of Devyn Michaels. I'm going to focus on the third interview.
And then, have you guys ever had a sexual relationship?
Yeah, we had.
Okay. But it's not there now?
No, I can't even have sex now.
This is important. This isn't something that Devyn is making up. You have her medical records. The time, 12/5/22, vaginal hysterectomy. She's had surgery. She's not having sex. She's telling the detectives the truth.
I couldn't tell you if he was bleeding from when he was doing the thing. He helped load up the truck, so if he was bleeding, it might be.
Or your
My Armada. Like, he was putting the things in the car, like anything that he had.
there's going to be obvious areas where blood doesn't belong even if you're loading. So I'm just asking you directly, because if we do find any DNA evidence in that vehicle, obviously we want to make sure we asked you if there would be a reason.
No, the only thing I knew he said was his hand that he hit on the table. That's the only time he ever said he was bleeding, and he said it got a pretty good gash.
Okay. But you didn't see that?
No, I did not, so I can't really speak on it. But he was still loading everything up, so I don't think it was really bothering him that much.
This is the inside of the Armada. For the testimony from Ozawa, it appeared the vehicle had just been washed. That's been disproven. The burla shows that that didn't happen. The location coordinates show that that didn't happen. Look at the inside of this vehicle. I know my partner, Mr. Horvath, had asked Detective Spangler, well, was it very clean inside? And I think he made a reference to teenage kids, something along those lines. This isn't well kept. I've seen much worse, but it's not well kept. The important point is we're to believe that there's buckets of blood in here. There's bloody rags. There's a head, a murder weapon, a saw. There's nothing in there. They sealed this vehicle and they took it off. If you're to believe that she murdered and decapitated Jonathan, you're to believe, common sense would dictate that there's going to be some indicia of a crime in here. You're taking buckets of blood because they weren't at that residence. This made reference, and again, nobody understood the significance at the time. Miss Miriam didn't, but there's the table that she talked about. It was a moving day. Injuries do happen. We're to believe, again, Dr. Yagi's, the reliability of her testimony. She said there was no bleeding injury. Well, we've got an injury right there. Whether it's bleeding or not, we don't know. But that's sign of an injury. And remember, this is the same doctor, the same coroner that said John didn't have tattoos on his arms. Big point was made about the telephone. And we're to believe that Devyn is so sophisticated and so cool and so cunning and so informed that she can murder this guy, decapitate him, not leave any evidence, and then drop his phone in her driveway. A more reasonable explanation, it's tired. She's got girls that are going to school in the morning. She's been carrying things, it's late. She obviously brought the phone. Whether it was knowing or not, we don't know. It appeared that it had fallen on the side. She tries to give an explanation. You recall about the cigarette butts? She didn't know the phone was there. That's why she was calling the phone, following up with Jonathan. She knew he wasn't dead because she didn't kill him. Another thing that was a big point of contention, sometimes little things can have very large implications. Remember the issue about the blood on the screen? Papakostas, the DNA expert, testified that she couldn't confirm that it was blood. There was a presumptive test, but the confirmatory test, and some of you are far more knowledgeable than I am, it was not. She couldn't confirm that it was blood. So then the state recalls crime scene analyst Miriam to apparently discredit their DNA expert in reference to the blood. And this is the entity that's charged with proving this case beyond a reasonable doubt. They're calling a crime scene analyst on a presumptive test to discredit the DNA expert who gave testimony, uncontroverted testimony, concerning the lack of a confirmation for this blood. We know that John's DNA is on the phone. I would submit that it is somewhat significant in determining whether the state's proven his case. Devyn's isn't. It was handled. Maybe there weren't epithelial cells left from Devyn. Clearly, Devyn took the phone, knowing or not, and I would submit to you that given the circumstances and the chaos of a move, she didn't know she had the phone. It's not evidence that she killed him. Just like the key, It's not evidence that she killed him or the wallet. She's going to go through all this work to leave this, this crime scene spotless or clean and not leave anything behind, no blood, nothing in her car. Yeah, she's going to drop the phone and then make calls to it. This is what the state is relying upon, this interview. And you recall the tenor of this interview? Please don't just look at one part or another. Listen to the whole thing. The power dynamic. You've got two large men. You've got a woman who they had said, we Mirandized you earlier today. You have to ask yourself what went on. What happened before this interview?
John? This is Jonathan, you last on? Yeah, but he had his boxers on. Okay, he had his boxers on. I don't know, he had his boxers on. His boxers were black boxer briefs. He had boxer briefs on. That's what I'm talking about, the shit's getting real. Keep looking at that. Take another look at this.
This was into the interview, and it was a fairly lengthy interview. She'd had multiple interviews before. We heard in this interview that they had told her previously, that day, about the decapitation. So there's more going on. She knew. It's at 16:01, and it's interesting that the state showed you the exhibit, the one that she supposedly wrote. When you look at the original exhibit, it says handwritten by Devyn Michaels. It wasn't. She drew a line, and that's significant. It was Detective Christopher that wrote that. And again, this is in the crises, in the crucible of a very confrontational interview. She didn't author that. And I'm assuming that Mr. Giordani is going to stand up when I sit down because he gets the last word. He's going to say that somehow, how could she have known that? She hadn't been shown the photos. This gentleman had seen the photos, and he filled in those details. As she's sitting there, having been arrested previous to this interview, and facing the horror of being accused of a crime, a murder, that she didn't commit. Here's the boxers. Why lie? Why lie? When she left, he was wearing those boxer shorts. She was consistent in that. Why choose that hill to die on? She was telling the truth.
Have you had moments in the past where you
Yes.
have been stuff where
Yes.
this happened?
Yes, there's things in my past where I cannot remember. And yes, I have talked to my doctor about it. Yes, they're trying to figure out what's going on with me. Yes.
Okay, you don't have to tell me if you don't want to, but what is wrong with you that you say that
I
you're trying to
don't
get
know.
back from?
They're testing me now. I think yesterday, for whatever reason, my brain tingles and I black out. And I literally have it on documentation from the doctor, and they're trying to figure out what's going on with me.
This interview was on August 15th of 2023. This condition that she's talking about, it's documented 6/7/2023. New patient established her patient she feels like tingling, vibrating in the back of head, comes and goes, denies headache, has dizziness. This isn't some ploy. I mean, she's in this high pressure, confrontational interview, and she's trying to give as truthful information as possible. She's had some problems. This isn't some defense where, oh, she blacked out and didn't know what she did. She didn't commit this crime. She didn't commit this decapitation. She's had some issues that she's been trying to address. And again, she's being truthful to these detectives. It's confirmed.
I think we're done. Absolutely. You're going to that and everything. You can't even have the audacity to give him closure. Shame on you. That's terrible. Get out of here! Oh, so there's there's some anger now, huh?
I told him from the beginning I didn't do it.
How do you feel against him?
No!
She's pushing back. She's been interviewed over and over again. She's telling him, I've told you I haven't done this. What we're dealing with now is a woman that's denying that she committed this murder. You know, it'll be up for you to determine whether she hit him in the head when he was grabbing her leg. She was consistent that he was alive. He was breathing. There's no evidence that she hit him in the head. And again, given this, we know that when people are confronted, they'll try and give something to appease the other party, this power dynamic. She was trying to give. In this interview, you'll read, they threaten. What you do here is going to determine what happens with you and your daughters. She gives a little, but then snaps back and says, I didn't do this. And she's expecting, through all these interviews, for them to pick this up and do their job. But they'd already made their minds up. You heard from Lanai yesterday. In their minds, she was guilty. That's it. And we're dealing with this investigation that you heard from Sean O'Brien, 3%. We're dealing with 3% of the information that was available on those devices. But still, in that 3%, we've been piecing together what really happened. We do know, and it's clear, incomplete Cellebrite reader files. Critical database files are missing from the phones. Now, years later, we're trying to piece together a defense to defend a woman that didn't commit this murder. There's artifacts which would indicate a need for further investigation. And Sean O'Brien testified that generally, as he's been a forensic analyst, he's been involved in law enforcement. There's supposed to be this back and forth. Hey, get us this. You know, as this investigation develops, we need more information. There was no indication that that occurred in this case. She's at the house. She's the low-hanging fruit. She's guilty. The end. All investigation stops. Image of Devyn and Devyn. And again, we would like to have more, but we can show you this image. Now, all the images that are available on a cell phone, I think I probably have 4,000. You know, it's going to be the state's position, well, this is just randomly popping up. Devyn had said that he was asleep, or Devyn had said that he was asleep at this time. He testified under oath. He lied under oath. Look. There's a Discord chat application, 231. This is telling. You know, the state can play 3 phone calls from the girls who are adorable. Those were all after 11 o'clock. We have no proof where Devyn is. But we have 2 indications of 2 artifacts at 2:12 a.m. and 2:31 a.m. that he's up and he is engaged. There's a deliberately deleted file. This is the image, 2:12:38 a.m. This is after there's been 3 calls from the home phone that night to Devyn. 3 of them were the girls. What about the other 8? But of all images, at 2:12:38 a.m., this is being looked at on Devyn's phone. Game box. Again, and this is important, this was not preserved, this was overlooked. There's photos, he was a gamer, they had issues. Gamers are on their game platforms and they talk to other people. We have a Discord file, there's a remnant of that. He's using that at 2:31 a.m. in the morning. He's up. He didn't drive his car over there, and again, I can't tell you for certain if he committed this murder. But he could have easily gotten out of the house, and he's not going to walk. He's going to talk to a fellow gamer. We now know that he's up, and he's lied. He's lied under oath. What does he have to lose? I mean, he was able to avoid the motives through the course of this investigation concerning getting kicked out of his house and losing his wife, who he, based upon all the photos, and we didn't have to go through those, you saw them, he was in love with her. But we do, in this 3% that's available to us, we can show you that he was up. Not one indication, but two. And given the nature of that photograph, the multiple phone calls that were made earlier, and now we have this discord, we have a remnant that he's on an app, it's not too hard to imagine that he went there. Those are the facts. And the timelines, you recall the detectives that for the Henderson Police Department that testified, they set out timelines, but they didn't do a more in-depth analysis. And this is what our analysis, with only 3%, we were able to show he was awake. This was deleted, it's there. I'm not saying that was that night, but that's something that should be taken into account, headed there now. He's there in this area, and you'll have the exhibit. He's next to a remote area. Don't know if he had a job there or not. This is the morning after, 8/7/10/25. You know, when detectives interviewed him, he'd said, hey, I've been drinking. We don't know if he'd been drinking all night. We don't. He's a drinker. He's in a remote area where, and obviously there's been no testimony, there's been no investigation in those wash areas. We know he was over there. We know he was up. We know that he was looking at a picture of him and Devyn. You know, it's, you see on the crime TV shows about motive, means, and opportunity. He had all three. He had the motive. He had the means. He didn't walk there, but he was talking to somebody. Clearly, he had the opportunity given the timeline, but again, I'm not going to stand before you and say he did it. We don't know. She didn't. These were texts that were between him and his father. You have nothing to tell me, WTH or TF. I thought you were my seed. If what I can know, I can't fuck with you. Boy, that's true. Devil shit. It was clear, and he tried to smooth things over through the course of his testimony, but Devyn did not like his dad. He had an affair with his dad's girlfriend. You know, these things don't reflect too good on her, okay? They reflect poorly on Devyn. But Devyn's not here for good moral character. You can despise the choices that she made, but you can't convict her for murder, for a murder that she didn't commit. This is their home. The home that he's being kicked out of. Again, there's the walkway down the side. There's a way to get out the back. There's no cameras that were pulled on Rebecca. We don't know. The police did a slipshod investigation. We can't show you him walking away. They didn't collect the evidence, but the motive would point to Devyn. This gun, there was an issue made concerning that. That gun was looked at the afternoon of, I'm sorry, that's another gun. There's guns in his possession. We don't know if that person was shot or not. Jonathan was. The swords, again, we're not trying to throw these things out, aha, but this just shows a conscious indifference on the part of law enforcement in collecting evidence that could exculpate her. Their minds were made up. She was guilty. There's so much evidence here that you can go through and look. Again, thank you for your patience. Thank you for your attentiveness. You know, this is the last chance that we'll have to speak. There's going to be things that I have overlooked, things that I missed. Don't hold them against her. Hold it against me. You remember the movie 12 Angry Men? The jury went through and exonerated that young man. I'm going to ask you to do that, to look at the facts. You may not be comfortable with a verdict of not guilty. She's done some bad things. She didn't commit this murder. She didn't kill him and cut his head off, because those two things are combined. Common sense would dictate that they are. She's not guilty of this charge. Thank you.
Second, are you prepared to give your rebuttal argument? Ladies and gentlemen, because the state has the burden of proof, they are allowed to open and close the closing argument.
Let's talk about reality now. I want to commend my colleagues over here who represented Ms. Michaels first, because they've done an exceptional job. And Ms. Michaels is entitled to a fair trial, like we talked about in jury selection. They've done a good job of coming through and poking as many holes as they can in the evidence, and I commend them on that. But make absolutely no mistake, that woman is guilty as sin. That family deserves justice. Those girls deserve justice. Do not take this lightly just because a real polished defense attorney gets up here and spins a yarn for you. Do not take this lightly. Those people deserve justice. If I were to tell you that a defendant confessed to a crime, described how she did it, everything she said matches the crime scene, except for the part where she minimizes or potentially blacks out the aftermath, you would say, well, that's pretty damn obvious. And some of you were probably sitting there when we played that confession the other day, yesterday maybe it was, or the day before, and go, why didn't you guys play this 2 weeks ago? We could have kind of sped this process up. Maybe you're thinking that. Because we have to show you that the cops did their job and she is overwhelmingly guilty. We wouldn't be doing justice to that family right there if we just played that confession and walked. And we didn't. We put 2 weeks worth of evidence up here to show you Devyn sure didn't do it, and she did. There is no reasonable doubt in this case whatsoever. And I want to address kind of an elephant in the room. You know, Mr. Draskovich just got up here at the very end and he told you those two things, common sense dictates those two things go together. And I kind of agree with that, right? The person who killed him, probably decapitated. But make no mistake, she's not on trial for decapitation. She's on trial for murder. She told you she did the murder. Now, she minimized it. She told the detectives that she hit him over the head and he was still breathing. Of course she did. But she admitted to the act that caused his death. Are we really, as reasonable men and women, going to believe this was a fatty liver or a marijuana overdose? Are you kidding me? That guy was murdered, and then his head was chopped off. And here's the elephant in the room. I don't care if you for some reason believe Devyn somehow snuck out of his home like a ninja, crossed town, and cleaned up the job. I don't care. She's not charged with decapitation. Look at the pleading document. She's charged with killing John. That is it. That is your job. Did she kill him or not? And the answer is absolutely yes. I need to show you a couple instructions because they're important. Bear with me. I know you're probably tired, because we all are. But this is too important to just gloss over. This is the beyond reasonable doubt instruction. Mr. Draskovich addressed it. I want to tie this into another instruction. Doubt to be reasonable must be actual, not mere possibility or speculation. Instruction 31, direct versus circumstantial evidence. The top part is really important. I'm going to address that in a minute, but this one down here that's underlined is also important. You must not speculate to be true any insinuations suggested by a question asked a witness. A question is not evidence and may be considered only as it supplies meaning to the answer. So everything Mr. Draskovich said through the course of this trial was a question, right? It was a question. That ain't evidence. So you tell me what piece of evidence, what single piece of evidence suggests Devyn did this? Not one. Not a one. And when you start accusing an innocent guy of murder, Devyn, you got to think about this for a second. That young man was taken advantage of. And like Miss Griffith said, it's not like he wasn't enjoying it and liking it and into it. No doubt. Mr. Draskovich in his opening statements suggested that Miss Michaels has a history in the adult film industry. Did you ever hear me ask that? No. Did you ever hear me or her mention that? No. Because Mr. Draskovich is right. She's not on trial for having a past. Doesn't matter. The only reason that does matter is because it dictates that relationship with Devyn a little bit, colors it. She is an experienced woman, much older than Devyn. He's a young knucklehead, and I would submit to you that when you heard from him, no disrespect, but that guy's not a criminal mastermind. He's not somebody who snuck out the back of the house, evaded all cameras, left his phone behind because he was thinking ahead to what he was going to do, somehow made it all the way across town, even though he didn't have his phone to contact anyone. There's no Uber notifications or pickups or anything suggested. There's no calls, no texts, nothing after 11 o'clock. So who did he contact and when? There's no evidence that Devyn was involved in this. None. There's actually evidence to clearly refute it. You heard those voicemails, and we can agree those little girls they're precious, they're adorable. Those voicemails eliminate this alternative suspect, which I will refer to as a scapegoat, because that's what's happening to him. He's being scapegoated, and it's not right. Those little girls said on those voicemails what Devyn was doing. He was knocked out, probably passed out, if we're being honest. And you didn't hear any other voicemails afterwards. You saw more calls from the landline. If Devyn had got up and snuck out, because we know the one little girl is awake and panicking and like scared, and where's mommy? She should have been home a long time ago. Where's mommy? Wouldn't there be another voicemail where they're calling going, Devyn left us? Like, really, Mom, where are you? Of course there would. Of course there would be. And there isn't. That's because Devyn was home. And you know that because he texted and he said, I'm going to sleep. He's no criminal mastermind. His phone is at home. There's no evidence his vehicle's left. There's zero evidence that Devyn is involved in any way. Zero. And so Mr. Draskovich brought up a good point with the instruction that Miss Michaels is the only one on trial. That's instruction number 36. I want you to think about this for a second before you let a guilty person walk. Okay? Think about this. Imagine if I were to stand in front of a bunch of jurors and try to prove Devyn's guilt. Imagine that. That's not what we're doing here. That's not what this is about. But imagine that for a second. Can you think of a single piece of evidence I could, with a straight face, present to a jury and say Devyn did this? A single piece? Other than speculation and really good questions by a really polished defense attorney? There is not a piece of evidence. I would be laughed out of the courtroom if I tried to prosecute Devyn for this homicide. Because he didn't do it. He had no reason to do it. Go look at the text messages between him and his dad. We included a bunch of them. Did he worship the guy? No. Did he hate him? Who cares? He didn't kill him. There's no evidence to suggest it. He says throughout the text messages to his dad, hey, what's up? You'll see it. There's like years of it. There's 2 years of it. And then those texts that Mr. Draskovich just showed you with the devil shit, I would submit that's a reasonable thing when you learn that your son is having sex with your ex or is married to her. That's reasonable. But then, they left out a text that's right after that, where dad is reaching out to Devyn like months later saying, hey. This wasn't some big, rift, homicidal relationship between dad and son. Now, when you're thinking about motive like that, you've got to think about this defendant. She told you in that interview with Detective Lynott and Christopher why she did it. She said it clear as day. I didn't think he was really going to move in. The walls were closing in on her, and she made a real horrible decision. A real bad decision. She said that she very specifically got up. He was down on the bed getting a massage. Got up because she was a little pissed off, I think were her words. Maybe don't quote me on that. Something like that. Walked across the room, grabbed this heavy blunt object, bashed him over the head, and he went limp. That's a confession to homicide. Okay. On top of that, she told a DFS worker, when you're thinking about motive, in the context of losing her children and homicide, specifically, which she brought up, she said she had to do it. She had to do it because that's how she felt. And I'm going to answer, or try to answer, a couple of unanswered questions for you. We all get this evidence before trial. You know, we're all obviously somewhat prepared. I'm not like tooting our horns, but we're prepared. We know the evidence when we come into this case. There were clearly going to be unanswered questions in this case, right? There's a missing head. There's a missing murder weapon. There's missing implements, no doubt. But think big picture, forest from the trees. Think about reality, right? Criminals ditch murder weapons all the time. Criminals try to cover up what they've done all the time. Just because she ditched the head and therefore the doctors can't confidently say what injury did it, does that mean she gets a reward? Like, does she get to benefit from the actions she took to cover up? Of course not. Does that mean we can't convict her of murder? Of course not. And that is why I asked Dr. Sims those questions earlier. I didn't challenge his credentials. Like, I've dealt with him on cases before, as you probably noticed, and he's a smart enough guy. He's very educated, but he's not disputing that a blunt blow could kill a man, right? He is saying exactly what Dr. Yagi said, the decapitation is post-mortem. And you know what he didn't say, which should be very notable for you? That there were other bleeding injuries on the body, including the hand, right? Because there weren't. He didn't say that because there weren't any bleeding injuries to the body except for up here. And that's how we know she did it. That droplet of blood, you can go back and forth about the DNA analyst not confirming it's blood. Well, DNA analysts actually look at DNA profiles. And DNA is in every single cell of your body, including your blood. And so no, a DNA analyst is not going to come in here and say, John's blood was on the phone. She's going to say, John's DNA was on the phone because she's a DNA analyst. That's what that is. John's droplet of blood being on that phone convicts the defendant even without her confession. Set those, two confessions actually, because she told the DFS worker she had to do it. But set those aside for a minute. There are no bleeding injuries on his body, except for up here. The phone left at 2:04 with a droplet of blood on it. That means the murder happened before 2:04. It had to. Nothing else would make sense. Nothing else would make sense. She, the defendant, traveled with that phone. Okay. So then you got this other big glaring unanswered question. How could someone be capable of doing that? That question, I can't answer. Okay? This is reality. It happened. I would submit to you that there is a chance that what she said about that hour and 4 minutes is true. Maybe our psychology major could talk about this. But I would submit to you that she may have been genuinely telling those detectives the truth that she didn't remember chopping John's head off. Because this is beyond anyone's wildest dreams, violent beyond all imagination. And there is a good chance she blocked it out. That doesn't mean that she walks out the door because she says she can't remember. It convicts her. There is no way she didn't do this. The evidence is absolutely overwhelming. And I need to address a few points because I just can't leave them unsaid, so please bear with me. Mr. Draskevich called into question Devier's testimony, and I want to bring this back for a minute. I think Devier is pretty well excluded, but he walked into this courtroom, and I want you to remember that I asked him the question, did we bring you back? We didn't have to arrest you or anything. He came back willingly. He flew here, right? He brought his girlfriend, a little more age appropriate now. I guess he's learned his lesson, but walked in the courtroom willingly with that big old camera and all you strange faces to him. And he sat on this witness stand. He swore an oath to tell the truth. He got up here. He testified. He looked at his wife. He looked at all of you. He looked at me. He looked at the marshal with the gun and the badge. And he testified to the best of his ability. Now, I am not and will not endorse his character. I don't know the guy. I've met him a couple times because he's a witness. But you got to see him tell you the most intimate details of his life. And I asked him straight up for a reason, and I did this early in the trial because we just learned he's the defense. Put him up early, and I asked him, did you kill your dad? And he said no. Now, I know he's a stranger to you, and you can't just accept his word, but you've got to consider the circumstances and what it took for him to do that, to put himself in front of the world, and testify about all this. Willingly. He came back. We flew him back from California, and he came in here and he answered questions from a very skilled defense attorney for however long he was on the stand. Think back to that. Did that kid strike you as someone who snuck out of his home, plotted this big old thing, and killed his dad and then somehow covered it up? Or did he strike you as someone who got himself in a bad spot, his words, tried to fill some shoes he had no business filling, and made a series of mistakes in relationships? His testimony from the stand has to be considered in context. And it's all corroborated. Now, I would submit to you that if he came up here and he said every word consistent, precise with everything he said over the last 2 years, then you might rightfully be a little suspicious. Like, oh, what is he studying for this? He had some inconsistencies. We don't shy away from that. He's not perfect. I asked him a question. I think the word I used was tumultuous, and he's like, what does that mean, sir? I don't know what that means. He's not a criminal mastermind. No disrespect to Devier, but he's not a criminal mastermind. He's a scapegoat. Don't let that happen. Need to address our pleading document. Mr. Draskevich brought this up, so I just have to address it. So you heard in the beyond a reasonable doubt instruction, it says the state must prove every element of the offense beyond a reasonable doubt. This is a legal pleading in Nevada. We are permitted to use unknown means and manner of death and unknown deadly weapon. This goes back to what I was saying earlier and what Ms. Griffith said about the deadly weapon instruction, where it says the state is not required to recover the deadly weapon used and present it in trial. There's a reason for that, because like I said earlier, this happens all the time. We don't reward criminals who are smart enough to get rid of the weapon. In addition, we don't reward criminals who are smart enough to get rid of the head after they've crushed it. Okay. That's why we are legally permitted to do this. Unknown object, unknown cause. Only question is it murder? Is it not? Did she do it? That's it. And it's absolutely first-degree murder. Mr. Draskovich brought up the robbery instruction, or the robbery pleading felony murder stuff. So I need to address that as well. Instruction 18. So, when you first heard the charge read by the clerk, I'm sure you're like, what do you mean by robbery? This doesn't really, it doesn't really make sense. This doesn't really seem like a robbery, but bear with me a second. Taking property by means of force is a crime. The motive and reason behind it is separate. So yes, she took his wallet, his keys, and his social. We're not saying she took that for its value, right? It's not like the traditional robbery. The evidence says she took that for a reason, and it all comes down to one thing, and that's the girls. She took the Social Security card because she knew she had John out of the way, and she was going to make some changes and live the life that she wanted to live. So it is, by law, a robbery what she did. She killed someone, took their property, but we're not saying that she took the property to take the property. She took it because she wanted the girls and she wanted John out of her life. Instruction 29 is the motive instruction, or we call it the motive instruction. Motive is not an element of the offense or the crime charged. We're not ever required to prove motive, but you're permitted to use it to color kind of the facts of the case and determine whether there was a motive that could lead you to convicting on the crime. I've addressed motive a little bit. I just want to kind of wrap up that idea with this. John and Yoko and his side, they had a very different understanding of the moving situation than the defendant. Okay. She didn't want it to happen. Go look at the text, especially the ones that Miss Griffith showed in her closing. John is continually saying, I miss my girls, I want you girls back. We need to put this family back together for the sake of the girls. And go look at the defendant's responses. Those ones that Miss Griffith showed. One was, I'm glad you appreciate what we had or how it was back then. And then that last text she put up where John is saying we need to do this, we need to have them under the same roof. She doesn't respond. So go look at those when you're thinking about motive and tie it in with the last statement, the confession. There is no doubt that both sides have been aware of this potential for a move. What I would suggest to you the evidence says is that she didn't want John moving in, and John did. John wanted that. And it didn't become real until that night. And you know that because of the conversations with Devyn. He's still there. He's literally still living there. So if he was going to be moving out for John to move in, why isn't he moved out already? That's because no one expected John to try to make the move that night. And that's when the walls started closing in on her. She's thinking in her head, I want my girls back. I want my girls. That's it. This guy can't move into my house. That's not what I want. She wanted him out of the way. And she did what most reasonable people wouldn't do. She made the decision to take a blunt object and bash him in the head and kill him. I want to address a few things with the defense expert. Mr. Draskovic showed a couple of cameras and a couple of texts or activity, 212 and 230. One's a Discord, one's a photograph. Remember what their own expert said. That wasn't active activity. That could have been background activity. It could have been active. He can't say that. So whether Devier woke up and activated his phone at 212 or 230, well, that just tells you he's still at home. And if it's just background activity, then who cares? Either way, it's not good for the defendant because it rules out Devier. It's either with his phone or it's a nothing burger. Mr. Draskovic talked about the boxer shorts being off, and I already mentioned this. The defendant may very well have blocked out what she did after she killed him. And whether she took the boxers off or not doesn't really matter. It's probably very likely that he was naked when they were having this massage situation, but the boxers being on scene have no real import in this case. Mr. Draskovic talked about the CVS pickup, and I got to address that. So he said, and he showed you the video, there's no blood on the defendant in that drive-thru. Now, we all watched it together. I don't see any blood from here up from what you can see. But do not forget, that shirt was never recovered. Neither were the shoes. Now, I'm not arguing to you or suggesting that I know what the defendant was wearing when she decapitated him. She could have been naked. She could have put John's shirt on. She could have changed her clothes, a number of things. But what I am telling you is that white shirt, from here up, maybe no blood on it, but it's never recovered. So we don't know if there's actual blood on it. Mr. Draskovic asked you a question, and I need to provide an answer. He said, is that a woman picking up this medication for her girls that's just done this, has the wherewithal to have just done this and go pick up medication? Yes. Yeah. That's reality. You heard the voicemails. The little girl was saying, you were going to get my medication. I'm not saying that the defendant is a bad mother. I will not say that. That ain't right. She took her children's father away. That's a bad thing she did. But did she care about her girls? Obviously. She stopped to get medication? Obviously. That doesn't exonerate her in any possible way. And neither does the post-homicide messages she sent to the victim's phone in the early morning hours. There is two very real explanations for those messages. Number one, you already know the extremes she went to cover up what she did to his head. She took it. That's extreme. She poured chemicals. She took a bunch of stuff from the scene, probably a towel too that was on top of him when she did the chopping. It's not outside the realm of possibility that she sent a text and made it look like she thought he was alive. That's certainly not unreasonable. The other explanation, as I've intimated to and pretty much said directly, is that she doesn't remember the real bad stuff. And legitimately, in her mind, he was still alive after she hit him. Because from then on, she blocked it out. So take those text messages for what they are. They're either she's alibying herself or covering up, or she genuinely doesn't remember the wet work. That's what that is. I have to mention the timing of the big confession, not the one to the DFS person, but the big confession. If this is all, there's no evidence to say this, but according to Mr. Draskovic, this is the defendant covering up for Devier. If that is true, why does she confess after she's arrested? Right? She's already been arrested. Devier's gotten away with it. Why does she confess after? Unless it's what happened. Mr. Draskovich showed a couple of videos, the small movement off screen. Remember the 2696 video? He showed the small movement off screen, and I believe he said, I'm sure it was just misspeaking, but I want to make sure it's clear, that that was the 204 movement. That was not. That, according to the detective, that was the 11 p.m. movement, when it goes off screen. And we know that for a fact because the burla shows that exact movement at 11, or it's 11 or 11:04, I can't remember. The 204 footage on that video is when you can't see the car, it's already out of frame, but you can see the lights turn on and it leaves. And then that is also consistent with the burla, so just needed to clarify that. Want to briefly address the girls. So you didn't hear from them in this trial. You can probably imagine why we wouldn't want to put them through anything more than what they've been through. I would just ask you to, that's my decision. I live with that decision to not call them. But I would submit to you that you heard everything you needed to hear from the girls in those voicemails. Devier was home. Devier was asleep. That's it. Need to briefly address this DNA stuff. So Mr. Draskovich made a point about the swords, the shower earlier in the trial, not an argument, but no blood being in the Nissan Armada and the footprints. And I just want to take this to its logical conclusion. So say we swab the swords and any one of the three's DNA is on it. What question does that answer for you that hasn't already been answered? If Devier's DNA is on it, it's, well, he's handled the swords before. If the defendant's DNA is on the sword, it's, well, she lives in the home, of course her DNA is on the sword. If John's DNA is on the sword, it's, well, yeah, those are his swords and they were just moved from his house in the move, right? That doesn't answer an actual question in the case. DNA being in the shower. The defendant's been to the home many times. Have we found her DNA in the shower? What is that going to change for you? Absolutely nothing. No blood in the Nissan Armada. There is so much evidence of her covering up her acts at the crime scene. It should not be shocking to you that she could have wiped up some blood if there was any in the Nissan Armada. We know from the patterning at the scene, and you look at it for yourself, the blood on the ground, there is something she used to collect that head. There is a very straight, clear line on the border of that blood that suggests that something caught that head. And whatever that was, she took it with her. And when the defense says there's no stops along the way, we agree. But what they can't say, no one can say, is what she did when she got home. And you may remember that many times, different witnesses talked about it being trash day. It is not very hard to walk over 2 homes or 3 homes and dump a bag or basket or whatever it is in a trash can. And, I got to address the investigation. Now, the detectives are all learning this stuff as the investigation goes along. They didn't have the burla and all that stuff when they go to Porcupine Rim on August 7th. Should they, because of they did know there was a head missing, should they have checked every trash can in the neighborhood? Yeah, probably. But they didn't. Okay. That doesn't mean that she didn't dump the head in the trash can. And that doesn't mean that this investigation gets the case thrown out or the defendant acquitted. These detectives actually did a pretty darn good job of follow-up investigation. When they suggested that she was the convenient, shortest distance between two lines, I disagree with that. Because remember, they found all that stuff in her home on August 7th. All that stuff, highly suspicious, blood on the phone. Did they arrest her then? No. Could they have? Yep. They didn't. They went and did mountains of follow-up investigation. All of that confirmed the suspicions. And then she confesses after she's arrested. It's too important to miss anything, so bear with me. I know it's getting late. Almost. Instruction number 35 is important. In arriving at a verdict in this case as to whether the defendant is guilty or not, the subject of penalty or punishment is not to be discussed or considered by you and should in no way influence your verdict. I want you to take that to heart. There's a phrase that's commonly thrown around in this courthouse. It goes, admit what you can't deny, deny what you can't admit. I'll say it again. Admit what you can't deny, deny what you can't admit. I want you to think big picture, forest from the trees, just one more time. When there is a confession and DNA and mountains of phone evidence and video surveillance, what could the defense possibly do? She's covering up. The only thing that these very skilled defense attorneys could say in this case. We, luckily, have a mountain of evidence to disprove that. Admit what you can't deny, deny what you can't admit. They were painted into a corner. I commend them on their job, but what they did is they blamed an innocent person for a homicide he didn't commit. And I don't want you to blame the defendant, Ms. Michaels. I don't want you to judge her based on whatever her past. No one's asking you to do that. I also don't want you to take into account whether she's a good person or a bad person. She seems like she has some good qualities about her. Seems like she's trying to be a good mom. You must not make this decision based on sympathy or a popularity contest. Mr. Draskovich, very likable. We're not here to do a popularity contest. This is real stuff. Okay? Real stuff. Do not think about whether you think she deserves a little leniency or redemption or this is a one-off. She lost it. None of that matters for you. That matters for the judge, Judge Jones, who in her wisdom will sentence the defendant, not you. That is not your calculus. Your job is simple. Did the defendant do it or not? That's it. Please remember your oath to follow the law. It's my understanding the judge is going to let you stay a little bit after to deliberate tonight. I'm sure you might get instruction on that, but please don't take this lightly. This is important to more people than just the defendant. She is guilty beyond a reasonable doubt. Guilty of homicide. Thank you for your time and attention these 2 weeks. We really appreciate it.
A I'm now going to ask the clerk to swear in the officers to take charge of the jury and the alternate jurors.
You do solemnly swear that you will keep this jury together in some private and convenient place, that you will not permit any person to speak to them, nor speak to them yourself, unless it be by order of the court, except to ask them whether they have agreed upon a verdict, and that you will return them into court when they have so agreed, so help you God.
Yes. All right, ladies and gentlemen of the jury, as you know, a criminal jury is composed of 12 members, and there are 14 of you who are here. That is because 2 of you will serve as our alternate jurors. This means you are not discharged from your service as a juror. Your service may still be needed if one of the other jurors is no longer able to participate in deliberations. In this case, our alternate jurors are juror number 13, Ms. Fitzpatrick, and jurors 1. May the record reflect we're outside the presence of our jury. Do you guys have any further matters outside?
I tell you, being the mama, don't stop, won't stop, can't stop, rock it with it, rock it, rock it, rock it, rock it, rock it, rock it. Whew, got that done. Gotta go get the baby. How's back? Hey, thank you for holding it down. Okay. I don't know. Okay, drunkie. Thank you. Thank you, thank you, thank you. We'll let you know what the verdict is. Wait a minute. Let me see. Maybe let me see if they even got a clock on. Let me see. I got a clock, but let me see if they got a clock. I like to go by the clock because that way I could tell. Mm, I don't know how. I don't know. I don't know if I like this. Okay, so check it. Wait a minute. Yeah, I got the start time. So my question to you guys is because Court TV don't have no clock up, and when they don't have no clock, I don't know. Okay, but the camera is still in there. We got to figure this out because Court TV, if they cover, and they usually have a clock. So let me see. Okay, they got a clock up. I see it. Oh, we got two jury watches. Oh, oh, look, we got two of them, y'all. We got the SD, they got the Trey kill case up in here. They've been deliberating for an hour and 58 minutes. And then we got ours that we currently watching that's 15 minutes and 43 seconds. So we got two of them. So we got two. Oh, I wonder, Maddie. I wonder if Maddie probably really watching that one. Maddie probably watch. I don't know. I wonder how he gonna be notified about the verdict. I don't know how. Let me see. Let me see if I can see. Yeah, I was trying to see if there was anything that we can watch in regards to the Trey Hill case. Like they didn't stream it. They didn't. Yeah, they got opening statements up here. Then they got where the mom testified about the night finding her son unresponsive, and I think we seen all of that, if I'm not mistaken. So yeah, boom there. You gotta leave early, Barb. What you got going on tonight, Barb? On this Friday night? Where's the prince? The prince. Yeah, Maddie was out here cheating. Maddie was out here cheating watching that trial. He'll be back. The trial is over, so he'll be back. They always come back, right? They think the grass be greener on the other side. See, back over there, he can't rewind. He can't replay. He can't go back and look at it. So he gotta watch it live. Like if you don't watch it live, all bets is out. Where's the prince? Yeah, he be cheating. Oh, so he's streaming tonight at 8, Barb? Yeah, he be cheating. He a cheater. Yeah. He a good cheater. He'll come back. He'll cheat and then come back and dip in. He like to dip in every night. All right. Okay, Frank. I'll see you tomorrow. Hopefully you can catch us over the weekend. We'll do the little after dark thing on Sunday and take care of that case. And we will, yeah, SD is in they in deliberations. Yeah, we'll do that over the weekend, and then tomorrow we'll have a premiere for. We're gonna do the preliminary hearing for the McDonald's thing. Y'all want me to go over the McDonald's stuff again while we kind of like waiting? Cause we gonna look at her hearing tomorrow for those that want to come and attend. Um, Let me see how long was her hearing today. Oh, oh gosh, I tell you, Detroit is something rough, baby. Um, Let me see how long is this lady's hearing. I hope it wasn't one of these ones where I gotta catch it live and I ain't gonna be able to see it no more because I'm gonna be upset. While I was listening to all that dry stuff going on in this trial today. Hmm. Let me see. I'm trying to get it off of. I know Lauren Crown got a lot of it. Okay, 7 hours ago. Wait a minute. They better make that. They better put this whole thing on there. I'm be upset. What's muted? Y'all can't hear it? I'm not talking about anything. I was playing the conference, the hearing, part of the hearing, the first hearing that she had. The McDonald's girl. I didn't went into the McDonald's trial. I wasn't talking about nothing. I was just listening to him. I was trying to show y'all what we was gonna watch tomorrow. We gonna watch her. Oh, I don't know why y'all can't hear it. Y'all can't hear him? That's interesting. Let me see. Well, let me remove it and try putting it back on there. Because, you know, sometimes it be like tripping. So let me do that. And then I will share. They be doing the most down here. Look at this. Oh, gosh.
Detective Showers, please approach for the swear to. Please raise your right hand. Do you swear that the information being provided is true and accurate to the best of your information, knowledge, and belief, subject to penalties of perjury?
I do.
Put your hand down. With regard to the defendant, Afani Muhammad, please set forth the factual basis for the warrant request.
Yes, Your Honor. 7/10/25, McDonald's employee Afeni Muhammad stabbed McDonald's manager Jennifer Harris multiple times with a kitchen knife at the McDonald's restaurant at 179219 Mile. Harris was not armed at the time and died of her injuries. Prior to the stabbing, Muhammad was sent home by Harris for not performing her work duties and told Harris, "I'll be back." Muhammad was arrested on scene and the knife was recovered. Muhammad admitted that she intended to kill Harris and stated that after she was sent home, she drove to a nearby park, decided to come back and stab Harris with a knife that she had inside of her vehicle. When Muhammad returned to stab Harris, she entered the back entrance with a hooded mask over her face in an attempt to conceal her identity and attempted to flee the scene after the stabbing, but was stopped by an armed customer.
And the requested charges are murder in the first degree, count 2, dangerous weapon carrying with unlawful intent, and there's a habitual second notice offense. Is that correct?
That is correct, Your Honor.
The warrant is being signed and we can proceed to arraignment.
Thank you, Your Honor.
Calling file number 25354, People versus Afani Badu Muhammad. Council appearances for the record, please.
Good afternoon, Your Honor. Sean Haney, public hearing on behalf of the people.
Thank you very much, Jennifer. Please, this honorable court, Matthew McConnell, hearing on behalf of Mrs. Muhammad, who does appear via Zoom.
Your name, please, ma'am?
Afeni Muhammad.
Very good. You're here today for arraignment on the charges of murder in the first degree, premeditated, count 2, carrying a weapon with unlawful intent, and a habitual second notice. Mr. Licata, how does your client wish to proceed?
Thank you very much, Your Honor. At this time, my client is asking the court to enter a not guilty plea. This matter set for a probable cause conference and a preliminary exam. I have advised my client of her rights, as well as the charges against her and the potential penalties. We are ready to proceed on those grounds.
Very good. Ma'am, do you understand the nature of the charges against you to your satisfaction after talking to your attorney?
Yes.
Very good. I will go ahead and enter a not guilty plea on your behalf. Are you requesting a court-appointed attorney?
Yes.
I will appoint an attorney to represent you. We'll set this matter for a probable cause conference on July 23rd, 2025 at 1 p.m. The preliminary examination will be on July 30th, 2025 at 1 p.m. As to bond, Mr. Licata?
Thank you very much, Your Honor. Just briefly, my client is 26 years old, does live in the great city of East Point. Your Honor, my client is a high school graduate. In fact, is actually was taking some online classes for college for a physical therapy degree. Your Honor, there are some disturbing facts in this particular matter, but there are facts that haven't been brought out yet.
Okay, so wait a minute. Okay, did y'all just see her? Right? Y'all seen her picture, right? Wait a minute, y'all. Did y'all see how she looked? This kind of important. We ain't gonna see. Y'all see this? Y'all see how she looked? Oh gosh, let me show y'all this. Wait a minute. I just seen this. This is from the hearing today. What's going on? What happened? What's happening? Oh my gosh. Y'all see her now? It looked like they didn't beat her up or something. Or is it just me? Oh my goodness. I mean, I don't want nobody to be getting beat up and stuff in jail. I don't think, but good grief. Look, her eyes is barely open. Like her eye didn't been beat up. Wow. You think she just puffy eyed? And I don't know. She done got beat up. To me. She look like she done got a whooping on her. I don't like look at this eye right here. That look puffy eyed. That look like it's closed eye. Like, oh gosh. I just want to see what it's like. What you mean? What you mean, Lynn? Like, I'm just trying to figure out what happened. Because although, if somebody, I know she unalived somebody, right? She allegedly unalived somebody. But in the same token, like, I don't want people to be, I want them just to, yeah, that's what I'm thinking, Barbara. No, she didn't like she didn't got in a fight. And she might have gotten in a fight because it looked like she got like attitude issues, right? And they ain't about to be playing that game with her.
Was taking some online classes for college for a physical therapy degree. Your Honor, there are some disturbing facts in this particular matter, but there are facts that haven't been brought out yet, and my client is extremely anxious to have those facts brought to light during the pendency of this case. She was in an extremely abusive relationship that was not only mental but physical, that involved alcohol issues, which is where the habitual second stems from, and her prior record. Your Honor, my client is a helpful person. She's a giving person. She's actually is credited with saving a life because of a 60-year-old who had skin cancer that she may go to the doctor to find out that that's exactly what it was, and that person is doing extremely well right now. I understand the facts that have been laid out today in the warrant, but at this time, Your Honor, we are asking the court to consider a bond in this matter that is appropriate, that my client can meet so that she can meet with her attorneys and prepare her for defense in this matter. Thank you.
Thank you. On behalf of the people?
Yes, thank you, Your Honor. Pursuant to court rule, the court is well within its authority to grant no bond involving any case involving.
Yeah, if we'd have missed this loud oh gosh, y'all. Look at this here. If I don't find this courtroom feed, I'm gonna be peed off. Look at this. We up there in that old boring old mess with that old Devyn today. I knew when I seen this, I should have been in this courtroom. Look at this. Oh, man.
Things got heated in court today. An altercation brings the hearing for Afani Muhammad to a standstill. She's the woman accused of stabbing her McDonald's manager to death. That courtroom is now closed off. Lauren Kostick is following today's proceedings. Lauren, what can you tell us?
Well, Priya, we knew this was going to be a contentious hearing. Before it even started, the judge said there was a fight between a family of the victim, with some of them being escorted out. And then just a little bit ago, we watched as this video of the incident was being shown, a very graphic video. And we are told one of the family members, they went out and they retrieved 2 knives and then attempted to bring them back into the courtroom. And because of all this, like you said, the public is now banned from attending this hearing. Just the media is allowed inside. So let me catch you up. We know that 27-year-old Fini Badu Muhammad appeared for her preliminary examination to determine if there is enough evidence to send her to trial. And that fatal stabbing, it happened back in July at the East Point McDonald's on 9 Mile. Afeni is accused of returning to work and stabbing her manager after being sent home early. And so far during this hearing, we've heard from 4 witnesses. We've also seen body camera video of her arrest for the first time and surveillance video of her walking in the back door wearing a mask. Now, one of those witnesses who testified was the driver credited with stopping this attack and holding Alfini at gunpoint. Take a listen.
Seen a bunch of commotion, a bunch of people running around. At first I thought maybe they was getting robbed or something like that, because I was on the phone, and I seen maybe 2 people fighting. There was one person had a mask on, and it was an employee. And then I seen a knife being produced, and I seen her start stabbing her towards like the neck area.
And again, this hearing, it is still ongoing. We're expecting one more witness to testify. But again, the public is not allowed inside. The family of the victims not allowed inside because of everything that happened. We'll let you know what the judge decides on this, and also if there's any more disturbances over on clickondetroit.com. Reporting live, Lauren Kostick, Local 4.
We know you'll stay on top of this story, Lauren.
Stay on top of it, Lauren, because Take It to Trial wants to know all about it. Oh, they having all types of drama and fights in the courtroom. Oh, yeah, this is my type of party. Oh, yeah, get it popping. Terrible. They have been deliberating for 36 minutes and 24 seconds in the Nikki trial, and then 2 hours and 19 minutes and 31 seconds in the Trey Kill trial. So just so you guys know. You say she was always late for work. Oh, they said that Barbara, they say that it's I'm doing day 1 tomorrow of our preliminary hearing. They got it on. I'm gonna find it. It's on here somewhere with Fox with News Channel 4, because I seen them streaming it earlier, and I didn't go in there because we was in this trial. But shoot. God, they say the family coming in there with knives and stuff. Like they won't get back. They for real. Wow. I don't know why they thought they was gonna get that off. Now that I don't understand how you thought you was gonna bring knives in the courtroom, but I mean, yeah. Yeah, so I'll find what we need and get it together for us tomorrow. I hope. Like, I'm probably gonna be like really not happy if I can't find it. But we shall see. Yeah, because I know at one point in time they didn't think she was competent enough to even stand trial, but they decided that she was. So I don't know why they won't let me get to channel 4, but let me see. Oh. Oh, maybe because they just got finished streaming it. Oh goodness. Yeah, because I seen the people testifying today. Oh man. Oh yeah, I'm gonna be up all night trying to figure this out. Yeah, because I seen oh yeah. Yeah, I better find this. I'm gonna be upset. Yeah, that's the one good thing about what I will say is that in Detroit, they show all their preliminary hearings. That's what I can definitely tell you. Like, that's how we saying that's where Jarvis Butt's case is. That's also where DeAndre Booker's case is. They always do their preliminary hearings, and that's one thing that I kind of like because yeah, I think her TikTok video might be still up where she was complaining in the car before she was going in to work. I just want to know what she gonna try to claim her defense is because y'all know this is not her first stabby incident. This is the second stabby incident. So this wasn't even the first stabby. Oh, okay. I found it. I found the hearing. Good. Okay. I want to hear like an hour and 41 minutes. And they said they got one more witness to testify. Yeah, it's like an hour and 41 minutes. So we'll watch it tomorrow in the morning. Yeah, I found it. And they said they got one more witness to testify. So I'm assuming they'll testify on Monday. Yeah. Yeah, she was in the car. She was sent home and she was back there always making like little TikTok videos and stuff and not working. That's half the problem. Okay. Yeah, she was always doing stuff back there and wasn't doing what she was supposed to be doing. Yes, that I do agree with you. Yeah, I think that Law and Crime showed a lot of them.
25 report, which opines that
Of instances we've seen that these assassination attempts on President Trump or the alleged assassin or the convicted assassin. Of instances we've seen that these assassination.
I want to go back though to this development in the case.
She definitely liked that color
Because the evaluator is not going on, and the people who are they're telling the truth. Defense, you get more information about her.
Isn't funny. She needs to understand that just because she's a mother and got children doesn't mean that she can come in this store, disrespecting people, talking to them like everybody's beneath her. She has no respect. And it isn't funny at all. Like, seriously, man, I got to take care of. And she keeps sending me home early. It's not funny. She's playing games. And then all day, throughout the day, she keeps sending her little racial And then throughout the day, she keeps on like putting negative energy in the air, talking about people, gossiping about people. It's not funny, man. That's gonna have to stop. She's a bully. I'm telling you. She's a bully. She brings a lot of negative energy in there. She always panic when there's a lot going on, and then she try to manipulate that and make it seem like we ain't doing something right, but we are working really hard and doing great. It's just the fact that she panicked, and I caught her a few times making a mistake, and she tried to hurry up and play it off. You know, nobody's perfect. It's God, it happens. You know what I mean? Like, sometimes, like, somebody might get confused. So it gets busy, yeah. But she needs to stop playing like she don't be making mistakes. I be catching her.
And you could even hear her say that.
She ain't playing. She said she be catching her. She be catching her. Yeah. Yeah, that one is really pure. Oh, look like he got sentenced today too. Everybody was getting sentenced today.
And their loved ones. You're both cowards. Neither one of you had the to stand up to each other and do the right thing. I also know that you two are the most naive, stupidest criminals that ever walked this planet. Every time you lie down on that cold-colored bed, every time you wake up to concrete walls and iron bars, every birthday, holiday that you don't get to celebrate, every time you have to ask to use the restroom, every time you step out of line, every time you have a nightmare. Melody is providing for you. She will forever provide those bars that obstruct your view for the rest of your life. And I hope she haunts you forever.
Sentence in this case for murder.
I don't know. I think it's the machete. It's like the machete redrawn plot sentencing. I think this is the one with Dakota, maybe. I think. Oh, I don't know. It's on court. It say it right here. Which one is that? I don't know. Y'all know the crimes be happening. Let me see. This one. This one is the Melody Hoffman's mother. You F with the wrong mama. Ooh. Y'all don't remember this one? Yeah, well, you know, they had multiple people, I think, that were convicted or went on trial for this.
Music loving, slime making, selfie taking, video making, supper cooking, animal loving girl. That will ever happen. And if it does, it's only for her and not you. You've taken so much from me, my family, friends, and even complete strangers that never had the chance to meet her. Melody will live on forever in each and every one of us. She will be remembered for the kind, caring, loving, organized, silly, artistic, music-loving, slime-making, selfie-taking, video-making, supper-cooking, animal-loving girl we all remember. I don't believe for 1 minute that McKinley made you do it, or that you made him do it. I believe that you're both 100% guilty of murdering Melody, our daughter, leaving all of her belongings in the trunk of the car, linking your phone to hers, having her password, her deceased sister's birthday, in your phone, and being seen together on surveillance videos before and after the crime. Let's talk about your selfies for a minute. What are you, in middle school? At the beginning of the night of February 17th, your selfies didn't include any classes. And then, all of a sudden, you had classes. You took more than 200 selfies. 200. With them on. Did you see them as a trophy or a souvenir? I don't. I see them as the evidence that put you away for the rest of your life. By the way, thanks for taking them home with you. You made the job a little easier for everyone seeking justice for Melody. Maybe now you can get your own state-issued, non-working classes. I've been called a helicopter mom a few times now, and I take that as a compliment. Being a loving, caring, concerned, supportive, devoted mother to Melody is an honor. I am proud to say this helicopter mom got my daughter's murderers put behind bars in days, instead of weeks, months, or years. You fucked with the wrong mama. You messed with the wrong family. I'm sorry you never felt loved. Anybody capable of doing the things you did could never fit into a loving, caring, supportive family. I'm sorry you never experienced a family with such strong characteristics. In fact, I don't see any of your relatives here supporting you today. Maybe the issue's you and not the rest of us. I'm relieved to know that there will never be another innocent victim with your name attached to them. If you would have let Melody get to know you, she would have given you the shirt off of her back. Instead, you took it, and so much more. I want you to think about her during every disgusting cold meal you eat. Every time you lie down on that cold-colored bed. Every time you wake up to the concrete walls and iron bars. Every birthday, holiday that you don't get to celebrate. Every time you have to ask to use the restroom. Every time you step out of line. Every time you have a nightmare. Melody is providing for you. She will forever provide those bars that obstruct your view for the rest of your life. And I hope she haunts you forever. Justice will be served to those who deserve it, to its fullest extent here on earth. A much higher power will get the final justice. I have no doubt when your time comes, you will not be allowed in the same place we all know Melody is now, with her sister Ellie, safe and far away from everything evil like you and McKinley. I will fight every day of my life to keep her memory strong and let her live on as long as I can. I know I'm not the only one determined to do this. So, from all of her loved ones, we all wish you the life that you deserve until you take your last breath.
It makes a little difference since the sentence is mandatory, but the state did make mention of me hearing the nothing to do with the evidence heard in another case. The sentence in this case for murder first and murder and kidnapping first is a mandatory sentence of life in prison, which is the sentence the court will be imposing. While the sentence is mandatory, it's also the sentence that is appropriate for these violent, incredibly cruel, and completely senseless acts. Your offense cuts the young life short and deprived Melody Hoffman's family and friends from having her in their lives, which is understandably devastating to them, but also undercuts the safety and feelings of security in the community. A sentence of life in prison with no possibility of parole is the appropriate sentence for these crimes as necessary for the protection of the community. The maximum sentence for the offense of conspiracy to commit a forcible felony is a 10-year indeterminate prison term. While it is largely symbolic in this case, given the sentence of life in prison for the other offenses, the court does find that the maximum sentence of 10 years in prison is the appropriate sentence based on the level of planning involved and the fact that the forcible felony involved a Class A felony. So at this time, the court adjudicates the defendant to be guilty of the offense of murder in the first degree in violation of Iowa Code Sections 707.1 and 707.21b. As a sanction for this offense, the defendant is committed to the custody of the Director of the Iowa Department of Corrections for the rest of his life. The court further adjudicates the defendant to be guilty of the offense of kidnapping in the first degree in violation of Iowa Code Sections 710.1 and 710.2. As a sanction for this offense, the defendant is committed to the custody of the Director of the Iowa Department of Corrections for the rest of his life. As to each of these offenses, the defendant shall not be released on parole unless the governor later commutes the sentence to a term of years. The court further adjudicates the defendant to be guilty of the offense of conspiracy to commit a forcible felony in violation of Iowa Code Sections 706.1 sub B and 706.3 sub 1. As a sanction for this offense, the defendant is committed to the custody of the Director of the Iowa Department of Corrections for an indeterminate term not to exceed 10 years in order to pay a fine in the amount of $1,370. The defendant is given credit for qualifying time previously served on this offense. The term of incarceration after this offense only may be reduced because of good time, work credits, and program credits, and the defendant may be eligible for parole before the sentence is discharged. While largely symbolic, count 1 and count 2 will run consecutive to each other. The reason for the consecutive sentences is that the kidnapping included separate planning and represented an entirely separate cruelty to Melody Kaufman, as she was picked up with no idea what was coming, with all the panic and separate torture associated with being taken, confined, and moved, all of which occurred before the separate act of murdering her. The court finds that because of that, and based on all the facts and circumstances of the two offenses, that they should run consecutive to each other. The sentence in count 3 will run concurrent to counts 1 and 2. Temporary custody is placed with the sheriff and then transferred to the DOC. Pursuant to Iowa Code Section 910.3b, defendant shall pay restitution in the amount of $150,000 to Melody Kaufman's heirs of law. Now, certain defendants are presumed under the law to have the ability to pay what we call category B restitution, but defendants have the right to request a determination of the reasonable ability to pay. Mr. Petrova, is your client intending to file an application for determination of category B restitution?
Yes, Your Honor, we did file one in this case.
I've not had a chance to review that. Has the state had any objection to the court reviewing that application and making the determination based on the and so, sir, what that means is that I'll either grant that request and find that you do not have the ability to pay, which is what I expect will occur. For any reason, I would determine that you did have the ability to pay. I would reset this for hearing so that you have a chance to be heard on that. Defendant shall submit a physical specimen for DNA profiling pursuant to Section 81.2, 901.58A, sub A. Defendant's prior bail provisions are exonerated. Appeal bond is set. In determining the sentence, I consider defendant's age and circumstances, the nature and circumstances of each offense, and the fact that the sentences for murder first and kidnapping first are mandatory under Iowa law. Finding the sentences will offer the defendant the maximum opportunity for rehabilitation and provide for the protection of the community. Now, Mr. Van Patten, you have the right to appeal this case to the Iowa Supreme Court. If you're unable to pay the cost of an appeal, you have the right to apply to the court for appointment of counsel and for furnishing of a transcript of the proceedings, all is provided in Iowa Code Chapter 814. In order to perfect an appeal, you must file a notice of appeal with the clerk of court here in Manhattan within 30 days of today's date. This is a jurisdictional requirement, which means that if you do not file a notice of appeal within 30 days, you would be forever giving up the right to appeal. Likewise, failure to comply with the other provisions of Iowa Code Chapter 814 could preclude you from pursuing your appeal. If you do appeal, you must cause to be served on and delivered to the Iowa Attorney General a copy of the notice of appeal. Is there anything that the state police have missed today? No, Your Honor. The defense?
No, Your Honor.
All right, order adjourned.
So it looks like everybody is still deliberating, just so everybody knows. I don't know how they just for reference, like I'm trying to check and see if anybody else yeah, so Law and Crime still has their thing on. So there hasn't been any jury questions just yet. Let's see. It's just at the 5 now in Vegas, so yeah, I'm just trying to see. It doesn't look like, I don't know if they're gonna stop or not stop. Who knows? I don't know. I'm surprised the judge don't have okay. You say the judge probably wants this ended? Yeah, I believe she probably do too. But I do know she got line dancing tonight at the MGM, and that is very important. So I don't care what you're talking about. But we got other stuff to do. Let's see. Yeah, I was trying to see if I could see the other trials little clock, but I can't even see that. On right now. They don't even have the clocks up. So just so y'all know, they don't even have the clocks up. They got Vinny on right now. He doing his show. He said, look, I'm gonna still do my show. I don't know what y'all got going on, when they gonna have a verdict, but oh, the Alfred plea. So that means that he has did he testify against the other guy, therapist? Mm. Okay, an Alford plea means that the defendant does not admit guilt, but accepts a conviction because they acknowledge the prosecution has enough evidence to likely convict them at trial. Wow. Yikes. Okay, so do we want to watch anything? Is there anything that y'all want me to put on as far as testimony or anything? Because they are still deliberating and don't have any games to play. And this will not be Alicia Keys. No, we gonna do it on Sunday, therapist. No, we're not doing it because I knew we was gonna have a long day in court today. I'm sorry. We're gonna do it on Sunday. We're gonna do it on Sunday. It's gonna be 6 o'clock East Coast time. So you say comfort movie to go with my. Oh, you know what movie I'm gonna go see this weekend? Now You See Me 3. Have y'all seen that movie? Have y'all seen 1 and 2? It depends. It may be after dark on East Coast. It'll be almost dark here. Maybe not. It won't be that dark yet, but it may be getting dark where you at. It's like dusk. Oh yeah, Liam, part 3 is coming out, guys. It come out today. I am going to go see that this weekend. I watched 1 and 2 again over the last couple of days. Like sometimes we watch me, but sometimes I watch it. So I've been watching 1 and 2, and I love. Oh gosh, I can't figure out which one I like better. So what is Now You See Me about? Now You See it is it's a magic movie. Oh, you should watch it, SD. Oh, yeah, it's a magic movie. It kind of reminds me like Ocean's 11 with magic, if you know what that is. You should say courtesy. Well, I love it. Oh gosh, 1 and 2. I can't remember which one I like better though, because I watched 2 last night and I was like, I kind of like 2 a lot. It kind of and so now they're coming out with 3. You say she fast with that? She fast with it, huh? Yeah, yeah. Let's see what they doing over here. Over here in they chat, I gotta look at Law and Crime's chat to see what's going on with the case. Because they'll put stuff over here. Because Court TV don't have their clock up no more. Because they got Vinny on. Vinny doing his show, so they ain't got time for no clock. Not right now. Yeah, still in verdict watch. I wouldn't believe this judge would be there late. Yeah, not at all. And last time when we stayed here this late and we was on this late, it didn't even record the verdict. Because I didn't realize that I can only stream so long on here. It didn't even record my verdict. I had to go back and re-record it. I'm tired. I'm yarning. Y'all see that? I'm tired. Look. Y'all know my chair got a massager. I'll be up in here getting my massage and kick my footrest out and be sleep on y'all. Yeah, it's in like the back part, like the lower back part got a massager. Oh yeah, it got the works, baby. It got the right stuff, baby. And it got like a footstool and it reclined. Like I could probably go to sleep. And I got like a pillow. See, look, you got a pillow. Like this chair is for real. Like I got a neck pillow and nice, and it curves like right around my hips and stuff. And yeah, I can go to sleep, like be sleep in the chair. Y'all wake me up when the verdict come. We'll be here until next week sometime. Yeah, I don't see them coming back with a verdict tonight. I don't. They got a lot of stuff to decipher through. When you think, I think they got a lot of stuff to decipher through. I think they got a lot of stuff to work on. You say see you Monday. I know, right? Yeah, like I think they got a lot of stuff that they got to work through in order to make this verdict happen, and I just don't think it's gonna happen tonight. Like when I really think they're gonna happen, I really kind of have an idea that they're gonna happen, but I just don't see this one happening. I don't. I'm trying to check on the tweet therapist. You better at that stuff than me. We don't see anything from Kathy. Seeing anything? I'm looking, but I don't see nothing. Yeah, I don't see nothing. I don't know if Barb's still here or not. I know she got to leave at 7:50. She said she got to go over to Zach's stream so she can mod. Yeah, I hope I get a I did sign up for his channel. Yeah, and I really don't even have any testimony. I mean, we got testimony from this case, but I really don't have any testimony that I really want to look at from here personally. Yeah, all I see is verdict watch. It said the jury began deliberations at 4:04 p.m. And that's the last, that's all I got. I was trying to see if Kathy had gave any updates. I don't know. I would have to look and see what I subscribe to his channel, but I don't know what the name of it is. I haven't been over there enough. It's Zach Jackson, the tranquil psychic. Oh, okay, she got it. She got it for you. I know. I'm like, I gotta go all the way and look and see what my subscriptions say. Yeah, because today was the first day I got his information to subscribe. So what should we do, guys? Y'all tell me. I don't have much more. You say read some salacious stuff. I'm gonna do that on Sunday. Yeah, I'm gonna do that on Sunday. I got somebody gonna help me with it. We gonna do that for the Sunday, the little Sunday fun day, whatever y'all want to call it. I don't even think I could do it tonight. Like I'm like, I know if I be tired, I know y'all got to be tired. You say why you help with that? Why I'm getting help with it? No, not really to decipher it. She came on. She was on here before. Juicy from Juicy Talk. She just gonna come on and hang out with us and read over the transcript, and we just gonna have fun with it. That's all. Do you want to leave the room open until / if the word of a break-in? Um, I don't really have to leave the room open for that. I could like if we get a verdict, like it, you know how you tell me like when the verdict is coming in, I can always just go live, right? And whoever has their notification on, they'll let them know that, take it to trial is live. I mean, or I can leave the room open it, but the only problem is that I can only leave the room open for about another hour. I think it only records up to 10 hours. Yeah, so it only records up to 10 hours, so I can do it for another 6 hours. Hey, Just back home. Are you still doing Friday Night Live tonight? We're going to do it on Sunday, Just Shamrock. Only because we still kind of in verdict watch, and I knew we was going to be in court late today. And typically, y'all know when we was having those, when we were doing our after dark, we would be like in court in Florida, and we would be done like at 1 or 2. At least my time, right? And I would have a break away and be able to take care of some stuff and then come back and kind of do the after dark. But we just gonna do it on Sunday. It'll be 4:00 Mountain Standard Time. You say it's 12 hours? Oh, it don't matter to me. Do you want me? Y'all want me to put on some testimony? Because I could put on some testimony. You scared? What you scared about, Lynn? You scared the verdict gonna come in? Leah said she's scared. What is you scared? What you scared of? Oh, you say that psychic stuff. Yeah, well, everything ain't for everybody. That's what I can definitely tell you. You just go over. I'm just gonna go over there and check it out. I don't know if it's my type of thing either, but I would definitely go over there and check it out. Um, let me get us into some testimony. Yeah, I can't. They gonna want dinner. That's what I'm thinking. They're gonna want dinner. We can't do closings because closings gonna put everybody to sleep. So we can't do closings. That's out. Normally, I would like to do something like closing or something, but I don't know if y'all seen these messages. Let's do these. All right, Barb. We said we gonna come over and we crashing the party. Let's see.
No.
And just kind of along the same lines of the Xbox, do you recognize these at all?
Just from what I saw previously today.
And if I told you they were from Devyn's cell phone showing Devier playing Xbox and that he was a big game, would you have any reason to disagree with me?
No.
And there's even more messages that we got from Miss Michaels' phone from the Celebrite extraction, talking about the video game. Because obviously it seems like he was a big gamer from reviewing all these messages, correct?
Yes.
Now, in going through the text messages, were you asked to look at the conversations between Devyn and Jonathan?
Yes.
And I apologize, I'm just going through the files that are on this thumb drive that's on B4. And I'll say the name of the file on this one, I apologize. It's Devyn and Jonathan Cordial Conversations PDF. So I'm actually going to go down a little bit here. It's kind of a long file. I think there's 200 and some pages on this extraction that was created. Now, who would this, from what you're seeing, who would this be to? Can you tell which parties are which?
Just by the phone number, a lot of times the names or whatever they put in the phone. But the 9242 phone number to someone else, I'm not sure.
Okay, and if I told you that these are messages between Devyn and Jonathan, would you have any reason to disagree with me?
No.
Just on this message from 8/2/2023. I'm doing good, trying to hustle up 50 bucks someday or somehow today. I have Saturday for sure, but need gas. It's 2 trips to Las Vegas, to St. Rose. I also have turf next week. And then also too, I'm getting up early to get the girls used to getting up for school. You see that?
Yes.
And what was the date of that one?
August 2nd, 23 at 8:18 a.m.
On another one on August 2nd, I'm gonna have good things happen for me today. It's just early. And it looks like she responds great things. Correct?
Yes.
And that's around the time, yeah, you said 10:03 in the morning?
Yep, same day at 10:03, yes.
I'm going to jump around a little bit because this will go back to the jury and they'll be able to see these conversations. So on 10/2, later on that day, that evening, it looks like a list on, ribs, crab legs. It looks like maybe like a dinner list or food that they're getting.
Yes.
And then, they ask what kind of drinks, and they're talking about getting Coca-Colas, what it looks like, some kind of sodas.
Yes.
No kind of crazy fighting text from just your observation of these text messages, right?
Not in these that I've seen. No.
And this is the this is Devyn Michael or a Devyn medical activity file on the thumb drive. So if I zoom in on this, do you know which phone this came from?
I don't see it in here. It says it's an SD card backup. I believe that was from Devyn's phone.
Okay. And on this kind of, I zoomed in a little bit. I forget that those ones are a little, looks like a picture of Miss Michaels in the hospital.
Yes.
Looks like some medical records of her going to the hospital.
Yes.
Let me zoom out here a little bit. There's just a few more. And that's what that looks like. Those came from her phone, correct?
Yes.
Now I'm going between Devyn and Devier. And who does this look like? I'm sorry, yeah, Devyn and Devier. These messages were previously addressed by the state, but we put them in here for the jury to have easier access to them. But do you know what number that came from, that top one? Liar, cheater, liar, cheater?
It doesn't look like it shows here.
Let me go down a little bit and pull. So we get the extraction one. There you go. Does it say there?
Yes.
And that's Devier's
phone. Yes.
Okay.
I'm sorry, Counsel, can we just clarify who sent it?
That was Devyn to Devier. Now I'm clicking on Jonathan and Devier text. This appears to be the extraction from Devier, or the exchange between Jonathan and Devier, correct?
Yes.
And it goes on for a while because this, it starts back on, this extraction starts back on October of 2021, correct?
Yes.
And then it goes all the way down to looks like July 2nd of 2023.
Yeah.
And the last file on this is the messages between Jonathan and Yoko. Is that what those numbers look like up there in this exchange? I'm sorry, I know I'm kind of moving it fast.
Between Jonathan and who?
Yoko.
Yeah. I'm sorry, yes.
And this goes all the way up to July of 29 of 2023.
Yes.
Is that correct?
Yes.
That last message. All right. Now, I'm not going to bore the jury with all the exhibits. Like I said, they'll have an opportunity to look back at them, and we may touch on them later on. But what I'd like to do is, in your investigation, you weren't at the crime scene, were you?
I was.
Okay, and then was it you that takes inventory of what to grab, or does someone tell you?
That time someone told me.
Okay, that time meaning when you were out there, or when they came to your office and said, hey, go through all of these?
Meaning since that time, we've gone to scenes to collect devices ourselves.
Okay.
And have input on what gets collected.
So when you show up to the scene, do you have an idea of what's going on, or do they just say some devices need to be looked at or collected, and you're going to take them back and look at them?
So in this particular instance, I was called just to go and do a router interrogation. So I had no input or had no idea what other devices were there.
Were you given any details of the incident before arriving?
Yes.
On the router, that was a Cox panoramic router, correct? Sound
Yes.
about right?
Yes.
During that interrogation, you took photos of the device and you collected the router logs that were stored.
Yes.
And you took photos of that?
I don't recall if I took photos of the logs or if I just collected the logs themselves. But I took photos of the router.
You didn't, okay. And the evidence log, or the logs, were those given to Detective Ozawa, or do you make the determination on what's important and give it to Detective Ozawa?
I don't recall if they were given to Detective Ozawa. Normally I would, yes, but I don't recall in this case if they were.
And if I told you, let me see here. In your report, in the 18-page report authored by Detective Ozawa, let me see here. I'll give you a page number here in a second. Court's indulgence. It's not a number. I know you were kind of you. I think it's just this word. So it says that you collected the data logs for Detective Ozawa, and that's what you did, correct?
Yes.
And did you discuss that with him, or the findings of those?
I don't recall for sure. I probably did.
I don't want you to guess, but you don't remember having any significant conversation with him.
I don't.
Fair to say that the router didn't have much on it for you to go back and tell Detective Ozawa.
That's correct.
Now, when we get into all the devices, there's 11 devices plus the router, so there's 12.
Yes.
I want to clear up a few things. You talked about the UFDR is the complete file, or download of the phone.
Yes.
Now, the UFDR, is that something that when you extract the phone, you get that and that's the whole thing, or is that something you are focused in on?
No, the UFDR is like a full report of all the data from the phone.
Is a UFDR different from a UD or UFD?
I'm not sure.
The UFDR it's a reader, right? Like you put in it all and it spits out what you are kind of looking for, right? So if it's a certain phone, certain things, it's marked for you, correct?
What do you mean by marked?
When you put it in, when you track the phone, and then you put it into the Celebrite, and then do you click on what you want, or is it just a whole thing and then you decide what to do?
There are different settings in the Celebrite software, but where you can, after it's processed everything in Physical Analyzer, you can create a UFDR report. You can change that by time frame if you want, or include just specific things.
And then was your UFDR, was it one that you had changed the settings on, or was it a full one?
It was a full one.
Okay. Now, when you go through your findings on these phones, you give it to Detective Ozawa to review.
Yes.
Is there any other follow-up of the phone? Or let me go back. You go through the phones, you tell Detective Ozawa, and that's it, right?
Normally, yes.
If in a complete investigation, wouldn't a detective like Detective Ozawa want to go further deep into it, or does he just trust what you have to say?
No, so typically we'll create that report of the entire data from the phone.
Mm-hmm.
We'll give that to the investigator, and the investigator will go through and look for the evidence that they need.
Do you know if Detective Ozawa went through this?
I don't know.
Court's indulgence. In your report to Detective Ozawa, it states what you did, but I'm kind of hitting on this is that it's his job to follow up, and if there's anything more that he wants, he's got to, it's up to him, correct?
Yes.
Any more artifacts, meaning the things that potentially could be left out of a report, or if there's anything that he, goes through?
Yes.
And did he ever do that with any of the devices?
I don't know.
Do you remember going through the HP laptop?
Yes.
Anything of any evidentiary value on there?
No.
And so Detective Ozawa, when he went through his investigation, as far as you know, he just used your report to come to his conclusions or direct his investigation, correct?
Yes.
He never came back and asked for any kind of follow-up or anything more that he needed from you?
I don't remember. I know that we, to prepare for trial, I started assisting in going through the devices, and so, but I don't recall if back initially, if there was any, collaboration between him and I.
Court's indulgence. No further questions, Your Honor. Pass the witness.
the system collect deleted messages?
It can, yes.
Would examination of the home router show activity for the Nintendo Switch or the Xbox?
Most of the activity that on this router in specifically and on most routers is it just shows connected devices. The other logs are like system logs and that don't really give us much information.
You have another question? Yes, you have a question. All right, ladies and gentlemen, do you have any further questions for this witness? Okay, seeing no response, sir, you are excused. Thank you very much for your testimony here today.
Thank you.
Can counsel approach?
Judge, Detective, with regard to the router at home, you said it logs connected devices.
Yes.
If I have a router at my home, my line connects to it, it's going to show connected consistently, correct?
Yes.
If my device is at home.
Yes.
So there's not really much information you can glean from the router.
Correct.
Thank you.
Any follow-up, Mr. Herbert, based on the jury question?
Yes, just briefly. Do you remember where the router was that you interrogated? What address it was?
I don't remember it was on Pauladura.
Did you conduct a router search at Porcupine?
I never went to that residence.
No further questions.
Any follow-up, State?
No, thank you.
Do ladies and gentlemen, do you have any further questions for this witness? Okay, seeing no further, sir, you are excused this time. Thank you very much for your testimony here today.
Thank you.
Can I take?
Yes.
Your Honor, just real, may I admit this?
Yeah, Mr. Giordano, you can go ahead and go outside.
This is B4.
Yes, that's it. Okay, and we're just gonna take like a quick minute, but we're not gonna take another recess. I know you guys are gonna be up and down.
Your Honor, the state calls Nick Ethan.
Raise your right hand, Chris, and swear. You solemnly swear or affirm the testimony you're about to give this action shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Sir, can you please state your full name and spell it for the record?
Sure. My full name is Nicholas Anthony Eason. First name Nicholas. Anthony Anthony. Last name Eason Eason.
Who do you work for, sir?
I work for Clark County Family Services.
What is your position there?
I'm a family services supervisor.
Turning your attention to October 16th of 2022, did you come into contact with a family, that being Devyn Michaels and Jonathan Willette's family?
Yes.
And you became the primary on that case, correct?
Yes.
You made contact with Devyn Michaels during that case, correct?
Yes.
You met with the two daughters of those two individuals, correct?
Yes.
You met with Jonathan Willette multiple times, correct?
Yes.
And he was a pleasant person, correct?
Yes.
He was very polite.
Yes.
He seemed very appreciative of your work.
Yes.
Seemed very organic, your conversations with him.
Yes.
Not hateful toward Devyn in any way.
No.
And there were just relationship things between them that just didn't work, correct?
To my understanding, yes.
Now, as far as meeting with Devyn Michaels, what were briefly your observations of her when you met with her?
So when I met with Devyn, she presented as what I would describe as bizarre. Her affect and presentation to questions were inappropriate given the nature of the questions.
She shared with you that she had been married to Jonathan in 2012, correct?
Yes.
That they were married for 6 years,
Yes.
and that they had broken up 4 days after having Tamaya, one of their daughters.
Yes.
And that the two of them had an agreement to have another child, even though they weren't together, correct?
Yes.
And her and Jonathan, she explained they were not a real married couple, correct?
Yes.
For the record, you are using air quotes.
That is correct, Your Honor. Lived in different rooms,
Yes.
and they were ultimately separated in 2018, that being Jonathan and Devyn, correct?
Yes.
And this is everything she told you.
Yes.
And I think you briefly mentioned this, but she presented with an affect that was not consistent with the situation, correct?
Yes.
And there was a contentious custody agreement between Devyn Michaels and Jonathan Willette, correct?
Yes.
On October 25th of 2022, Devyn expressed that she was at the office to quote, and this is her own words, do whatever she needed to get her girls back home, end quote.
Yes.
Correct?
Yes.
And at that point, she showed desperation. Is that right?
Yes, I would agree.
The girls were then in Dad's physical custody, and the girls were released to him specifically on October 27th of 2022, correct?
Yes.
And you work with an individual, or at that time, an individual by the name of Yolanda Lizardo,
Yes.
and you are aware that she met, Ms. Lizardo met with the family on October 27th as well as October 28th of 2022.
Yes.
And your involvement with the case concluded on December 18th of 2022, correct?
Yes.
Pass the witness, Your Honor.
Yes, just, I have a couple of very narrow questions for you.
Yes.
There had been a question concerning a contentious custody issue, correct?
Yes, sir.
That was specifically in October of 2022, correct?
I believe so, yes.
So you were not involved following that concerning a reunification of the parties, were you?
I was not.
Thank you. No further questions.
Any follow-up statement?
No, Your Honor.
Do the ladies of the jury have any questions for this witness? Okay, seeing no response, sir, you are excused. Thank you very much for your testimony.
Thank you, Your Honor.
State, you may call your next witness.
State's next witness is Yolanda Lizardo.
Yolanda?
You can step up and stand in the person of swearing.
Hi.
You solemnly swear or affirm the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
May I speak? And if you please state your full name and spell it for the record.
Yolanda Lizardo, Yolanda, last name Lizardo.
Ma'am, were you employed with the Department of Family Services back in 2022?
Yes.
At some point, did you become involved in a custody matter involving Tamaya and Janaea?
Yes.
And those were two minor girls.
Yes.
And the natural mother was Devyn Michaels.
Yes.
The natural father was Jonathan Willett, correct?
Yes.
On October 27th of 2022, physical custody of the girls was given to the natural father, Jonathan Willett, correct?
Yes.
And there is something called a parent placement verification letter that was given out. Is that right?
Yes.
At this time, I believe between stipulation of the parties, the state is now moving to admit states 14.
States 14 will be admitted.
Permission to publish.
Yes.
Showing you, once I zoom out. States 14 there, is that parent placement verification letter we just spoke about?
Yes.
And the two minor children's names are there, Tamaya Baker and Janaea Willett, correct?
Yes.
With, I assume, their birthdays, correct?
Yes.
And then down below is your signature there.
Yes.
And it states that they have been reunified with their natural father, Jonathan Willett, on October 27th, 2022.
Yes.
Correct?
Yes.
And that he resided at 2698 Paladura Drive in Henderson, Nevada, 89074.
Correct.
And that's your signature at the bottom.
Yes, it is.
And you dated this October 27th of 2022, correct?
Yes.
Now, this was a contentious agreement between the mother and the father, correct?
Yes.
The mother, Devyn, was not happy about it. Is that correct?
Yes.
The father, Jonathan, was happy about getting the girls, correct?
Yes.
Devier was not involved in the custody agreement, correct?
Yes.
And you yourself met with Dad, Jonathan Willett, multiple times.
Yes.
You were actually the individual that gave the two minor girls to the father, Jonathan, correct?
Yes.
And you conducted follow-up at the father's home with the girls.
Yes.
The girls appeared happy with Dad during those follow-ups.
Yes.
They were well taken care of.
Yes.
All their needs were met.
Yes.
Once they were placed with their father, Jonathan, you had no further involvement. Is that correct?
Yes.
Pass the witness.
Cross.
Your involvement was just primarily limited to October of 2022, correct?
Yes.
Nothing following that?
No.
No further questions?
Can you follow up, Sam? No, Your Honor. Do you ladies and gentlemen of the jury have any questions for this witness? Okay, seeing no response,
Hi.
maybe you are excused. Thank you very
Thank
much for
you.
your testimony here today. State, you may call your next witness.
State's next witness is Elizabeth Lemons Woods.
You can step on up and remain standing. The person is right there. You solemnly solemnly swear or affirm the testimony about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Yes. Again, please state your full name and spell it for the record.
Elizabeth Lemons Woods. Elizabeth is ELIZABETH. Lemons LEMONS and Woods WOODS.
Good afternoon, ma'am.
Good afternoon.
How are you employed?
With the Department of Family Services.
And you were employed in that capacity in 2023 as well, correct?
Yes.
Turning your attention then to August of 2023, did you become involved in a custody matter involving the two minor girls, Tamaya and Janaea, correct?
Yes.
And the natural mother was Devyn Michaels, correct?
We got a verdict, y'all. Okay. Here we go. Let me take us in there. Jeepers, creepers. Where'd you get those eyes? Okay. To our newbie that's here, we have a verdict in this one, so you may not want to watch this. I don't want to be the spoiler of spoils. Okay, so we still looking at the seal. Let's see. Oh, okay. I just don't be wanting to spoil it for nobody. And I know you just got over here. You was like, yeah, I don't want to spoil it. Okay, so you kind of like me. I'm like that too, Deanna. I will. I don't care if I hear the verdict. I'll watch it again. I'll watch the trial again. I like to rewatch trials and all types of stuff. So that is good with me. We're on my SD that went to bed. She said she started drooling and she had to go to bed. How do we alert people? The community board. Well, in Vegas it's only 6 o'clock. So it's not really a bad time in Vegas. You know, they can work 9 to 6. Right? If the jury come in at 9, they get an hour lunch, a work day at 6. You can post on the community board or here, I can do something else too. Wait a minute. Let me see. I post on the community board and let me see. What is a good way for me to do this? Okay, I can probably let me see. I can probably make a little clip and say verdict in. Wait a minute. Hold on, let me do something real quick, and that way I can alert everybody, y'all. I'm kind of talking to you guys, but not kind of talking to you guys. So don't pay me no attention. I'm really talking to the guys that are not here. Hi, guys. We have a verdict. Come tune in. Verdict time. Devyn Michaels, a.k.a. Nikki, a.k.a. Tracy, whoever you want to call her. We now have a verdict. See you at Take It to Trial. You see, I just made that commercial. I made a commercial within the stream so I can clip it and send it out. I'll send it out right now, guys. You got to do what you got to do. Okay, let me put this on here. I see the judge. Or no, maybe I don't see the judge. Do I see the judge? Oh no, that wasn't in. Oh, that was earlier. Okay. I'm like, oh, do I see the judge? Wait a minute. attention. I'm really talking to the guys that are not here. Hi, guys. I'm kind of talking to you guys and not kind of talking to you guys, so don't pay me no attention. I'm really talking to the guys that are not here. Alert every. Hold on, let me do something real quick, and that way hold on, let me do something real quick, and that way how do we alert people? The community board. Well, Vegas is only 6 o'clock, so it's not really a bad time in Vegas. You know, they can work 9 to 6, right? If the jury come in at 9, they get an hour lunch, or work at 6. You can post on the community board, or what the? Here, I can do something else too. Wait a minute. Let me see. I post on the community board and what? Let me see. What is a good way for me to do this? Okay, I can probably put. Okay, let me see. I can probably make a little clip and say bird eat.
It's a good question, actually.
The Devyn Michaels trial couldn't get any worse. And you're not muted. We can hear you and your baby daddy. he laughing that loud. I'm trying to figure out how to wake SD up. Oh yeah, Barb got to go over there and mod. Hopefully they'll come up here and do this verdict. I don't know. Maybe I don't know who they waiting on. I'm here. The most important people is here. I don't have her phone number either. But I know she be out here. I'm trying to figure out how to Jason just responded on one of my little things, so hopefully he'll come in here. Okay, so wait a minute. This is definitely a guilty, right? If they came back this fast, this is guilty, right? I'm so glad you seen the alert, SD. We was trying to get you. I was like, oh my gosh, SD just got off and said she was going to bed. Oh, I'm so glad you got it. Oh goodness, yeah. You have to give your phone number out to someone. No, we don't have no spoilers yet because we not in there. That's what I could tell you, just Sharon Rock. They ain't did nothing. They ain't even asked no question, did they? Yeah, we still waiting. They ain't even asked no question. Okay. I got it on there. Devyn about to come in with her hair done. She about to come in with her hair done. Like, yeah, I'm about to go home. Deuces. Going back to be Nikki Fairchild is what they call me. Nasty. Nasty girl. Mickey Mouse. Mickey Mouse, she gonna come in with her hair done. Like, what y'all talking about? Talk about my hair. I'm about to go home. The fuck? You know I can be real. The fuck? Oh, it's not after dark. Oh, yes, it is after dark. Ooh. Yes, it is. Yes, it is. This is our poll. 31 people. Let's see. That's what she gonna say. Deanna, the fuck? Ooh. Like, I'm going, I don't know what y'all thought. Boom. Oh, gosh. I don't know why we had to know about your TMI OnlyFans. Like, you could have kept that to yourself. So just to be clear, there is a guilty verdict. SD. We don't know. We just waiting. We waiting. They say a verdict is in. We wait for them to announce the verdict. We be doing all of this, y'all, and waiting for these verdicts, and it be 2 damn long minutes. Like 2 minutes. Like they gonna tell us in 2 minutes. It did tell us all to go home. Yeah, there is a verdict. We just waiting on them to announce the verdict. Right? Is that my understanding? Sure. I don't know. That's what somebody said. Somebody has said that. Let me see. Yeah, I think I looked on the Twitter thing and I did see it. There is a verdict. Let me make sure, because you know sometimes they be behind on certain stuff. Like I be noticing, like when I go to Court TV, they'll be a little bit ahead. Okay, well I see a head movement. Y'all see a head moving? Y'all see a head moving? I keep seeing the judge head move every now and again. Did y'all see the judge head move? Don't worry, Barbara. If you miss it, boo, I'm going to have it up there for you. I mean, we've been in this trial for 7 days. 7 whole days. And not a word from you. 7 whole nights. Ow! And I'm just about through. I don't know the rest of the words, but y'all know what I'm talking about. I had about enough of you. And this is for real. I'm going to be on my own. What? 7 whole days. I'm so through with this case. I was over this case, y'all. I'm telling y'all, like, if it wasn't for you guys, I probably would not have continued to watch this case. Like, I would have probably, after we heard from the son, the brother, son, husband, whoever he is, I would have been done with this. Done. Like, everything gonna be on fast forward. because all that digital and maybe some of the photos, some of the photos. I see head. We got head action. Y'all see that head action?
All rise for the jury. Wait, bring a seat. Please be seated, Your Honor. The jury's all present and accounted for.
Back on the record, C 377239, State of Nevada versus Devyn Michaels. The record reflects that Ms. Michaels is present with her attorneys. Deputy District Attorneys on behalf of the state, we both parties stipulate to the presence of our jury.
Yes, Your Honor.
All right, ladies and gentlemen of the jury, has the jury selected a fourth person? All right. And Mr. Gilpin, Mr. Foreperson, has the jury reached a verdict?
Yes.
If you could pass the verdict form to the marshal. All right, the clerk will now read the verdict into the record.
District Court, Clark County, Nevada. State of Nevada plaintiff versus Devyn Jade Michaels, a.k.a. Devyn Willett, a.k.a. Nikki Fairchild, a.k.a. Tracy Baker, a.k.a. Tracy Nicole Tavares, defendant. Case number C-23-377-239-1, Department 10. Verdict. We, the jury, in the above entitled case, find the defendant, Devyn Jade Michaels, as follows. Count 1, murder with use of a deadly weapon. Guilty of first-degree murder with use of a deadly weapon. Dated this 14th day of November, 2025, signed Aaron Gilded. Ladies and gentlemen of the jury, is this your verdict as read? So say you one, so say you all?
Yes.
Does either side desire to have the jury polled?
No, Your Honor.
All right. Ladies and gentlemen of the jury, I want to thank you very much for the time and attention that you paid to this matter. The right to a trial by jury is a right that's guaranteed in the Constitution, but it's a right that we cannot provide without our citizens like you being willing to sit and serve your civic duty as jurors. I do appreciate the time that you gave us tonight, so on behalf of the court and the parties, I want to thank you for the time and attention. I know that this was a lot that we asked you to do, so if you guys could follow the marshal to the back, and I will come back and formally excuse you from jury duty.
All rise for the jury.
Okay, this matter is going to be referred to the Division of Probation, set down for sentencing on
January 8th at 9 a.m.
All right?
Thank you.
Thank you. And I'm going to go back and talk to the jury in the least that they desire to speak to you guys. I'll come back and let you know. It's late. I'm going to write them down. Thank you.
Yeah, because I'm working, it was like,
Yeah.
Dang, her lawyers didn't even talk to her. Her lawyers didn't even go pat her on the back, say, homie, we gonna follow appeal. They didn't whisper in her ear. They ain't said nothing. It's like they knew this guilty verdict was coming. Oh my goodness. Y'all know usually they'll say something like, pat her on the back saying, I'm so sorry. We tried to do everything that we could do. It just didn't work out. They basically walked away from her. They walked in one direction, was like, go ahead and take her. Look, he back. He calling his wife like, baby, I'm about to be on my way home for dinner. Like, this is over. The jury didn't buy it. They both call. Everybody calling their significant other like, yeah, we got her. Got him. Definitely, she should have took her plea deal. Goofy. She a goofy. Oh, well. I don't know if they do anything else after this. I don't know. Because you know the judge, she was like, y'all can't be in the courtroom unless the jury in the courtroom. And we don't want y'all looking at, oh, nope. I guess that's...
You probably worn out that carpet by now, going back and forth. But
I mean, really, another one really bit the dust. Oh, boy. God, her attorneys, like, they ain't even care. That's messed up. I wasn't expecting for the attorneys to just kind of like, they walked away from her like they wasn't even representing her. Or am I reading too much into this? You know, because sometimes I can read too much into stuff, but you're talking about another one bites the dust. Talking about guilty to the mud. Guilty to the mofo. I guess. Whoa. Well, she did twist her hair into a little, that was the best her hair done looked the whole dang on time. She twisted it into like a little, you know, whatever it is. You say, you so glad that it's over? I know, this trial was long. It was too long for me. I don't know how y'all feel about it, but it was too long for me. Way too long. Way too much long. Y'all know tomorrow we'll do our little McDonald's lady tomorrow. We'll do her in the morning. Yeah, and if for anybody, if y'all want to go hang out and with Zach and I think the psychic, right? I'm gonna say it wrong. Oh gosh. Don't pay me no attention. I need cue cards. Can y'all give me some cue cards? I need cue cards for certain stuff so I can remember. Yeah, we're going to go over there. We're going to support Barb tonight over there. Who's the McDonald's lady? Ronald McDonald had a Big Mac. Yeah, I'm getting sleepy. I'm just saying, oh, anything. The McDonald's lady, we're gonna be looking at her preliminary hearing. She unalived her manager at McDonald's because her manager sent her home. So it's one of those shocker. I don't know what you want to call it. We're gonna watch the preliminary hearing tomorrow to see what evidence they have against her to see if it's gonna be bound over. But everything was kind of caught on camera, and she did some Facebook posts and different stuff. So we will do it tomorrow morning. It's about an hour and 45-minute hearing. I'm thinking since it's a Saturday, we should probably start at about 9 or 10, guys, or kind of early, get it out the way. What y'all think? I'm good for any time. 9 or 10. I mean, you in Cali? We're going back to Cali. Ooh, look at all these California people. California knows how to party. California knows how to party. Yeah, well, I'm in Arizona. They know how to party, right? Like California, boy. We will, I'm thinking, we will do, because it's Saturday. So we'll do it like maybe 10, 9, 10. We don't have to get up at the crack of dawn. We done had a hard week this week, baby. We done been in Florida. We done been in Arizona. We done been in Vegas. Like, we done been somewhere everywhere. We got 2 verdicts. I don't know what the hell we gonna do next week. The fuck? I better stop saying that. Oh gosh, I better stop saying that. Me tired. You tired, Northwest? Did you see that verdict, Northwest? They wasn't playing no games with her. The fuck? What the fuck you thought it was? Shoot. Oh man. New trial in Georgia, Cobb County. I will look at it, Northwest. Thank you. Don't forget tomorrow, guys, in the morning, I will get the alert and send it out tonight. Yeah, I'll send it out tonight. Then that way we can make sure we watch it. I'm gonna kind of record it so we don't have no commercials or nothing like that. So we'll be good. So we will be good, and we can chat and watch this hearing and talk about this hearing. About 2 hours. What time, Cali time? It's gonna be like 9 your time, because you're about an hour ahead of me. Monday is neighbor shooting 2 neighbors, leaving baby alone. Okay. I'll look at it, Northwest. Because I think the only other trial that we got is the one in Arizona. Okay. I'm going to look so we can be ready. Okay, the baby is okay. Okay, yeah, I'll look at it. Okay, cool. We good. All right, crew. Thanks for hanging in here. Thanks for chilling. I'm glad that everybody was able to make it back. They needed to make it back. I will go ahead and load it up. Don't forget to go over there if you can for a little bit of time and go support Barb. I'm going to go over there for a little bit. I'll be over there lurking. I guess I'm going to be lurking because I got to cook some dinner for some kiddos. I got to cook some dinner. I got to do some mommy duties. I think. Or maybe not. Maybe I should throw the box. We got some Cheerios. Maybe I'll just feed them Cheerios tonight. Which I think. Who knows? All right, guys. You know you were in the right place today where there's no filters, no fluff, just facts. So you can be the judge. All right, guys. Have a great evening, and I will see y'all in the AM. We going to Dirty D. We gonna be in that Detroit and Mickey D's. Peace.